and Mr. Sean Tate. And then we will also expect Institute for Security Studies to arrive at around 14 hours, represented by Mr. David Bruce, and possibly Gun Free South Africa by Dr. Stanley Maphosa. So in the event one of the latter two arrives in the afternoon, we will have 3 or 4 of them appearing. And I must also indicate to you and the members of the public that these organizations are not appearing here as witnesses. They are appearing here to make their presentations, to give the committee more insight into the criminal justice system. They will share with us their observations, which will be very enriching to members of the committee. And my expectation is that they will also make recommendations on how they think the South African criminal justice system can be improved. What are the legislative and policy interventions that may be necessary for us to have a resilient and effective, efficient and responsive, and even accountable and ethical criminal justice system in the country. So they will not be required to go through the oath administration process. But before I hand over to the advocate to formally introduce them and make remarks, I see the hand of Honorable Nomvalo is up.
Yeah, no, thanks, Chair. It's up for 2 things, Chair. The first one is that we want to register our great feeling of unease by this amount of apologies. We can't weaken the work of this committee towards the end. So it must be reprimanded, Chair. And I think in future, apologies from each organization should not be more than 2. At least if there's 1 person, because we also have organizational commitments. At least if there's 1 person, that is why we're saying organizations which have more than 1 member are more privileged, because when 1 is absent, 1 should be available as a basic principle. That is the first one. Then the second one, Chair, is that we're hoping to have a meeting to deal with housekeeping issues yesterday, because we don't want to be ambushed on the position of this committee about the approach on the Paul O'Sullivan issue. We're hoping that we will be given an update yesterday by the legal team on how far they've gone in pursuit of our previous position on the matter. Because the last position we took is that Paul O'Sullivan must be subpoenaed. So I don't know if that is happening or it's not happening. The reason why we're raising this here and now is because in terms of the time that we have, we're only left with 2 weeks. So we don't want to be told on the 11th hour that we have not done the work of this committee, when by that time we would not be left with any option. So we want to be given an update, Chair, on what is transpiring on the matter, so that if needs be, we can also advise on the way forward. Thank you.
Okay. Honorable Breitenbach.
Thank you, Chair. Mine are housekeeping issues as well, so I'll save it for the housekeeping meeting. Thank you.
Okay. Honorable Sangwen.
Thank you very much, Chair. Chairperson, I want to agree with the notion that you would not want to weaken the work of the committee as we are on the last mile. But I think that we must not agree to things that are not provided for in the rules of parliament. There is nothing in the rules that says a party can only have so many apologies, it can't have apologies. And I don't think that anybody exercising their right to submit an apology when they're not able to attend a meeting should be reprimanded. So we haven't had a tradition of coming to this meeting, accepting apologies, not accepting apologies, reprimanding others, not reprimanding others. I think parties must be allowed to make their own internal arrangements and ensure that members, as they fit, are able to submit apologies when they need to, Chair. And on the issue of, I know it's not my place to answer, Chair, but on the issue of Paul O'Sullivan, I thought the committee had taken a very clear decision that says that in the event that we get to the day where we need to finalize, and Mr. O'Sullivan, having been subpoenaed, has not yet appeared before the committee, then the committee would then still be able to supplement their report when he eventually comes before the committee. I just don't want us to create impressions that there are people who are more vested in having Paulo O'Sullivan than others. I think it's a resolution of the committee, and I trust that when we have a housekeeping meeting, we'll be updated. Thank you, Chair.
Yeah. Honorable Kolabanato.
Thank you, Chair. Could you just clarify the witness for Thursday and Friday, Brown Mkhwanazi? Is he not coming at all? Is he coming? Has he been rescheduled? What is the situation there with him? Thank you.
Okay. Honorable Nombalo.
No, Chair, we can't roll a red carpet for unjustifiable excuses. We maintain the position. It's wrong, especially towards the end of the work of this committee, to have apologies from all members of the party. We don't want to be part of that kind of tradition. Even if you continue with it, you must continue knowing it, that as the MK party, we don't endorse that kind of practice. At least if there's one member that is not present, then other members must be present. Whether that's a political right, people were making all sorts of commitments here when we were beginning our work. Others were even saying they are prepared to work on weekends. Now the work is here. People are giving excuses. What is happening here today, Chair, is undesirable. And we're condemning it as the MK party to say you can't have a committee with many members who are not present in the committee. So if you endorse it on your own. We're not part of it. That is why we're always here as members of the MK party. As on the issue of Paul O'Sullivan, yes, we are more vested on it. One Paul O'Sullivan to come and present himself here in the committee. And if it doesn't come, he must be subpoenaed. He must be subpoenaed. That is our position as the MK party. Thank you.
Honorable Skosana.
Thank you, Chair. I just wanted to add, that the issue of Paul O'Sullivan, this white supremacy, this attitude of undermining this core committee, and for us not even to be like kind of a kid gloves, should not be allowed here. If he has to be summoned before we finish this Ad Hoc Committee, as we don't have any more days, we must be, I wanted to use another word, Chair, but let me reprimand myself. But indeed, this white supremacy should not be tolerated here. All the witnesses were here. He must appear here. If he doesn't want to, let's do everything in the book to have him here. Thank you, Chair.
Okay. No, it's fine, honorable members. I saw your hands were up and I decided to give you a chance to speak. All the things that you have said here are our decisions. And those decisions have not been changed anywhere. I think the legal team is working on those matters and will accordingly give a report to the committee. With regard to attendance of meetings, it is not for me as a the chairperson of this ad hoc committee to respond to your absence in this meeting. It's not my responsibility. Nobody must ask me a question why members are not here. I have not elected you to be here. And I have not sent any one of you to be a member of this committee. You have been elected as public representatives by South African voters and sent here by your parties. It's not me. I don't have a member in this parliament. I don't have a fiefdom here. So as to how you conduct yourself, how you attend meetings, and how you are answerable to South Africans who voted for you, it's your choice. And I would agree with members who say that we started very well and we must have the same endurance towards the finishing line. I'm just saying that from today onwards, I can't be answerable to apologies and absenteeism in the committee. And Honorable Nomvalo, in as much as I hear your sentiments, I'm not going to reprimand anybody why they are here or they are not here. I can't do that. I have not sent anybody to Parliament. So when we came here, sworn in as members of Parliament, my belief is that we made a choice. And the choice that we made is to serve. And there is nobody who is going to be reminded about the choice that they have made. Honorable Barnard, I think the legal team, together with the relevant section in Parliament, were still working on the matters of Mr. Brown Mkhwanazi. The report that I got this morning is that the statement is about ready, but there are security issues that he is raising, which the security section of Parliament must attend to. And once those matters are sorted, they will give us a report as to whether they are able to reach an agreement or not. Yes, but what Honorable Nomvalo and Honorable Breitenbach are saying, they are right that this matters belong to a committee housekeeping meeting where we should be able to deal with all of them exhaustively. Thank you so much, honorable members. Can I hand over to Advocate Arendse to formally introduce our guests and make any remarks that he thinks are necessary for the proceedings. Thank you so much.
Thank you, Honorable Chair, honorable members, and a formal welcome to our guests, Advocate Paul Hoffman, Senior Counsel, Director of Accountability Now, and also lead counsel in this seminal cases of Glenister 1 and 2. Is there 3? Okay, 3. And Sean Tate, Director of the African Policing Civilian Oversight Forum. Both made very helpful submissions to the committee for its consideration, especially on policy matters and proposed amendments to the legislation that speaks to the terms of reference of this committee. As you pointed out, Honorable Chair, they are not witnesses before you. I know Advocate Hoffman has sent us an unsigned affidavit. I'm not sure whether you want to swear them in, nevertheless. But I present to you both Advocate Hoffman and Sean Tate. I think, Paul, you are first. Thank you. Yeah, I otherwise have no other comments to make. Perhaps at the end, maybe pose or ask a few questions with your leave. Thank you, Chair.
Okay, what is your advice? Because where I'm standing, the impression I have is that they are not witnesses. Can we proceed without administering oath?
I think if they don't have any objections, then perhaps we should swear them in. There may be factual questions or issues that either they raise or one of the honorable committee members raise, in which case we want to confirm it for the record. And perhaps if they don't mind or have any objection, I would propose that they get sworn in formally, Chair.
Advocate, let's proceed because they are representing organizations. They are not coming as individuals who would have made submissions to request appearance before the committee. Is that fine with yourselves to proceed without? Advocate Hoffman and Mr. Sontate, are you fine?
Yes, that's perfectly in order. Thank you, Chair. I can help. The affidavit that Accountability Now submitted to this committee in September last year has actually been properly attested, and in its original form, it is with the Secretariat of the committee. The version that has been made available is simply a copy of the electronic version that was made available at the same time in order to enable the Secretariat to circulate the affidavit among the members of this committee. And that document, which is the basis of our submission, has been summarized, supplemented by a note which I prepared yesterday, thinking that I would be limited to an hour, which is very difficult for any lawyer to stop after just an hour. But as I understand it, the Secretary has an electronic copy of the note which compresses the 36 paragraph, 8-page affidavit into a 3-page document. So, and I'll speak to the latter document if that suits the committee.
No, we can proceed. How much time do you need to make a presentation?
Well, when I came here, I thought that I would have an hour. 35 minutes of that hour have gone already. But what I propose to do is speak to the notes for about half an hour and then take any questions which the members of the committee may wish to direct.
I think the best will be to allow both of you to present, and then we can interact. Is it fine?
Thank you, Chair. That I think is probably the most sensible way to go forward.
Okay.
So members of the committee should have the submission, which is an 8-page document, and then notes on the submission, which is a 3-page document. And if they haven't got it yet, they will be able to get it from the Secretariat. Suppose the main question that we have to ask ourselves at this stage in the proceedings is, what is the mischief that this committee is addressing through its deliberations, through the evidence that it's receiving, and now through the submissions being made by civil society organizations and others? And our submission in this regard is that the nub of the problem is that the criminal justice administration in South Africa is dysfunctional because corruption with impunity is rampant in the land. And that is what this committee is going to have to address from the point of view of Parliament, which in our submission will involve the revision of the criminal justice administration's capacity to deal with corruption effectively. And we rely in making this submission on the decision made by the majority judgment in Glenister 2 in 2011, in which the joint majority judgment of the Deputy Chief Justice Moseneke and Justice Cameron was to the effect that our law requires, our law demands is the word that they used. Our law demands a body, not several bodies, but a body outside executive control to deal effectively with corruption. Now that decision ought to have been translated into law, into legislation that this parliament was, well, not this parliament, but the previous parliament was ordered to consider and to put on the statute book within 18 months of the judgment being handed down in March 2011. The matter was indeed debated in that parliament then, and amendments were effected to the legislation that gave rise to the Hawks. The Hawks are currently on their third incarnation from a legislative point of view, but they continue to struggle when it comes to dealing with corruption effectively. And the reason for that is not hard to find. The Hawks are not a body outside executive control. The reason why we are here is because a member of the executive, the Minister of Police, saw fit to issue a directive purporting to close down the political killings task team, which by its very nature is a body that deals with corruption. Political killings happen because hitmen are greedy and because those who engage the hitmen are hungry, or should I say, crazy for power. And that toxic combination is a form of corruption which has not been addressed at any time since the law requires a single body outside executive control to deal with corruption. I think I must pause here with the first part of that statement by the court, when they say a body outside executive control. They are not referring to a collection of bodies, but to a single body. Now, this is not what has been the case in the past, nor is it the case today. The multi-agency approach to corruption in South Africa has been the approach since the new South Africa dawned. And so we have hubs, and we have task teams, and we have cooperation between various entities, but we don't have a single body outside executive control that is tasked with the business of effectively seeing off the corrupt in our midst. And this has very deleterious effects in relation to the trajectory of South Africa. The economy suffers because of it. South Africa ranks number 80 in Transparency International's Corruption Perception Index of 180 countries with a score of 41 This is below the average, as well as well below the ratings of the faster growing economies of Rwanda and Botswana, who rank at 57. Corruption is undoubtedly preventing the rapid economic growth of which South Africa is clearly capable and which is desperately needed to lift half of the population out of poverty. So if we approach the work of this commission, this committee, on the basis that it is necessary to adjust the system that is in place, then we have the guidance of the Constitutional Court, guidance which has not found its way onto the statute book yet, and guidance which needs to be on the statute book sooner rather than later. You will recall that the reason for the Glenister litigation was that the Scorpions, or Directorate of Special Operations, as it was officially called, were disbanded in 2009 following a resolution of the ANC that was taken at its Polokwane conference in December of 2007. You've heard evidence from the acting Minister of Police before this committee, and he has conceded that it was a mistake to close down the Scorpions. And the reason why it was a mistake is because the Scorpions were a prosecution-led body which sought to counter corruption on a single agency basis, and which was far too successful for its own good in dealing with corruption in high places among the politically connected and among the politicians of the day back then. So the Scorpions were closed down, and they were substituted from an investigative point of view by the Hawks, or Directorate of Priority Crime Investigation, and they were also left in the situation where their prosecutors remained, if they were prepared to remain, in the National Prosecuting Authority. And a lot of people, even to this day, even in high places, believe that the National Prosecuting Authority is an independent body. Now, that is not the case. If one looks carefully at section 174 of the Constitution, sorry, 179(4) of the Constitution, you will see there that there is a reference to the National Prosecuting Authority operating without fear, favor, or prejudice. But if you read the rest of the section, it's very clear that the Minister of Justice has final responsibility over the National Prosecuting Authority, and that the minister must concur in any policy decisions that are taken by the National Prosecuting Authority, which in effect means that the Minister of Justice has veto rights over whatever the prosecution service may want to do at any time, and can steer the prosecuting authority in the direction that the minister wants the prosecuting authority to go. It gets worse than that. The National Prosecuting Authority has no control over its budget. Its accounting officer is the Director General in the Department of Justice, an employee of the minister. And the effect of not having control of the purse strings within the NPA is to hobble it from the point of view of trying to effect changes that may improve its efficacy and effectiveness in the fight against crime in general, and in particular in the fight against the rampant corruption with impunity, which we suggest at Accountability Now is the reason for South Africa's backward trajectory in relation to getting on top of the criminality that is unpunished, well rewarded in South Africa since the closure, the mistake of closing the Scorpions down back in 2009. If we go further into the innards of the legislation that pertains to the National Prosecuting Authority, it becomes plain that the phrase "without fear, favor, or prejudice," which many of us for a long time thought meant independent, is actually a reference to impartiality. You can see this if you compare the phraseology that is used in relation to the judiciary in section 165 of the Constitution and in relation to the Chapter 9 institutions in section 181 of the, or sorry, 180 of the Constitution, which make it clear that impartiality and independence are different things, and that to assume that the ability to act without fear, favor, or prejudice implies independence is a mistake. So having regard to the finding of the court that a body, a single body outside executive control is required in order to deal with the issues around countering corruption effectively, we have a structural problem in South Africa which relates to separating the investigative work, which is the work of the police, from the prosecutorial work, which is the constitutional function of the National Prosecuting Authority. What the court has said, and it has looked deep into the meaning of the Constitution in order to get to the conclusion it reached. It relies on section 7.2 of the Constitution, which is the famous section which says the state must respect, protect, promote, and fulfill the human rights guaranteed to all in the Bill of Rights. Now, you cannot do that if your system is leaking vast amounts of resources and cash and assets in the direction of those involved in tenderpreneurism or state capture or any of the features of corruption which we have experienced in South Africa since the demise of the Scorpions. The government has actually recognized that this problem needs to be addressed, and it has sought to do so by introducing what Deputy Minister John Jeffrey referred to as a stopgap measure, by introducing IDAC, the Investigative Directorate Against Corruption. And guess what? IDAC is situated within the National Prosecuting Authority. It's an investigative directorate, which means that the investigation powers that were taken away from the NPA have now been given back to the NPA in May 2024. And as a matter of law, IDAC is indistinguishable from the Scorpions of old. It's structured in exactly the same way, brought about by ordinary legislation, which was passed by a simple majority in Parliament, in the previous Parliament, not this Parliament, and signed into law just before the May 2024 election. And if you have regard to the size and the shape of IDAC, I believe it has 158 personnel. It's led by Andrea Johnson, who is the subject of a complaint to the public protector because she encourages her staff to fake it till you make it. And I think that has been dealt with in various fora, including her interview as a prospective but failed wannabe National Director of Public Prosecutions. That little body is expected to do what the Hawks have been unable to do. We know that the Hawks are not up to dealing with corruption in high places. They are part of the police, and the police must, as things are structured now, must answer to the Ministry of Police in the final analysis of the work that is done there. So what is required in our submission is what has been proposed by the Honourable Breitenbach, who is a member of this committee and will explain her thinking better than I can, that what is required to address this mess that is not giving us the sort of return on our investment in the criminal justice administration that we deserve. Her proposal is to establish and to enable a new Chapter 9 institution, which she calls the Anti-Corruption Commission. It's based upon the drafts that Accountability Now prepared in 2021 for the introduction of what we called an Integrity Commission. I suppose an Integrity Commission has been given a bad name because the one that we know, a part of the ANC, has not been as effective as the body envisaged by Honourable Breitenbach is intended to be. So the idea of a Chapter 9 institution is not written in stone. The court, when it said a body outside executive control, implored Parliament to make the reasonable decision of a reasonable decision maker in the circumstances. What we got out of that was the revised Hawks. Everybody agrees, including the President, that the Hawks are not up to the task of dealing with corruption in South Africa as it manifests in state capture, tenderpreneurism, and the like. So the idea of a Chapter 9 institution seems to be the most obvious. None of the Chapter 9 institutions answer to the executive branch of government. Their reporting line would be to the relevant ministry, the relevant the relevant parliamentary portfolio committee, oversight body, and that will depend on which part of the activities of South Africa are covered by any particular Chapter 9 institution. And the idea of a Chapter 9 institution with a reporting line to the Justice Committee seems to be a familiar way of dealing with the requirement of a single body outside executive control, but I imagine it can be done in other ways. The other big advantage of making this body, this Anti-Corruption Commission, a Chapter 9 institution, is that to close it down, you would have to persuade 2/3 of Parliament, and we know today that the biggest party in Parliament has 35% of the seats in Parliament. So it would be very difficult to get to a point where 2/3 of Parliament would support the closure of any Chapter 9 institution, including that institution envisaged in the Brighton. In Parliament, it would mean that 2/3 of the parties currently represented in Parliament would have to vote in favour, because in order order to create a new Chapter 9 institution, in the same way as if you are closing down a Chapter 9 institution, a 2/3 majority is required. That is a difficulty, but it ought not to be a difficulty in relation to the Breitenbach bills, because the Breitenbach bills are a constitutionally pure way of addressing the dysfunction in the criminal justice administration, insofar as it is a problem in South Africa today. I see that I've got to noon, or just about noon, and I know that the diligent members of Parliament will read the affidavit that was presented in September and the references in it. And I imagine that the overworked members of Parliament will make do with the 3-page memo which summarizes it, which has been provided yesterday. So I'm going to invite honorable members to ask any questions that they may have in relation to the submission that we make, that the mischief that this committee is addressing is best dealt with by revising the system of criminal justice administration in a way that renders it effective in the fight against corruption.
Are you done, Advocate Hoffman?
I'm done if none of the members of the committee have any questions. If they do have any questions, I'm very happy to do my best to answer them.
No, we will come back to you. Is it my impression that your presentation is largely on legislative reform? Okay. Mr. Sontate.
Thank you very much, Honourable Chairperson. We were honoured to be able to make a submission to the committee in October. We focused our submission on the issues at hand and an aspect of the mandate of the committee, which was to consider the need for legislative, policy and institutional reforms to restore public confidence in the criminal justice system. And we focused on 2 issues that we thought pertinent. The first was strengthening Parliament's oversight functions, and the second on further insulating SAPS's operational command from executive interference. These relate to what we understood as the call to establish the committee and the ongoing work of the committee. So I'll turn to the first issue, and that is around strengthening Parliament's oversight functions. One of the kind of concerns raised by General Mkhwanazi in response to the press conference that precipitated these events was that he had previously submitted statements to Parliament and to the Portfolio Committee, but that these, in his opinion, had not been taken further. And he was presented with, again, as he alleges, very little opportunity or option but to engage this through the press. Reflecting on this, we think that there certainly is pause for thought in terms of Parliament's ability to strengthen its responsiveness to allegations or issues, concerns that are brought to their attention. And these could include initiating an investigation for further information or potentially calling police management to further explain the situation. Honorable Chairperson, we believe that it is a critical duty of Parliament to respond and address allegations of political interference in policing. It is beyond an issue of discretion or political discretion for the committee. This is something that goes to the heart of the separation of powers. It goes to the heart of independent democratic policing, and these allegations demand serious and immediate attention and action by Parliament. So we submit that there are potentially areas where we can think through around further strengthening Parliament's ability to respond. One is the whole issue of recommendation and request that is made to the executive appearing before any of the portfolio committees, and the ability of those portfolio committees to follow up consistently, comprehensively, and in a decisive manner. How do we strengthen that environment so that there is a clarity and a responsiveness, and that is built into the action? I think a further area is the support for members of Parliament and the parliamentary staff, the committee secretaries, the content advisors, and the researchers with further capacity and training when it comes to a rapidly changing environment, particularly regarding criminal justice issues, the continuing evolution of policing, and South Africa's response to the crime and insecurity that is facing the country. The issues that come to our fore in vary and we anticipate will change over the course of time. That how we recognize corruption and interference today and how it manifests itself might not be the same way that it would manifest itself in 5 or 10 years. There could be a number of reasons around this: the advance of technology, the shifts in the way in which crime and insecurity manifest itself. There's a range of things, and it's important that Parliament has the capacity and is up to date to be able to recognize and respond with the best knowledge and evidence at its disposal. And then finally, the ability of Parliament in terms of being able to effectively track progress and the impacts recommendations that it makes, that issues are brought to its attention, that it identifies an area of concern or a weakness, that it makes a recommendation that these be addressed, and that there is a timeous, coherent, and effective response from the department, and Parliament is able to track this and engage if further input is needed. And here too, we think that there's opportunity to strengthen the capacity and the work of Parliament looking into the future. So we offer a few suggestions, and we do so very humbly, in the sense that Parliament is appraised of its workings and its capacity to a far greater extent than what we are. But we thought perhaps the establishment of a subcommittee of the, in this instance, Portfolio Committee of Police, but it can be and potentially is relevant to all criminal justice system portfolio committees, with the mandate on an ongoing basis to scrutinize interaction between the executive, SAPS, and extended all law enforcement and criminal justice agencies. And that the monitoring and evaluation capacity of Parliament is strengthened with facilities that are able to track the implementation of its findings, recommendations, and the actions taken by the executive. With regards to the latter, and again, we submit humbly, is that this could potentially be established under the office of the Speaker, and ensure that the Speaker conveys parliamentary findings, recommendations, decisions to the relevant member of the executive, along with clear deadlines for providing feedback to Parliament. That there is a mechanism to track responses, communicate progress, and distribute feedback back to the relevant committees. We submit that sanctions be considered and imposed on members of the executive who fail to comply, particularly with the deadlines, or fail to provide adequate feedback on what is requested. We think that the system would be further strengthened if we are able to require of SAP's leadership and the Minister to submit regular public reports to Parliament detailing all executive instructions that are provided to SAPS, and that this provides for a proactive scrutiny of the interaction. And finally, that we are able to strengthen performance management of SAPS, the Independent Police Investigative Directorate, and the Civilian Secretariat of Police by providing and developing specific indicators on responsiveness to any allegations of political interference and corruption, and that this be developed and built into their KPIs, can be tracked and can be engaged with by Parliament. We go on to our second issue, and this is related to some observations regarding further insulation of the operational command of the South African Police Services from political interference. We believe that we need strengthened legislative provisions to ensure, in the first instance, transparent and merit-based appointments to SAP's leadership, that these be done on a competitive basis. that we ensure that the tenure for operational commanders, the security of tenure for operational commanders below that of commissioner is also provided for, and that legislation clearly codify the separation of roles between the minister and the commissioner, and provide that needed clarity and accountability, which has been this issue of contestation that has come up in how parties have responded to the allegations that have been made. We in legislative reform, and we're mindful here, Chairperson, that we do have a SAPS amendment bill that is waiting in the wings. We have seen a copy of 2025 that is awaiting a process for development and of submissions. But that these events do give us the opportunity to scrutinize that amendment bill and ensure that whatever recommendations are developed by this committee, whatever comes out of the Madlanga Commission, that those can be brought in and we are presented with a golden opportunity to actually strengthen the SAPS legislation to address the concerns that have manifested themselves over the past years. When it comes to executive instruction, we submit that these must be made in writing, that they must be entered into a formal register, and this must be available for review by Parliament, IPID, and the Civilian Secretariat. And further, that legislation should provide for and allow SAPS management to be able to report in a structured and systemic way any instances where they feel there has been undue political interference, and this happened through a defined process to the Portfolio Committee. That this avenue presents itself as an opportunity should the submission of the register be something that we would not want to wait for in regard to the submission of the register. And finally, that any unlawful or improper instructions by the executive should constitute grounds for accountability before Parliament. And in the same way that we advise members not to implement unlawful instructions or commands, that this should be the same in this instance. In our submission, Chairperson, we do reflect on the model police law that was developed by the Pan-African Parliament, and the model police law recognizes the importance of the separation of powers, and in this instance identifies areas that should be excluded from ministerial instruction. And these include, for example, enforcement of the law in relation to any person or groups of person, the investigation or prosecution of offences in relation to any person or group of persons, the preservation of peace and the protection of life, property in relation to any person or groups of persons, and the allocation or deployment of police officers to particular locations or in regard to any extraordinary situations or made in cooperation with other government ministries or departments. And finally, it should also include the operational structure of the organization, which is in the purview of the commissioner. Chairperson, I want to conclude by making 3 further points. These were not included in the submission that we submitted in October, but as a reflection again on the events and the development of events. The first is that we think that there would be benefits in looking to establish formal interaction between the Portfolio Committee on Intelligence and the Police Portfolio Committee. And this is particularly with regard to the crime intelligence budget, the scrutiny of that budget and the reporting of that budget. Mentioned earlier in the proceedings as well, the importance of vetting and lifestyle audits for all SAP's senior management and of crime intelligence officers. And then finally, with regard to crime intelligence, we believe that there's a need that we relook at performance targets and make sure that these targets are clear and measurable and that they are in line with national police priority and government priority, so that there is a clear focus in terms of what it is that crime intelligence will be seeking to do in line with government policy and priority, and that will then guide the structuring of the budget and the individual performance areas for crime intelligence and the officers serving within that facility or division. Honorable Chairperson, thank you very much.
Thank you so much, Mr. John Tate. Sean Tate, not John Tate. Sean Tate. John Tate is that legendary boxer. We have come to the end of the presentations by Accountability Now and African Police and Civilian Oversight Forum, represented here by Advocate Hoffman and Mr. Sean Tate. I want to thank you so much for the formulations that you have presented here, hoping that they will help us to intervene appropriately in the legislative and policy architect that will help the criminal justice system in the country to be relevant to the challenges that the country and the world face today. We are going to proceed in this way. We use a rotation system of the members that we have in the committee. So I'm going to allow your members to ask questions and also to give comments where you may want to comment on the presentations. This is what will happen. Listen to me. You ask a question. It means when we deal with let's say, Honorable Sangweni, for instance, Sangweni, if you have questions, you can ask questions. And then when the questions have been answered, you have comments that you want to make, you comment. So that you don't come back later and say, I have follow-up questions. So we're going to take a door-to-door approach. We will start with Honorable Sangweni and then go to Honorable Nomvalo, Honorable Shongwe, Honorable Skosana, Honorable Breitenbach, Kola Banat, Honorable Cameron, Honorable Copper, Honorable Vessels, Honorable James, and Honorable Souls, in that way. Yeah. And then we will come back to the chair and the advocates here. Then from there, we will then break and release you. After break, we will take the next presentations. Thank you so much. Are we ready to start, Honorable Sangwen?
Yes, Chairperson, thank you very much. Thank you very much, Chairperson. Let me greet Advocate Hoffman as well as Mr. Tate. I just have a few questions. I'm not sure, perhaps I'll ask a question, we engage on it and we come back, since the Chairperson is being very benevolent today and hasn't put timing on how long we may speak. Chairperson, maybe let me start off by thanking both gentlemen for their submissions. I think they are very, very helpful, especially at this point in the process, because what we are trying to do is to get to a point where we say, having listened to, the witnesses responding to the allegations, what do we do with all of this? And I think in line with our mandate as Parliament, looking at the systemic issues, at the legislative issues, is really where we're going to be able to make an impact. I say this, Chairperson, and again, because I've got the latitude of time, right from the onset, I don't think that we ever thought as Parliament, given our mandate and our capacity, we could always make a determination of guilt, not guilt. It was always going to be about what are the systemic issues and how do we fix them, and perhaps even what are some of the politics, if any, around it. So maybe let me start with Advocate Hoffman. You propose, so you say, what is the mischief that we're trying to resolve? You then answer the question by saying that the reason the criminal justice system is dysfunctional is because of corruption. Then your remedy then is a body outside of executive control to effectively deal with corruption, I suppose. And I suppose this is where I want you to help me. There are bodies that are outside of executive control. And even in those bodies, you still have allegations of political interference of one form or the other. You just need to look at, for example, the Office of the Public Protector, where, and I do want to say that for me, this issue of political interference, which we've been trying to engage in this committee, seems to be very anecdotal, because we would really try to ask the witnesses, so have you, how many times, who would, it doesn't take away from me the irony that we're sitting here because of political interference, but it seems to be a bit anecdotal. So what is it that makes you think that a body not directly reporting to a minister, because that's what it means crudely, insulates it from corruption? And then secondly, this body, how would it differ, for example, from what is proposed in the NACAC report, which looks at establishing an office of, I think it's called Public Integrity and Ethics or something. It takes the mandate of the SIU, brings it in-house. So how does it differ? And then in this architecture that you envisioned, where then would you locate, for example, IDEC? And thank you so much for saying what you said about IDEC literally being a reincarnation of the Scorpions, because Honorable Breitenbach was very dismissive of me when I said that it is a reincarnation of the Scorpions. So the African National Congress has sought to go back and rectify some of the decisions that perhaps we would have reconsidered. So maybe let me stop there, give you an opportunity to answer, and then I'll come back. Thank you so much.
Thank you, Honourable Sangoni, for the opportunity to engage constructively, I hope. The beauty of an all-new organization is that you start from scratch and you appoint people who are like Caesar's wife. You subject them to integrity testing, you subject them to lie detector tests, you ensure that they don't have the baggage that is interfering in the system at the moment, and you lead them properly. Can I refer the committee to the minority judgment of Justice Cameron in Glenister 3? In that minority judgment, he deals with how do you appoint people who are not going to be corrupt? That's putting it very crudely, but that's what he was dealing with. And the system that he suggests there, I would recommend to this committee as being the correct way to going about ensuring that this new Chapter 9 institution is not the same as the old Chapter 9 institutions. I think you will find that those Chapter 9 institutions who have wobbled have been led by people who are appointed because they are favored by the president at the time and are therefore more inclined to be executive-minded than to be independent. I think that I think that answers that aspect of the matter. As far as NACAC is concerned, I'm afraid NACAC is congenitally incapable of getting away from the ideas of the National Democratic Revolution, which we have contended for a very long time, are absolutely anathema to the values of the Constitution. The idea behind the National Democratic Revolution, as everybody in this room knows, is to secure hegemonic control of all the levers of power in society. And obviously, the Criminal Justice Administration is a big lever of power. So the idea that that form of control should be tolerated in a constitutional democracy under the rule of law is quite wrong, and we need to get over it, because we are now in a situation in South Africa where we are no longer a dominant party state. And it is quite conceivable that those who hold the levers of power now may not hold them in time to come. It's a good time to clean out the stables and make sure that the system works no matter who is in charge. So that I think is something that needs to be taken into consideration as we move into the era of coalition politics at national level, which we have only just entered, May 2024 for the very first time, unless, of course, you regard the tripartite alliance as a coalition of sorts. But I think that that's perhaps pushing the idea of coalition.
Sean Tate, anything to say on the question that was fielded? Okay. You may proceed, Honorable Sangweni.
Okay. My next question also refers to a statement, I suspect it may have been made by Advocate Hoffman again, where he, in reference to the National Prosecuting Authority, says that the minister has veto rights. Now, that is not my understanding of, either the role of the minister or how practically it works. I have heard of two examples, if I'm not mistaken, one involving the late Minister Nathi Mthethwa in relation to issues of prosecution. So again, I say, for me, this becomes anecdotal. I'm not saying we must not resolve the problems because, they have not yet gotten as bad as they could be. But if you could just give me guidance on, when you say the minister has veto rights, that would be blatantly illegal. Now, you then say that if we were to take this approach, we're resolving the problem of the NPA not having authority over its budget. I understand that the accounting officer is the Director General, right? But the NPA I'm sorry, I'm not in the justice portfolio, so I may get some things wrong, but my understanding that it's appropriated a budget, even though that budget resides within the Office of the Director General. This discussion that you're raising doesn't seem to be much different from the ones that were raised by the judiciary, who insisted that they wanted to be outside. So in reality, are you envisioning a situation where this separation of powers literally leaves the executive not having control, what you call hegemonic power, not having oversight, maybe is a better word, oversight over these particular institutions that have been established as part of executive functions, because they don't exist of their own? And perhaps my last point on this, and it depends on your response. You then say they must be accountable to Parliament. We are sitting with a situation where Mr. Tate in his presentation speaks to the limitations of parliamentary oversight, yes, taking into account, some of the recommendations he's making. But we also have instances where members of Parliament are accused of interference in the criminal justice system. Now, are you not just playing musical chairs, thinking that if it comes to Parliament, you take it away from these individuals? And, are you not trying to change a system that has been proven to work across the world? I mean, I don't know, and please do educate me if I'm wrong. I don't know a country in the world where the Attorney General or the prosecuting authority is some independent, impartial, and you did say there was a difference in the words, which I like. So outside of executive control, basically runs itself, accounts only to Parliament. And we've seen weaknesses in parliamentary sole oversight over in these institutions. So how do you recommend that we would deal with that?
Thank you, Honourable Songoni. I think that your questions are pertinent and deserve a proper response. The question in relation to the concurrence of the Minister of Justice in the policy decisions of the National Prosecuting Authority, the NDPP, arises from any plain reading of section 179(5) of the Constitution itself. It says that the NDPP must determine, with the concurrence of the cabinet minister responsible for justice, and after consulting the DPP's prosecution policy, which must be observed in the prosecution process. So it's very clear that the concurrence of the Minister of Justice, there's no similar provision in relation to police, which is obviously your forte because you're not on the Justice Portfolio Committee, you're on the Police Portfolio Committee. But the bottom line is in section 179(6), which says the cabinet member responsible for justice must exercise final responsibility over the prosecuting authority. That's very much a situation where the executive is in charge. And that flows as a matter of what was before the court in the Glenister litigation to a situation in which politicians have control. Politicians in the executive have control of what the National Prosecuting Authority is allowed to do. And you remember, maybe you're too young, but you remember that Vusi Pikole lost his job because he could not agree with the then Minister of Justice in relation to what should happen to Jackie Selebi. And he was suspended, he was eventually fired, and he litigated his firing and won, well, settled favorably in the litigation. And today he works in government as a special advisor to the man who brought us all here today with his attitude towards the political killings task team. If you are concerned about political control and feel that the executive is a better place for political control to be situated. Just consider this. In a multi-party democracy under the rule of law, a body like the Justice Portfolio Committee consists of members who are drawn from all of the bigger parties, if not all of the parties, in Parliament. So it's across the political spectrum. There's far less opportunity of interference and conkling and getting involved on the wrong side of the law when you have your colleagues in a portfolio committee keeping you honest. Whereas in an executive branch of government, you get the likes of Nathi Nhleko and, sorry, gentlemen, and you get the likes of Bheki Cele, who also features in the evidence in this matter. It really is very difficult when a person like that is the one who's calling the shots, rather than a committee of Parliament exercising oversight over the activities of a body outside executive control that has a very specific mandate to deal with corruption. The reason why there is so much corruption is that the executive branch of government has become corrupted in South Africa. There may be individual members of Parliament who are also corrupt in their various ways, but for the executive to be in that situation where decisions are made because you are protecting your colleague who may or may not have done something wrong, or you simply feel beholden to a colleague who has done something wrong, then you are not getting the type of oversight that we are entitled to, not only because of Section 7.2 of the Constitution, but also because South Africa has solemnly undertaken in international treaties to create an independent body to deal with corruption. Corruption is a particularly insidious form of crime. You don't see it happening. You don't know that you're the victim. There's no body, there's no blood, but there's big damage. That's really why corruption, why the court decided when it was confronted with all of this, and with a great deal of argument too, why it decided that it's a better idea that a body outside executive control should be created. And if you go the Chapter 9 route, which doesn't have to be, but it's the one that is favored by the Honorable Breitenbach and by Accountability Now. If you don't go that route of having a reporting line to Parliament instead of to the executive, and the executive is fraught, well, more problems are going to arise down the line. Hence, the idea that serious corruption and organized crime need to be the province of a specialized body. And by the way, my colleague, Mr. Tate, mentioned the IPID. IPID's mandate should have corruption carved out of it and given to this specialized body. Otherwise, you're going to have IPID looking at corruption and the Anti-Corruption Commission looking at corruption, and a lot of falling through between the cracks. IPID it's very invidious for IPID because the Minister of Police thinks he's in charge of IPID. It's very invidious for them to do their job properly when it comes to serious corruption. And the way to solve that is to say IPID can look after the petty and serious crimes that are not part of corruption. And then you'll solve your problem that way.
Any addition from you, Mr. Tate? I know the issue of Parliament was a key part of your presentation.
Yes, no, sorry, that's yours. Sorry, I took my glasses off and all I could see was, yeah. It was a question for my colleague, sorry, yeah.
Could switch your mic off. Thanks, Advocate Hoffman.
If I understood your question, it reflected on the challenges within Parliament among members being accused of interference, and that a response to executive interference, if it resides completely within Parliament, perhaps isn't or might not be responsive enough to those types of challenges. You raised it in relation to the reporting lines of either the anti-corruption body or the OPI in terms of where it goes. But reflecting on the issues that we raised in our submission, I think there is a substantial difference between an allegation of interference that comes from the executive versus any other politician or member of Parliament in this instance. The executive is the accounting officer, or not the accounting officer, but it is the political accountability of the operation of in this instance, the police service. This is where the policy is set. This is the entity that presents the budget, defends the budget, presents the annual report. And so if there is interference there in terms of operational matters, it carries a significant consequence for the ability of the commissioner in this instance to be able to do his or her work and to do it without fear or favor. Policing is constantly confronted with engagement, political engagement in terms of what and how they should be doing their work. This does not always have to be party politicians. You see it at community police forum meetings in terms of the weight of certain members or interests in terms of what they want to advocate for. You see it at amongst potentially their interaction with politicians, local government or provincial or national. And it is par for the course in being able to navigate that and to stand up with the law and the integrity of your organization behind you to be able to provide that service. That ability is corroded when the interference undermines the leadership and undermines the ability of or how the leadership is seen to be able to act with integrity. And I think that's where we need to put a particular emphasis on that, and then through training and supervision and engagement, help members on the ground navigate the political pressures that they will be under on a day-to-day basis as they carry out their work.
Okay, now let me leave it there. I'm sure, I mean, we'll have a lot of time to engage this also as a committee, and I'm sure society in general, although my view is the fact that I think that we're trying to tinker with systems because of individuals, that you have had people who have sought to work in a manner contrary to how the system is intended. And now we're looking at this whole thing, we're saying it's not working when, you know, a lot of thought would have gone into it. And I suppose a lot of dialogue, even right at the beginning. And we would have thought that that was the best way. I'm going to ask you a question that I'm going to ask anybody who appears here from civil society. And I really hope that you don't take it as an attack. Right. But it's important for us. There's no question that there's a trust deficit in South Africa, you know, across any line that you talk about. And we, as the African National Congress, have been obviously considering the sponsorship of a bill around NGO funding. And I'm asking you because you are civil society, where in particular we would want the same level of transparency that political parties are expected to display in terms of their funding and things like that. And I really want to know from the perspective of accountability now. And Mr. Tate, I'm so sorry. I've realized I'm not as young as Advocate Hoffman says. So my eyes are going a bit. African Policing Civilian Oversight Forum. Would you be open to openly declare your funding sources, and where there is foreign funding, like political parties have got limits and ceilings to operate within that sort of system?
Yeah, look, I don't think there's any problem at all. I don't think it's a good idea that secret funding should be given to NGOs anyway. And we've always been open about who has deigned to give us money, and it's never been a lot.
May you list
Sorry,
the-
I'm not too far away from the mic.
Yeah.
All right. I think I've answered the question. Accountability now doesn't have a problem with the proposals in relation to funding. But I do need to circle back to NACAC because I didn't deal with it when in the last round, and you asked a question about it. I have, in fact, in paragraph 23 of the main submission, I have dealt with the criticisms that we at Accountability Now have in relation to the NACAC proposals. The difficulty with NACAC is that they seek to preserve executive control, which is exactly what the court has said you can't do. And in relation to the Office of Public Integrity, they even go further and say, yes, we'd like to roll the SIU into it, which is a good idea because the SIU has got a very limited mandate and OPI would have a much bigger mandate. But in doing that, they say they would like the power of the president to issue a proclamation to OPI to go and look into this, that, or the next thing. And that is a manifestation of executive control over the OPI. And by its very nature, the OPI could not be put in Chapter 9 of the Constitution because that chapter says all Chapter 9 institutions must be outside the control of the executive and must account to Parliament, which is what they've all done all along. So I think that's the short version. The long version's in the written submission.
Mr. Sean Tate.
Thank you. As an organization registered, our funding and expense is completely transparent. So we are registered as a public benefit organization. Our annual reports, our directors, our finances in terms of audited statements are all listed in response to maintaining our public benefit number. And as a non-for-profit trust, we are responsible for producing an annual report and annual audited financial statements. Those are on our website and they're available for further scrutiny. Every transaction that comes into the organization is scrutinized by the bank and reported to the Reserve Bank. Every transaction that goes out of the organization, if it's foreign in nature, is under the same scrutiny process. So I think those controls in terms of what is coming, what is going, who's doing what, who is supporting and how are all in place. And I think South Africa has come a long way in terms of that initial grey listing to be able to address all of those loopholes. The second part of your question is, it demands a lot more conversation. As you know, civil society, not across the globe, and I'm pleased to say in South Africa that this is not the case, is under considerable pressure from authoritarian responses to its actions and to the statements that it's made. And one of the go-to responses has been to try and limit foreign funding to a certain percentage or just limit it totally. As I said, it requires a conversation, but the net effect of that, particularly if funding is not readily available in the country, just given kind of economic kind of status and the availability of donor funding in country, has the effect of silencing and chilling and kind of limiting the ability of organizations to function. And you know, in a democracy, you want the voice. You want to engage. You don't want to put the lid on the pressure cooker. You want to be able to interact. So it's a question of really looking at that piece in a lot more detail. And if that bill does come before the committee and there is consideration, it's certainly a conversation that we would like to have with you to think through the issues. Thank you.
Thank you very much, gentlemen. And you're totally right. I think it's things that we need to speak about. I mean, it would be remiss of me to say, you know, one sees it as a response of an authoritarian regime, whereas on the other hand, and this is not like just ideological commitment to something that doesn't exist, we've also seen civil society being used to subvert democracy in certain instances. So, but I do appreciate your responses, both of you, and thank you once again for the public submissions. Thank you very much, Chairperson.
Thank you so much, Honorable Nomvalo.
Yeah, no, thanks, Chairperson. I don't think I'll be very long. Let me appreciate you as well, like the latter speaker, for the submissions that you have made. I would like us to engage insofar as the NPA is concerned about the appointment of the NDPP by the president, as it is entailed in the Act, I think in Section 12 of the Act, the NPA Act. No, the suspension, not the appointment, the suspension of the NDPP. So it provides that the president must initiate the suspension process and make a recommendation to Parliament, and that leaves less space for Parliament to intervene right at the beginning when there's a problem in the NDPP's office. So I'm saying my view or our view as the MK party is that that provision is a bit problematic in that it doesn't give space to Parliament to act when there's a problem in the NDPP. It will first have to wait for the president. And remember, the very same NDPP has been appointed by the president. It's public knowledge. It's an open secret that as the MK party, we had some serious reservations on the previous NDPP, the outgoing one. But there's nothing that we could do to influence Parliament to have a position regarding her term and regarding her misconduct. So we had to wait for the president first. So don't you find that provision alone limiting or eroding the independence of and coupled with the appointment process of the NDPP? Because remember, the NDPP is appointed by the president, and the president can disregard, as he has done recently, the recommendations of a panel and use his discretion to appoint the NDPP. So at a basic level, at a basic constitutional level, don't we find that to be a direct threat to independency of the NPA? Well, what is your take on that?
Yes, thank you. That's a question that's got very long legs. But if you look back in history, you'll recall that Deputy Chief Justice Moseneke said in public that far too much power is concentrated in the hands of the president in the way that our constitution in South Africa was put together. I think it's because everybody thought that every president after Nelson Mandela, who gave my learned friend, Mr. Orange, and I our letters patent, and he has not been succeeded by clones, and the result of that has been that a lot of what could have been has not happened. It's wrong to suggest that the National Prosecuting Authority is independent. You frame your question in that way, but it is correct to say that the independence, if there ever were independence of the National Prosecuting Authority, is undermined by giving the president so much power in relation to the suspension and indeed to the appointment of the leader of the National Prosecuting Authority. So I'm agreeing with you that too much power is concentrated in the hands of the president, and that probably in a coalition type of parliament that has found its feet will be dealt with by amendments that can address the over-concentration of power in the hands of the president. Your point is well taken.
Can we move on? Okay. Now, secondly, our take is that in terms of the legislative framework, there is no deficiency in the already existing bodies, the NPA, IDEC, and so on. The problem is a problem of one, of incompetency. That's number one. And two, we have a problem of undue political influence. Politicians are influencing this institution to a point where they get compromised. The work that they are doing gets compromised. So our view is that we must cement the institutions the bodies that are in existence. And we must clean and ensure that all the problems that I've spoken about do not find expression therein. So there is no problem with the NPA. And if there are legislative deficiencies that need to be addressed, we must identify them, but not change the structure or change location, take the NPA and put it under the Chapter 9 institution. The reason why I'm saying that is because it's not guaranteed that when a body is under Chapter 9 institutions, it's not going to have challenges. And it's not guaranteed that when it's under Chapter 9 institutions, there will be no political undue influence. We, in terms of our assessment, we're coming from different political parties. But our final assessment is that there are Chapter 9 institutions which are not immune from political influence. Badly so. So it's not guaranteed that when you establish a new unit and put it under a Chapter 9 institution, it's going to be a paragon of virtue. It is going to be affected by these challenges for as long as you don't address the issue of capacity, for as long as you don't make sure that you put enough mechanisms and systems that will preclude this political influence. So that is our take. Then how can you engage this submission that I've just alluded to?
Yes, thank you for the opportunity to do so. It's important that we have this discussion because as matters stand, we are not talking here in this committee about the overall structure of the criminal justice administration. I have suggested that the focus of this committee should be on the rampant corruption with impunity. That is the particular problem that we are facing in South Africa. As far as accountability now is concerned, there is a binding decision of the highest court in the land which tells Parliament in terms that a body outside executive control is required. Now, you may be right. It could well be that the court came to that decision without ever pointing fingers at anybody, because it was convinced that the executive of 2011 was corrupt and wasn't prepared to allow that executive to have anything to do with anti-corruption work. Be that as it may, the law is that anti-corruption work ought to be taken away from the various institutions that deal with it. And I'm talking about the National Prosecuting Authority, the Hawks, IPID, all of those have a mandate that covers corruption. The way to rationalize it in terms of the decision of the court is to create a single body. It doesn't have to be a Chapter 9. If you can think of a better way to do it, to insulate that body from undue political influence, well, let's talk. But the structure that is there with Chapter 9 institutions who have guaranteed impartiality and independence in terms of the Constitution seems to be a sensible place to start with this specialized, trained, independent, properly resourced, and secure in tenure of office body which will deal with serious corruption. That's all, just serious corruption. That's its whole mandate. It's a small body. It will probably be populated by a lot of people in the SIU. I think this committee is well aware of the fact that the SIU does so much better than the NPA because it has a different salary scale for its staff, and it's able to cherry pick the best people in the NPA and the police to go and work for the SIU with its mandate to be the debt collector for the state and the SIUs. So I'm not sure that there's so much difference between your position and Accountability Now's position. I think it is incorrect to assume that the National Prosecuting Authority is independent. It's certainly not if you read the Constitution and if you have regard to what the Constitutional Court said about the meaning of the Constitution. See, the problem that they were facing in Glenister 2 was that corruption was running out of control. Said so as well in Glenister 3, in the first two paragraphs of the Glenister 3 judgment. And when that happens, it's necessary to take stringent measures. I think the former Chief Justice Zondo has been on record now, 24 or 25. Urgent, drastic steps need to be taken in order to prevent corruption from capsizing the ship of state in South Africa. So that recipe of creating a body outside executive control is the way to deal with malfeasance and perhaps dysfunctionality in the cabinet. They have nothing to do with corruption, and the multi-party parliament is the oversight body, because in parliament, you're all watching each other and making sure that everybody is behaving properly. Whereas in the cabinet, it's only cabinet members who are doing their business.
Currently, we are faced with a quagmire as this committee of having to make a determination on an allegation of undue influence in the police. An influence that an executive action has encroached to operational framework in the police. So you have also spoken about the responsibilities of the Minister of Minister of Justice. And my reading is that you seem to have reservations on the present responsibilities of the Minister of Justice. So are we likely to see a situation, even if these allegations in the police are anything to go by, are we likely to experience the same scenario in the Minister of Justice of an allegation of an encroachment by the minister because maybe of an ambiguity either in the legislation or in the constitution by the minister interfering in the work of the NDPP? Is that a possible scenario because of how the current legal framework is designed? And if so, then how can it be avoided?
Thank you. As far as the police are concerned, I've made the point in the written submission. If the Glenister 2 decision was in place now, the Minister of Police would have absolutely no say in the matter at all in relation to what he has purported to do in respect of the political killings task team. He wouldn't have been in the loop. It would have been anti-corruption work, which is what political killings are about. And that task team would not have existed. It would have been the job of the Anti-Corruption Commission to dig into it. So I think we must be careful not to try to preserve too much of the existing framework when all that the court has said is in relation to corruption, it's necessary to have a party outside executive control if you want to have effective anti-corruption work in the country. And that being the case, you're going to, I think it would be a good idea to give the National Director of Public Prosecutions greater independence and to curtail the powers of the Minister of Justice insofar as that body is concerned. And I'm talking in general now, not just in relation to corruption. But as we sit here now, we're in this mess because Parliament, long before MK was formed, decided not to create a body outside executive control when it amended the legislation in relation to the Hawks and its anti-corruption mandate, which is only part of the Hawks mandate. I mean, priority crimes covers all sorts of things that have nothing to do with corruption.
So when you say to curtail powers of the minister, you mean the minister must not even play oversight, must have no oversight responsibility over the NPA?
Yes, what the Constitution says at the moment is that the Minister of Justice has final responsibility over the NPA, which led to Vusi Pikoli losing his job and to much friction between the executive and the NPA. But if the NPA is given greater independence, it doesn't have independence at the moment. If you look at the section, we've all been staring ourselves blind at that term, without fear, favor, or prejudice. It's in section 179(4). And that section says, national legislation must ensure that the prosecuting authority exercises its functions without fear, favor, or prejudice. So it's a purely operational thing. It's not about the structure. It's not about the chain of command. It's not about who is the boss and who isn't the boss. It's about doing your work impartially. And for all sorts of devious reasons, that has been understood to mean that the NPA is independent. It's not. it's enjoined to be impartial. And to make matters worse, the national legislation referred to in section 179(4), that legislation that must ensure that the prosecuting authority acts impartially, doesn't exist. There is no such legislation.
So does this final say that the minister has also relate to prosecutorial work? Does it also relate to prosecutorial work? If maybe there's prosecution that is being done in KZN, the matter escalate for the minister to make a final determination of whether the matter can be prosecuted or not, or that lies solely in powers of the NDPP as the final arbiter in that context.
The NDPP is the author of prosecution policy. If the work that has been done is within the parameters of the prosecution policy, which has to be concurred in by the minister, and the minister comes along and seeks to interfere, there'll be trouble. But as matters stand, prosecution policy must carry the concurrence of the minister, which means that the NPA is not independent. That's the only way you can read section 179. There is no other way to read it. No other honest way to read it.
Okay. So I think this is my last question. So what is your final conclusion now within the context of allegations that this committee is investigating? Have all these shortfalls that we have alluded to had an impact in these allegations? Maybe if they were all closed, if they were not present, maybe we're not going to face allegations like this. Is that your final assessment?
I think that had there been a body outside executive control looking after the corruption or the incidents of corruption with impunity at high level in South Africa, this committee would not have put so much energy, would not have been called upon to put so much energy into dealing with the matter. And to my way of thinking, as respecters of the rule of law, the members of this committee will look at the big picture, see that the Constitutional Court has ruled that a body outside executive control is required to deal with corruption effectively, and it will see to it that the parliament to which it belongs does the necessary to honor the decision of the Constitutional Court in Glenister 2, which has not happened so far. And the way to do that is to debate the Breitenbach bills, which are pending, properly, refine them, make sure that they have no rough edges, and make them law, because then you will not have to have an ad hoc committee trying to decide whether this minister or that minister or the other deputy minister has intruded across the lines between executive control and operational work, because those lines won't exist anymore.
Okay. No, thank you very much, SC. Thank you, Chair.
I'm so glad I've persuaded you.
Thank you so much, Honorable Shongwe.
Chair, I'm still scribbling something here. Can I pass it to Honorable Sposana? I'll come back.
Okay, thank you.
Thank you.
Thank you, Chair. And welcome to our witness, Advocate Paul Hoffman and Mr. Thames, if I remember well, the surname, Sean Tate from AFCO. I'm going to start with Advocate Paul Hoffman. My question, I'm going to be very direct to you, because South Africa, as South Africans, we are infiltrated by this so-called motive forces. There's European interests in this country using civil society. White privilege, they want to maintain it at all cost in disguise of civil society. I can name them, Helen Suzman, your organization as well, Kazakh, and others. My first question will be, who's funding you? Because I think the honorable member asked you, and for me, I was not happy with your answer. Just want to find out, let's start there in the beginning. Who's funding Accountability Now?
Accountability Now is funded by small contributions from members of civil society in South Africa. It is also supported by the Konrad Adenauer Stiftung, which has offices all over the world in about 90 different countries, but they do not pay us any salaries. They simply give us work to do. And they have an office here in Cape Town and another one in Johannesburg. In the past, we have attracted funding when we took on the dysfunction in the education system. The Potter Foundation in the UK gave us some money. But none of the directors of Accountability Now draw a salary, and none of the work that is done by them is paid unless it is in public interest litigation in which a costs award is given in favor of the litigant being represented. That's not a financial model, and it's not one where a great deal of money changes hands.
I understand the issue of which we are raising, the salaries and the benefits, and my worry is simple. You've mentioned the Potter, I think it's the Potter family, Dr. David Potter and Dr. Elaine Potter, Michael Polowski, and all those, because they've got their own trustee as well. I mean, those are trustees of their own organization. But my question is simple, Advocate Paul Hoffman. Mkhwanazi said, there's no free lunch. There's no free lunch. What interest do they have in this country? Those Western, these people we are talking about. And the civil society, civil society, as I said earlier as well, they've got their own interests. And in this country, what we've seen, they target black professionals. They come as what they call it, friends of the court. I'll give you an example, perhaps to draw your attention. Your organization said nothing about Phala Phala, am I right?
No, on the contrary, we believe that Phala Phala is a disgrace, that the ConCourt has taken far too long to deal with the appeal in relation to that. We're now waiting more than a year. It's December. It had its birthday in December last year, and we're now close to February this year, and we're still waiting for a judgment. Yeah. And we have, if you go and look in Business Day, you'll see I've written in Business Day saying it's just not good enough that the ConCourt is taking so long to produce a judgment, which they say should come within 3 months, and it's now over a year since they heard the matter. So we're with you on that one.
Yeah. Hence we say, we cannot be held at ransom by a constitutional court. We can't be ruled by 11 judges in the constitutional court. We are lawmakers here. We have to make laws in this country. People voted for us to be here. Now, you've raised an issue now to say they've promised in 3 months' time.
That's the standard. The standard is 3 months'
time. Yes. That's what's supposed to have happened, and it never happened. Because they are law unto themselves. Do you agree with me on that?
I can imagine, because I have an insight into how these things work, that there may be different threads of thought in the Constitutional Court as to how the matter should be dealt with. and that those are being debated between the justices who are sitting in the matter. Unlike you, I still have confidence in the ability of the Constitutional Court to uphold the law and the Constitution. And it is a bad example that we have all been kept waiting for so long on the Parla matter.
Let me just add on that. Do you believe that judges are independent?
I do know that the ANC actually admitted it in the Zondo Commission, that they felt the need to involve themselves in the appointment of judges at all levels, and that they were not willing to leave the appointment of judges to the discretion of the Judicial Service Commission. But I'm not sure what this has to do with the business of this committee.
I'm going to ask you once again, we've got term of reference, as you know. My question is very simple. Do you believe that judges are independent?
Yes. Yes, I do.
So are you saying judges are independent?
Yes.
So with all what is happening in this country, hence I was saying to you, you know that there's one judge who's suspended as we are sitting here.
Is that the corrupt judge in Gauteng?
No, I'm just asking to you, I'm just putting to you. You say judges are independent, am I right?
Yes.
And I'm saying no. And I can substantiate that they are not independent. You know, they are a human being like you. They are fallible. They are not supernatural beings. Now, in fact, we've got a problem of this Dutch Roman law. I think yes, the Roman Dutch law, we have a problem with that. Now, in fact, you said earlier, you've made a mistake and said the Honorable Sangweni is a member of the Portfolio Committee of Police. She is not. And as well, the issue, Advocate Rahman, the 35% is not true. They were supposed to answer for themselves, but they are 40%. There's GNU as we speak. Our fellow opposition party before we came into Parliament, who raised the issue of Pala. They won't raise it again. They are very happy because, as you know, it's politics. You know, they are in the same bed as the other parties, in fact, who did not mention the issue of Pala. They've forgotten about Pala completely. We are the one and the other opposition party who are still raising that, and I'm happy that you have said so as well. Let me come back and take you back to CIX. You were a complainant, am I right?
CIEX?
Yes.
Yeah.
No, can you get closer to the mic, please?
Sorry. Yes, we complained to the public protector that the work that was done by CIEX hadn't been followed through on in the new South Africa after it was found that there was corruption in the old South Africa and that it was possible to rake back loot from various parties involved in malfeasance in the old South Africa. We did initiate that.
And you raised that with the public protector, Advocate Turima Tonsela, am I right?
Correct.
6 years down the line, there was nothing from that office, am I right?
She actually told us that she wasn't going to deal with the matter at all.
Yeah,
and then she changed her mind and she tried to deal with the matter, but she didn't actually finish her report.
Now, when that report was released, were you happy with it?
No, I wasn't.
That ABSA must pay the interest.
It wasn't what I was expecting at all.
No, what I'm asking, were you happy that ABSA was ordered to pay the interest?
No, I don't think that was a correct order.
Yeah. Now,
neither did the Constitutional Court for that matter.
So why were you complaining? What was your complaint about that?
The complaint to the public protector was that I got given a copy of a report by CIEX that indicated that there had been malfeasance in the old South Africa, which I believed should be followed up on and wasn't being followed up on. And that is why Tuli Modonsela, in her term, worked on that case and kept that file open.
You remember Judge Heath?
Do I remember?
The report which the SIU reopened that proclamation which Judge Heath to recover the interest owned by ABSA. And you were against it. Hence, I'm asking, why were you against that report?
I didn't catch the name of the judge that you're referring to.
Judge Heath. Judge Heath.
Yeah, I don't know what happened in that part of the deal. It wasn't really germane to our complaint.
So it was normal, and you were talking about the executive getting involved in other issues, that even the executive went to court, you know, to complain that ABSA has to pay the interest.
Yeah, I'm not familiar with this part of the case, I'm sorry to say.
Yeah, but you were a complainant. But let's pass on that, Advocate Hoffman.
Yes, I did.
My issue with these civil society, you know, and these courts, you know, because I hear you, you know, you are very obsessed with the Constitutional Court or courts. Hence, I was saying to you earlier, they are fallible, they are like you. And we can give you examples with prosecutors as well. They've mentioned, some witnesses mentioned them here. And General Mkhwanazi is not only one person. And we know for a fact that especially the legal fraternity, they are closing ranks like any other institution to protect each other. To say, hence I'm saying, Mkhwanazi made it very clear that as judges, they are human beings. They are not supernatural beings. And he was right. I'll give you an example. Somebody was sentenced without trial in this country, and you said nothing. Nothing. I don't want to go to the merits of the case, but it was unheard of in this country. Unheard of. That no one will take an oath before the magistrate or the judge to plead guilty or not guilty. And we know what happened. We know what happened. Hence, I'm saying to you, this issue of establishing, I'll put it into in a plain, simple language. By hook or crook, it would be a rock unit of some kind. It will be a rock unit. This what was proposed, this bill which has to be passed here, it will be a rock unit. Perhaps in my view, and as Mkhwanazi says, I will say the SIU and perhaps the the Public Protector Office, maybe mesh them together, but don't have another institution. Then we are told it's independent. Independent is a big word. It's a big word. There's no guarantee that those people who you said they'll go through all the, what do you call it as well, light detector, the integrity. It depends in your eyes. In particular, the Western interest in this country is huge. We've seen in the Western Cape, some people want the Western Cape to be independent from South Africa. Us as indigenous people of this country, we are told that we are foreigners in our own country. And some of this civil society, they are quiet. Including the one which you are the chair. Corruption Watch is quiet. Kasak is quite quiet. Helen Suzman is quiet. And others. So in my view, I'll contextualize this, in fact, what you brought in here. For me, you said my honorable colleague, Honorable Breitenberg, is the one who brought this issue, as well of this independent, so-called independent body. But I'm saying there won't be any independent. They are going to push white interests here. I'll put it clean and clear. Bitter as it sounds, but there's European interest here in this country. We had the NPA, as you said, they failed. When Patoyi was brought from, I think he resigned elsewhere, he came in here, glorified to say he's going to lead the NPA. We know what happened. We know what happened to the so-called state capture, the Zondo issue. You might be correct, Advocate Paul Hoffman, on other issues, to say the executive, as we sit here, some of them who were named in that Zondo commission, we have to respect them. They are executives, they are ministers. Nothing happened. It was like a talk show. Big money has been spent.
Honorable Skhosana, the two organizations have made a presentation before you. And when we started, I said that they are not witnesses. And I listened for about, it's over 20 minutes now. And I wanted to hear you asking any question pertaining to their presentation. Because if you want them to comment on matters that are outside of the scope of their presentation, it's going to be very difficult for them. They are suggesting legislative and policy interventions. Or in short, just to say, they are proposing a review of the structural framework that we have in the criminal justice system. And they have been very categorical in terms of the areas that they wanted to talk to, including the recommendations they are making. So, but if we want to take them personally to say to them, who are you? And what right do you have to come and stand before us and make a presentation? I don't think we are being fair to them. I think I've given you adequate time to ask your questions. And once again, I'm going to give you time to ask them questions pertaining to the presentation and the suggested recommendations that they are making before the committee. Yeah.
Okay, thank you, Chair. Obviously, this presentation doesn't come from the sky. There's some roots in it. So I wanted to start with the roots. It might not be right, according to you, Chair. But I think Advocate Hoffman has done well in responding for himself, and I must appreciate that. I'm going to come to AFCOP, Mr.
Before you move on, will you permit me to respond to something that you put to me in the course of the last 20 minutes as an independent body in the judgment upon which I rely? It is simply a body that needs to be placed outside of executive control in order to deal with the mischief that the judges perceived when they were hearing the Glenister litigation. So we're not asking for an independent body. We are suggesting that the body that is a single body outside executive control should be one that reports to this parliament instead of that executive. And to the extent that you were suggesting that I'm here to ask for an independent body, certainly independent of the executive branch of government, but not independent in some nebulous way. So I just wanted to get that correct so that you and I are on the same page in relation to the work of this committee. Thank you.
Yeah, but I must just say to you as well, the Public Protector's Office reports here in Parliament as well, same as that body which you propose that should be established. So it will be the same thing. But for me, it would be costly as well because we don't have budget. You know, and those people who will want to be paid as well, as you said, you know, the salaries as well, people should be paid well and that, you know. So for me, and we don't think that we need another body. Let me be clear on that one. Coming to the issue of the subcommittee, establish a standing parliamentary subcommittee of the Portfolio Committee on Police with a mandate to scrutinize the interaction between the executive, SAPS, and all law enforcement agencies. Can you briefly perhaps enlighten us on that? Because we have the Portfolio Committee, and I guess that for us to have made a mistake in terms of what General Mkhwanazi presented to us, I don't know, those members of the subcommittee must come from where? Within ourselves as well, or must be from somewhere else, if I may ask?
Thank you, sir. No, I understand it as members of Parliament and members of the Portfolio Committee. The issue here is a system of systematic and sustained scrutiny of executive interaction with the operational leadership of the organs of the criminal justice system. So a facility that would receive, and we go on later to say, a register of those interactions, the submission of that register, but a subcommittee that will be able to engage with those issues and on a, I suppose, a standing basis, so that these issues are recognized as important and they scrutinized to the extent that there might be or might not be undue interference.
The strengthening of legislative provision to ensure transparency and a merit-based appointment within South African police service leadership. What do you mean? What do you mean by that? Do you mean that the current one is got some flaws?
Currently, the National Commissioner is appointed by the President.
Yes.
So we are advocating that in terms of the integrity and trust in the process and the trust the public has in the person of the National Commissioner, that there is a competitive and transparent process, much like the appointment of the head of public prosecutions, appearing before, interviewed by, and recommendations made that then go through to the President for final appointment. We believe that this will increase the trust and transparency in the appointment and the person that is being appointed.
If I may take you back, I know it's not about the police. You know that when the Chief Justice was appointed, there were a lot of hullabaloo because they recommended a judge who was supposed to be the Chief Justice was not appointed by the President. Am I right?
Yeah. Yeah.
Am I right?
Yeah.
And now, as we speak, there was these interviews of the NDPP, and unfortunately, no one was appointed for all those ones who were appointed. Don't you think the same thing will happen again?
Unless those provisions are tightened in the legislation, the way in which the system currently works is it is the prerogative of the president to make those appointments. We are arguing that the criteria for appointment is far more transparent and clear, that the competitive nature of the application and interview is provided for, and that the best candidate's name is put forward. If we believe that it would be beyond the purview of the president to then appoint somebody outside of that list, that short list that is provided, then this is something that Parliament and South Africa must apply its mind to.
Chair, I just want to thank for your benevolence as well, because you didn't give us time today. And I must say to both of you, thanks for your responses as well. And I made a lot of comments indeed. And I must say that, you know, this did rise from the patriotism, you know, of this country, you know, especially from Advocate Paul Hoffman. Hence, as Mkhwanazi says, we are still concerned about the civil society, especially those who are sponsored by the West. Hence, we have to, I had to question that. I know the chair has raised that to say, perhaps it was inappropriate. But for me, that's the route to know, because sometimes we are dealing with some people sitting elsewhere in London and Australia and other areas in the US, you know. Hence, I was asking, because we have that problem in this country when those people who've got big pockets wants to control the narrative. Hence, I even mentioned an example about the Western Cape, that today a foreigner for that matter is telling us that he wants an independent Western Cape. Hence, all those questions which are posed to you to say the issue of civil society is a big concern for South Africans, indeed, in particular, the indigenous people of this country. I thank you. Thank you, Chair.
If I may respond to the final words from the honourable member, I need to place on record that the only time in its history that Accountability Now has found a sponsor for public interest litigation was indeed in that attack on the malfunction in the basic education system that was sponsored by the Potter Foundation. It's the only time that we have lost big time. So the Potter Foundation has been impoverished to the extent that it funded the litigation, and it has absolutely nothing to show for it.
Honorable Shonga.
Thank you very much, Chair. Sanbonan Batlonesha, how are you? Now, I think I'm covered mostly by my colleagues and Honorable Sangweni. Sangweni. All right. Just few questions. Thank you for your time. Thank you for taking your time to even think or consider South Africa with your proposal. It's welcomed. However, I want to understand something. It doesn't, actually, one has to, before considering, you must think, who are these people bringing this proposal and what is their intention? So kindly forgive us if we travel that route a bit. What is your take with the issue of the ABSA loan, illegal loan? Should they pay back or what?
Yes, I thought that should have been paid back, and it hasn't, because the law has been differently interpreted by the courts and by the fiscal authorities as well. So you can't win them all.
True, you can't win them all. Can you explain to me, when you say it has been interpreted differently by court, does this mean we do not have a standard law in South Africa? For example, if we say 1 + 1 is 2, the standard law is that 1 + 1 is 2. Does this mean there's a problem with this constitution or laws that we have in South Africa? Hence, we come out in different outcomes all the time.
I think in this particular case, the way that it was looked at was because of the various transactions along the way, it would have been Sanlam shareholders who would have had to pay back the money rather than Absa Bank, and the consensus in the halls of power was that isn't the way to go, and we were wrong, and we were proved wrong on that.
So in your understanding, who should pay?
We thought Absa should pay, and we were wrong about that.
But now who should pay? Because the money was taken, right?
No order has been made as to who should pay.
But in your own understanding, or if you may suggest, who should pay in this regard?
The way that we looked at it, Absa should have paid.
Should pay.
Yeah.
Still stick to that.
Yeah.
I think I'm with you on that one. No, I just wanted to understand that, because in my mind, I was thinking that you were against Absa paying and protecting the apartheid debts. So I somehow wanted to understand that clearly. But what I want to understand as well, what was the issue with you and the public protector regarding the provincial, sorry, what is that, provincial, what do you call it? I forgot the name, but what was the issue between that? What was?
I don't know what you're asking about.
I'll record it. I'll just check it quickly on my notes. I wrote it somewhere. So while I'm looking for it, regarding all these Chapter 9 institutions that we have, do you think all of them are failing us? Hence, you want to have another one?
I must agree that due to cadre deployment by the ANC, some of the Chapter 9 institutions are not as good as they might have been if more objective appointment criteria had been applied.
Can you repeat that?
I'm saying that Chapter 9 institutions have been a terrain of cadre deployment. And as a consequence of that, the quality of the persons in charge of some of the Chapter 9 institutions is not what you and I would expect.
So this one will be independent of those? The one you're proposing would be protected from such?
Yes, no, it would be. It would be because the appointment criteria, as I discussed with your colleague, would be in accordance with the Cameron judgment in Glenister 3.
You somehow said the appointment to the PP was not accurate according to you, and you said she was a Zuma person. Do you think the system used to appoint the public protector is proper or is correct?
No.
Or does it allow a certain president to have powers on who to appoint?
It's the same story as I gave to your colleague on your left, that is too much power is concentrated in the hands of the president in the South African system. That's how these things happen.
But if a collective decides, how is that a president's decision? Because the collective comes and say, we recommend this for 3 names, then the president decides on those names.
No, the way that cadre deployment has been used in South Africa in the past is currently the subject matter of an appeal that is pending in the Constitutional Court, in which the Democratic Alliance has challenged the practice of cadre deployment in the public administration and in the Chapter 9 institutions and in the state-owned enterprises as well.
Okay, let me get your thought on this matter. I have a view that SIU should be taken to be under the public protector so that it beefs up that office. For example, currently SIU has seized or taken stuff from a guy called Maumela, but there's no charge, there's no case there, he's not arrested and all that. In the view of the public, that guy is guilty of something. But in the view of the law, you understand what I'm saying? So what's your view in taking SIU to be under the public protector? Do you think that will be proper?
In my crystal ball, and it's only a crystal ball, so let's talk in theory. The way that the system should be developed is that the SIU, which is not part of the Criminal Justice Administration, is not part of the Criminal Justice Administration and is not able to do anything without a proclamation from the president. So the SIU does not send anybody to jail. The SIU does not investigate criminal complaints. What the SIU does, it looks into maladministration and corruption where there has been a loss, and it then investigates and recovers using the special tribunal to do so. And that process is something that the new Chapter 9 Anti-Corruption Commission could very usefully take over. So in my crystal ball, the good guys in the SIU, the ones who really know their oats, they will pass the entrance exam to get into the Anti-Corruption Commission, and they will be used as investigators and prosecutors of serious corruption. They will be used, as the SIU is, to rake back loot from people who have been acting corruptly and making money out of it. And the SIU will be no more. Its infrastructure, its assets will be taken over by the Chapter 9 Anti-Corruption Commission. And the president will no longer be issuing proclamations and telling the SIU what to do and what not to do. That's the, I see your colleagues are agreeing with me. Thank you.
All right. Now, so do you think with the amount of these organizations or organs that we have, do we need another one?
Not a question of whether we need another one. The Constitutional Court, which I know is not the favorite organ of state of the MK, it is the highest court in the land, and it has determined in a manner that binds the state that our law, and I'm quoting, our law demands that a body outside executive control deal with corruption effectively. That's the line of the judgment that brings me here today. And in order to give effect to that, we are going to have to, in this committee, decide what is to be done about the mess in the capacity of the state to deal with serious corruption. And you have the advice of the highest court in the land, which has been given in binding terms. It's not as though it's a nice to have because the court said so. It's an order of court that required that amendments be effected to legislation. And they have not been done in a way that fits that description that I've just given you.
Thank you, gentlemen. I think I've heard both of you. I appreciate your time. Thank you very much.
Honorable Breitenbach.
Thank you, Chair. It's almost evening, but anyhow, good afternoon, gentlemen. A lot of questions, Chair, because I agree wholeheartedly with a lot of what's been said. So I'll start with Mr. Hoffman. It's very kind of you, Mr. Hoffman, to refer to the proposed legislation as the Breitenbach bills, but that's not entirely accurate, as we both know. The very basis of that proposed legislation is derived from the work that was done by Accountability Now. And so it's very much a piggyback situation. The proposed legislation has been tweaked, of course, to accommodate development since the Glenister judgment and other smaller issues, but largely it is the work of accountability now, and you should take the credit for that.
I will, in future, I'll make sure to refer to it as the private members' bills and not
Yeah.
not to
I would hate
any other
to
name.
think
Yeah.
that it was all my work when in fact it isn't. So it's largely the work of accountability now. I think we've seen, Mr. Hoffman, I'd just like your view on this. I think we've seen over the course of this ad hoc committee, the course of the Madlanga Commission, and just the general state of disrepair of the criminal justice system. I think everybody in this room is perfectly aware that we're in deep trouble. And there's a lot of opposition to an independent body outside of the National Prosecuting Authority, largely because people want to rely on the fact that the Constitution says that there's one prosecutorial body, and that would be the National Prosecuting Authority, words to that effect. However, constitutions can be changed, amended. This particular constitution has been amended more than 20 times. And so as things develop or fail to develop, one must be alive to the fact that, that amendments need to be made. And we need to develop institutions that answer to what we need now, not perhaps what was the position then. So I'd like your view on that. And then if you could just also, the statement made by the Honorable Sangoni about the IDAC being a carbon copy of the DSO is in fact, it's not a carbon copy of the DSO by any stretch of the imagination. The DSO was founded with a different intent. The DSO was founded to combat corruption, grand-scale corruption, and it did so with incredible success. One of the reasons for that was it had access to the best training in the world. It was able to attract the best people in the country because they believed that they had security of tenure. So they believed that they could do this job that was given to them. They could go after whomsoever involved themselves in corruption of any nature, and that as long as they acted within the confines of the law and without fear, favor, or prejudice, they would do their jobs and do them well. And they did that. Muscle memory is a strange thing. And even now, people who were around at the time of the disbanding of the DSO remember the absolute horror of being told that you are now unemployed because you did your job and did it too well. And IDAC is in that position. They have not had access to the best training. They don't have access to not unlimited funds. They don't even have access to adequate funds. And they have not been able to attract the very best people. And one of the reasons for that is not only money, is muscle memory. Who's going to go back to IDAC and do exactly the same thing again, go after the corrupt, the well-connected, when you know that the end of that story is you lose your job? So it's not a carbon copy in the fact that it doesn't have access to the funds and the abilities and the people and the skills that the DSO had. And there's nothing to prevent IDAC from being disbanded tomorrow by a simple majority in Parliament, 50% plus one. Thank you.
That's exactly what it has in common with the DSO. When I referred to the one as being carbon copy of the other, I'm talking about the legislative structure, a creature of an ordinary statute given a specific mandate in relation to corruption, housed within the NPA. They're both the same in defense of the Honorable Sangoni. They're both the same structure. I agree that the DSO enjoyed an esprit de corps which you will never see among those 187 people who work for IDAC. In fact, they worked as if they enjoyed operational independence, even though they actually didn't. And I think that myth or mystique carried them to great successes against very important crooked people. And it's the DSO that did the investigation of Jacob Zuma, of Jackie Salebi, of Tony Yengeni, all manner of very important political players who were brought low by the work of the DSO, even long after it had been disbanded. Well, we're still waiting for Jacob Zuma to get to trial. Whoever knows when that's going to happen. But the situation in relation to what is similar and what is different about the two is not one of structure. It's one of the way in which society viewed the two. IDAC is a neglected stepchild, whereas the DSO was the blue-eyed boy. That's the difference. I mean, you know, that I think is the way to deal with it. I also want to take you to paragraph 23 of the main submission that's been made by Accountability Now. In that, I refer to Potsani's case, which is authority for the proposition that the National Prosecuting Authority does not have sole rights to prosecutions. You have military courts, you have municipal courts, all manner of things that according to the Constitutional Court is allowable. So I don't think that it is necessarily a hindrance to the plan in the private members' bill, which sometimes bears your name.
Thank you. Yes, I agree with you on that, and yes, well, we'll keep pushing them. You know, perhaps the Justice Portfolio Committee will revisit them, and perhaps we can reach an agreement with the Department of Justice on how to accommodate their proposals and our proposals and get something concrete and positive structured. So we'll try.
I think that you should, because the alternative is to resort to litigation to enforce the Glenister judgment, and that will not be good for national unity. It will not be good for the ANC
and it will be time-consuming
for the country. Yeah,
it will be time-consuming, and time is something that we don't have as a luxury right now. We're busy being drowned in corruption. Then just one last question about NACAP. So what they're essentially, I don't know if you agree with me, what they're essentially trying to do is to pay lip service to Glenister while keeping the executive happy by giving them the kind of control that they have and want. And so it's a model that is doomed to leave us exactly where we are, drowning in corruption. Would you agree with that?
Yes, it's exactly this. It faces the same problems that IDAC face. IDAC is also an unconstitutional body because the law demands that a separate body outside executive control look after corruption in the country, and there is no such body. And creating a mini body within the NPA to do that, or in the OPI to do that with the president giving instructions on issuing proclamations on what can and can't be done by OPI is really a hybrid that won't fly. It will be a mule. It won't be a donkey or a horse.
I agree with that. Thank you, Mr. Hoffman. Mr. Tate, thank you for your presentation. I have no questions for you. Thank you.
Honorable Kola Barnett. Honorable Cameron.
Nothing from me, Chair.
Honorable Klopa.
Thank you, Chairperson, and thank you to Mr. Hoffman and Mr. Tate for your presentation and the time you took out to sit here and give insight, which is extremely valuable today to assist this committee. So we thank you. I was going to speak on the specifics of that security of tenure, but I was really covered adequately by Honourable Breitenbach, because I think it's an extremely important aspect to consider when we speak about this. And with the disbandment of the Scorpions, it was an absolute loss, but it was extremely well covered. So I won't get into it. A very important point that you raised, and I thank you for that, and it's just a comment, it was to include the SIU into the Office of Integrity and all of that, because I think that is what was on the table just recently in the Portfolio Committee, or at least the last time we sat. And it's opposite of what the Glenister judgment sought, and to have that body independent. And it will be valuable going forward in our internal discussions in the committee, as well as that as of the Justice Committee. So I just want to thank you again for that. I think what's important, Mr. Hoffman, is for the ordinary South African who might not always understand all these 21st Amendments and Chapter 9 institutions and so forth, you know, as well as in the next person. You emphasized, you know, to implement an anti-corruption body as in the private members bill. I would just like you, if you could explain in very simple terms, what would that mean and what would the immediate impact be for the ordinary South Africans? And, you know, how would they notice this change? And obviously it would lead to a change of confidence with the public into that of the institutions. If you could just give a plain explanation of that.
Yes, I think that the Parler-led executive branch of government will be deprived of its control of the levers of power in the anti-corruption machinery of the state, because that anti-corruption machinery will be answerable to this parliament and not to the executive, and that will redound to the benefit of the people of South Africa, in that the hesitancy of investment will be cured by that amendment, and that we can then look forward to peace, prosperity, and progress, which is not possible while the executive continues to hold the anti-corruption machinery of state under its thumb.
Mr. Hoffman, you spoke also, and I think it was in relation to this matter, about 50% of people that are facing poverty could be lifted out of poverty by implementing this anti-corruption commission. Is that what you were alluding to at that point?
Yes, I think that the country has the potential to grow at 4 or 5% a year conservatively. And at the moment, it's hovering around 1, maybe 1.5 if you're an optimist. And that's not enough, because our population is growing faster than that. So as a matter of sound economy, relieving South Africa of the millstone of dysfunctional anti-corruption machinery, showing the world that we are serious about anti-corruption work in South Africa, which will certainly be the case if a Chapter 9 anti-corruption commission is formed, will open the pockets of a lot of people who are keeping them closed at the moment, both in and outside the country, to invest in the future of South Africa without fear that a feral elite will rob them of their money.
I know some of my colleagues are very anti money from the West, but I mean, it does bring investments. And this is what you're alluding to now when you say that, you know, it's money within and without, and it will increase investments largely if we don't have this absolute rampant corruption that's currently in place.
Yes, I think it's inevitable that it's not only the West, I mean, all over the world, lots of spare money in China, India, and they are hesitant to invest in South Africa with their BRICS membership because there is this nervousness about recovering an investment in a country that is blighted by corruption to the extent and in the manner in which South Africa is so blighted.
Thank you very much, Mr. Hoffman, for your inputs. I only have one comment to Mr. Tate, just to acknowledge your presentation. It was spot on. You spoke about the executive appearing before the committees. I mean, we're 100% in agreement. And I agree, I think, because we do seem to have this weakened state where, you know, many members from all fields of political parties have complained that sometimes the questions that you ask, whether it be in the written format or that of the oral questioning, is not the version or a particular a problem that we are facing. And especially in our system that we speak now, I think it's really, really important. I also appreciate in your presentation, you spoke about merit-based appointments, and I couldn't agree more. And while I respect the terms of reference that this is a security and justice issues that we are facing, I think merit-based appointments should be standardized in all departments, because corruption didn't start and end in SAPS. It's through the band a problem, and it doesn't help we sort out one department just to see all the rest are facing the same because of that type of cadre deployment, and not merit-based appointments. Thank you very much for your cadre deployments and not merit-based appointments. Thank you very much for your time for both of you today. Thank you.
Advocate Hoffman, did I hear you use the phrase phala-led executive branch of government?
I was referring to the troubles of the president, and he is the head of state, and he is the leader of the cabinet.
Yeah, that's what I'm asking. Did you say phala-led
Yes, I did.
executive branch of government? Do you think that is appropriate? Then
Might have been better to say an executive headed by a president who has the parla baggage rather than the shorthand that I used. But I take your point, and I withdraw the parla-led statement unreservedly.
You know, when earlier on during the proceedings, I had to address Honorable Skosana to say, we are not here to impugn the bona fides of any one of us. We want to have a dignified conversations as South Africans. Whatever word that we use or any manner of address, must never be interpreted to mean humiliation or to belittle any South African, or even to be heard or understood to be showing disregard to the integrity of our government institutions. But I hear you when you say that you are withdrawing unreservedly. It was unfortunate that a statement like that one could be made in a forum like this one. You know, the President of the Republic is elected by members of Parliament. And I think the decorum of Parliament, or the honors to uphold the decorum of Parliament, must not only be left to members, but even the citizens have the duty to uphold that decorum. And in proceedings like this ones, but I understand what you have said, and that you are apologizing unreservedly. That statement is withdrawn, isn't it? Thank you. Honorable Sangwen.
Thank you for recognizing me, Chair, and thank you for that intervention. I did want to say throughout the proceedings, but respecting you, respecting this House, respecting the witness, I don't think it is correct that Advocate Hoffman comes here and he shows contempt for the African National Congress in particular, but government in general. He has said there during the course of the day, we kept quiet, where he sought to speak for the African National Congress. He has no idea of ANC policy. He gives his interpretation of ANC policy, tells us what the NDR is, tells us what cadre deployment is. But I did not want to come in, although I felt that he is misrepresenting us. And if this continues, Chair, then this meeting is going to degenerate, because we're going to have to keep calling points of order. So I request that Advocate Hoffman speaks to things that are within his factual knowledge and not try to impugn the African National Congress while trying to make his submissions. Thank you, Chair.
Okay. He has withdrawn, isn't it? I take the point that you are making, and I want to also persuade you to accept that he has withdrawn the statements that could be interpreted to impugn the integrity of government and its institutions, and also any other party that has a right to be respected. Thank you so much, both of you, Honorable Sangoni and Advocate Hoffman. It's only dialogue and understanding that can help us to move forward as a country. Honorable Vessels.
Thank you very much, Chairperson, and good afternoon. And let me also welcome the presentation and the input by Advocate Hoffman and Mr. Tate. It's very insightful, and it's a very important dialogue and discussion and debate that we should have. I do want to hear, especially from you, Advocate Hoffman, there's a variation theory that says that, or let me start there, separation of power is to a large extent, as we all know, not a fail-safe, it's not absolute. There's encroachment, and it's normal. We, members of the executive serve in the legislature. And so we can go on throughout all the three spheres of or the three arms. But there is an alternative theory that says that there can be a fourth arm where the National Prosecuting Authority and an anti-corruption commission, as you put it, can rather fall. than to say it reports directly to the legislature. Because of that encroachment of the legislature and the executive, and it not actually being a true separation, there is that theory that you can have accountability and integrity as a fourth arm, and that there can be the same type of fail-safes, although it's not absolute, that you have for the judiciary in terms of such a fourth branch, and that the Constitution can be amended as such. What's your view on such an alternative?
Yes, my take on this separation of powers issue is that since 1994, South Africa has actually had a system in which there are 4 seats of power. The judiciary, obviously, which just determines disputes that are brought to it. The legislature, which makes the laws. The executive branch, which runs the country. And the 4th one is the Chapter 9 institution. And I remind honorable members that the public protector has the power to make binding findings against those complained against who are brought to the office of the public protector, and that even in other Chapter 9 institutions, there's quite a lot of dilution of power of other institutions. The Human Rights Commission organizes commissions of inquiry and meetings in relation to what is going on in the executive branch, and has reports on it and so on. So I don't see a problem in relation to corruption with putting a body outside executive control into Chapter 9 and allowing it to function with a reporting line to the Justice Portfolio Committee instead of a reporting line to the Minister of Justice, because that's what that body will do. It will both investigate, prosecute, prevent, and combat corruption on all levels. It will get involved with crime intelligence and all manner of dark corners of the existing setup with a view to doing some spring cleaning.
But one of the points of opposition to that is that traditionally, investigation and prosecution is viewed as an administrative function, which falls under the executive. Our Constitution is to a large extent configured to put the National Prosecuting Authority in a hybrid position. It is under the executive, but it is also, as you put it, impartial, which does not mean it's independent. But the fact is that that is one of the criticisms of such a unit. Then the other point, which I would want your comment on, that's raised a lot, is that a Chapter 9 institution or Chapter 9 institutions are configured and positioned and mandated as an oversight body and not as an investigative body currently. That's one of the viewpoints, and I think it was raised a lot in Parliament when these discussions has been taking place. So I would want to hear your comment that it should not be a Chapter 9, because Chapter 9 is like the Human Rights Commission, the Public Protector, that is oversight bodies and not really investigative and prosecutive bodies.
Let's start with the prosecution in South Africa as it's at present configured. I'd like to suggest, and I've said so before, that the National Prosecuting Authority is neither fish nor fowl. It's sort of somewhere between administrative and something else, but what that something else might be, your guess is as good as mine. But if you were to create a Chapter 9 institution, and remember, these are institutions to support constitutional democracy and give it a mandate in relation to dealing with corruption, because that's what the court has asked it to do, then it can configure itself in a way that deals with all the problems of corruption, and they are many and varied, without being controlled by the executive and with a reporting line to Parliament, which, to my way of thinking, would solve the problem that we have at the moment, which is that too many people are corrupt with impunity in South Africa. Corruption is one thing, but corruption that enjoys impunity is a far bigger tiger in the jungle. And so I don't think that the 4 feet is necessarily completely watertight components or neatly packaged separately. I think it's very clear that Chapter 9, which is there to see to it, I think that the way that the founders of the new constitution were thinking was, look, the people of South Africa have lived under an authoritarian regime where they have been passive subjects. They have not actively participated in their governance of their country. And what we want to do in the new South Africa is to promote active citizenship. I don't know if you remember Mampela Rampele starting a thing called, what was it, the Active Citizen Movement or something, but their slogan was subject to citizen. So you went from active citizen, I can't remember, but if you took that to change the mindset of all South Africans away from being, there's the boss up there and I'm down here and what can I do, to being an active citizen who participates in the governance of the country, you will end up with a far better society than this top-down stuff.
Thank you very much. That's all from me. Thank you.
Honorable James.
You want to go, Honorable? Thank you so much. Thank you so much to Advocate Hoffman and Mr. Tate for the presentation. Appreciated. I want to agree with your observation that you made. You said something earlier on, and I agree with that. You spoke and you said corruption in this country goes unpunished and rewarded. As Action SA, we want to agree strongly with that observation of yours. You also mentioned that corruption in this country, it's something very difficult to detect. It's sort of unseen, you know, it's not tangible. That was your definition of corruption. I want to disagree with you there. Where we're at as a country and in our communities, we see, we feel corruption daily. We see SAPs taking money from the drug dealers. So maybe where you come from or whatever, you know, you're not exposed to the depth of corruption and how it impacts us on a community. And your presentation was very high level. It spoke to the policies, it spoke to the legislation, which we appreciate and we agree that we need to look at. But the reality is the ordinary South African, we see it, we feel it, and it goes unpunished and it goes rewarded. So I want to correct you on that statement that you made earlier on, that observation when you explained it. You also recommend yet, and my colleagues touched on this earlier, I'm not going to be long. You also recommend yet another Chapter 9 institution. Currently we have, you touched on it earlier on, the South African Human Rights Commission, established to do what? To act in the best interest of South Africans. To put South Africans first. As you jou nou kyk, waar is the Human Rights Commission with everything that's happening in this country? Chapter 9 institution, 224 million in funding. Whether underfunded, whether overfunded, 224 million in funding. 70% of that budget goes to what and to who? Goes for staff salaries. Where does that leave us as South Africans? These are the real issues that exist that we don't speak about. Like I said, I understand that your presentation is high level and it speaks to policies and you make many recommendations. The Human Rights Commission has failed. It's no longer for South Africans. It has lost its mandate somewhere along the way. We are suffering as it is. Mr. Tate, you mentioned earlier on that executive ministers, one of your recommendations was for the executive to come and table all the instructions and present to Parliament. Am I correct? Was that correct?
We suggested that there is a register that contains all the instructions made by executive to departments. And that is submitted through a committee that would run under the office of the Speaker.
I'm just failing to understand how would that work, especially in a department such as SAPS, because currently we are probing allegations where a minister went against his mandate and acted outside of his mandate by making an instruction, and everyone that came here and testified here said that a minister, it is not within his mandate to actually give instructions. So you are basically saying that it is within the mandate of these ministers to actually give instructions. Is that what you were saying?
No,
Just try to help me understand.
No, there are areas where the minister would be able to issue an instruction in terms of policy.
Okay.
There are areas in terms of operations where it is not appropriate for the minister to be able to issue an instruction. What this would do would give you a register of all those instructions, and Parliament would be forewarned and be able to take action and proactive action if necessary based on this. And the two competencies, both the executive and the operational command in the form of the National Commissioner, would be protected in a sense of having all of that interaction open and recorded for review.
Okay, thank you so much. I'm clear now. In the spirit of conversation, like the chairperson said, I think that we just also need to be clear that when we make those recommendations, we specifically align it to policy and not to operational issues matters. So I just like to highlight that. And then also you spoke earlier on, you've given us, both Advocate Hoffman and Mr. Tate has given us several recommendations that speaks to policy. I'm a little bit worried because when I look at what happens with a department, a body such as, maybe that's the incorrect word, as IPID. IPID is the watchdog, the teethless watchdog with no backbone over the police that does exactly what you were saying here, that makes recommendations, that has meetings, that sits for hours on end, makes recommendations when it comes to corruption. And guess what? We that sit in the police portfolio, none of those recommendations ever comes to light. So I ask, none of those recommendations comes to light. We do detect crime, but there's never ever consequences. Where we are sitting as a country and what would instill, and I always keep this in the forefront of my mind, that when we engage, we must always remember that the one thing that South Africans want right now, the purpose and the reason why we're here, is to restore public trust. Now, when the public hears about formation of these committees, when they hear about recommendations, and we've been there, we've done that, we have it on paper. It's been on paper, but it hasn't been implemented. What is it that we can do now? And I understand also we have a mammoth task at hand and it's very difficult. What is it? Is there anything that you can tell this committee that we can do right now to restore that public trust? Because the recommendations you make speaks to systemic failures, it speaks to reform. That's going to take us decades. Let's be honest. It's going to take us decades, and that's what we're not saying here. Wat doen ons nou met die frot that exists in the system? And I'm going to leave it at that. Thank you, Chair. If you do have a response for that, because like I said, we have a mammoth task at hand. Thank you.
Thank you, Honourable Member. I think it's each of the environments, there are things that can be done. And the first one that I'll point to is the SAPS Amendment Act. This is a bill that has been drafted and is now waiting a process to be initiated by Parliament for comment and submission. So we're right on the cusp of making significant and substantial changes to the way in which, to the legislation governing the South African Police Service. I think the outcomes of this ad hoc committee and the outcomes of the Mkhwanazi Commission of Inquiry, the outcomes of the Zondo Commission of Inquiry, I mean, I think there's an opportunity for members to scrutinize that bill and to start including responses that address some of those very concerns that you've raised. I think there are weaknesses in the IPID Act. We've engaged with it many times, and we would welcome reviews of that act coming back to Parliament. I think there's an opportunity for IPID to use its insight knowledge to make those proactive recommendations around how risks within the SAPS environment can be addressed. That proactive mandate has never been developed to the extent I think it should. There is challenges within the IPID response when it comes to administrative issues and recommendations around discipline, and the receptiveness of SAPS and the process around engaging with those administrative responses, stroke discipline responses. That environment can be strengthened. And there are a number of areas where I won't waste time now talking about it, but where we can make substantial difference to enhancing the effectiveness and performance of IPID. So each of the environments, whether it's prosecuting authority, whether it's IPID, whether it's SAPS, there are areas where we can start affecting real change. Thank you.
Honorable Sauls.
Sorry, may I respond to Honourable James?
Yeah.
Thank you, Chair. In relation to IPID, which is where the tackies and the tar get together, IPID is not sufficiently independent to be able to acquit itself of its anti-corruption mandate. There are lots of things that happen in the police that do require the attention of IPID, but the corruption aspect needs to be transferred to this body outside executive control, which is contemplated by the private members' bills currently pending, so that anti-corruption work is a one-stop shop in South Africa. It all goes to that, and it means that there's no opportunity for ducking and diving and muddying the water. There is a body that deals with all corruption of a serious nature that everybody answers to. That is what the judges were thinking about in that Glenister judgment when they understood that corruption has the potential to destroy the country if it is left unattended. And they came up with a formulation which they believe would address it, and it's something that has yet to be implemented at the political level. Thank you.
Honorable Sauls.
Thank you, Chair. Advocate Hoffman and Mr. Tate, good morning. Advocate Hoffman, is your submission that over the years, especially since 2009, that Parliament has intentionally failed in legislatively protecting our institutions against corruption?
I engaged with Parliament at the time that the Glenister 2 decision was the subject matter of debate in a, I think it was a joint committee that was formed to implement the Glenister judgment. And it was very clear to me, not only from the chair, but from the members of that committee, that they were having a great deal of difficulty getting their minds around the effect of the judgment on their work. The attitude that was taken by the chair of the committee was, we are going to work on what Parliament has sent us. We are not going to start again with something that is a little bit more true to what the Constitutional Court has required of us. They took the attitude that Parliament is led by the executive branch of government, which doesn't seem to be in favor anymore. We noticed the budget getting rejected by Parliament last year, and so we have a different mindset now to the mindset that was in place there. But there's been a great deal of difficulty understanding that Glenister 2 judgment. The main judgment, which is the first judgment you read when you get into the law reports, is that of the then Chief Justice, Sandile Nkomo. And he wrote it as if it was a majority judgment, but in the end it wasn't, because 5 of the judges hearing the matter agreed with the joint judgment of the Deputy Chief Justice Moseneke and Cameron. So there, towards the end of the main judgment, comes this joint judgment add-on. And even recently, when he was still Minister of Justice, the Honorable Lamola spoke at a conference at UCT on the basis that the Chief Justice's judgment set out what the law is, without regard to the fact that the joint judgment is in fact the majority judgment and is what binds. Now, I think there was a lot of confusion as to what goes for what in relation to implementation of Glenister. And one of the reasons why I'm here today is having twice attempted to persuade the Constitutional Review Committee to look at it. I'm now dealing with a very muscular Ad Hoc Committee, which is very much alive to what the issues are in relation to successfully. Yes, it's paragraph 24. Paragraph 24 of the main submission from the 29th of September gives you chapter and verse as to why IDAC is not a constitutionally compliant body.
You interpret the Glenister trilogy as requiring a single body to deal with both the investigation and the prosecution of corruption. I do note that you are not suggesting no accountability. Instead, you are proposing, based on a court judgment and not your own opinion, as we've established, a shift from accounting to the executive, rather to Parliament instead. So I get that. Now, how do you guard against the risk of creating a super agency that lacks its own internal checks and balances?
You do that by appointing the right people. And I'm not sure if you were in this meeting when I referred to the judgment of Justice Cameron in Glenister 3, in which he said how you go about. Look, it's not fail-safe, there are human beings involved. You know, anything can happen when human agency intervenes, but that is the way around the conundrum you pose.
Can you summarize that for us, Advocate?
Yeah.
Because I heard you mention it earlier, but how do you determine who's the right people?
Yeah, what you do is you subject those who wish to join this anti-corruption body to integrity testing, to lie detector tests, and obviously do a background check on all of them to make sure that they don't have skeletons in the SAP 69 cupboard or anything like that. They have a clean record, they have established integrity, and they pass a lie detector test. That way you get the best possible human material into this specialized body, which concentrates exclusively on dealing with, that's the verb that is used in the judgment, dealing with corruption. And the court said dealing with corruption, advisedly so, because it was seeking an all-embracive verb that would deal with prevention, combating, investigation, prosecution, the A to Z of anti-corruption work.
All right. You mentioned that in 2012, 20 out of 21 public submissions were critical of the Hawks legislation, yet Parliament passed it. Are you saying that the majority view of public submission should be considered the rubber stamp for implementation or non-implementation?
No, I don't say that at all. I was simply observing that civil society was not buying what the executive dished up to Parliament as the way forward on this judgment. And that I think...
But that suggests that you are implying that because of that, and that's why you're raising it, that the majority view of the public submission was questioning the bill, but yet Parliament went ahead despite.
No,
what should they have done?
Yeah, it's not a question of a majority or minority. What I'm saying is that most of the people who took the trouble to go to Parliament to talk about that process were not in favor of what Parliament did. But in its defense, Parliament did effect more than 50 amendments to the bill or the draft bill that was presented by, I think Kola Barnard's the only person here today the Honourable Kola Barnard's the only person here today who was in that committee. And she'll be able to give you a blow-by-blow account of what happened behind the scenes. Yeah.
Look, Advocate, someone like me who reads your submissions, when I read you say 20 out of 21 of the public submissions was critical of the Hawks legislation, yet Parliament passed it. To me, it sounds like you're saying that they shouldn't have, given that so many of the public submissions was that way. And now you're saying no. So that sounded like you are saying...
No, I'm not saying no. What I'm saying is that the public sentiment in relation to the bill that was presented to that committee is one of rejecting what the executive had suggested. And
but it doesn't mean that
I'm not saying that the 20 civil society organizations should have been allowed to take over from the committee and do the work of the legislature. But I am saying that in spite of concerted public opposition to the bill presented to Parliament by the legislature, by the executive branch then, we ended up with a very unsatisfactory situation, and the amended legislation was also struck down for its unconstitutionality.
Okay, but just to be clear, that there wasn't any breach of any legislative protocol in the passing of that bill.
I think that the majority of the members of the committee did not understand the judgment to mean what it clearly does mean, which it's not difficult to interpret a sentence in a judgment which is critical to the meaning of the judgment that says our law demands a body outside executive control to deal effectively with corruption.
This is
And
going to
that's
be,
there.
this is, sorry for interrupting, Advocate, but this is going to be my last attempt. You see, when you are an expert and you make expert contributions and you put it to us, just as an observation, that in 2012, 20 out of 21 of the public submissions was not in favor, basically, of the Hawks legislation, yet Parliament passed it. Immediately, you make me think, was there a problem with the process legislatively? Is it an issue? Because it was 20 from an expert, that should have served as a rubber stamp that they should have went the other way. I'm merely coming from that angle, but your expert submission is not, although there was no bridge of what's supposed to happen when a bill is passed, in your view, that should have been a very big red light. And for that reason, that's why we are where we are. Yes?
Yes, no, I agree that it is a red light and it remains a red light. And what has happened since 2012 in this country in relation to corruption shows that it's a bright red light that is still flashing very angrily, because the route that was taken by the majority in that debate was a wrong route, which has caused state capture, tenderpreneurism, all of the ills from which South Africa suffers, to the detriment of the welfare of the people.
I've got 3 more questions for you. On the STIRS criteria and whistleblower safety, you argue that a body must be secure in tenure to be STIRS compliant. Does your analysis suggest that the current lack of a Chapter 9 Anti-Corruption Commission or body creates a legislative gap that served as the reason why senior officials who blow the whistle on corruption are forced out of the system?
Yes, I'm on record to say that whistleblowers are the lifeblood of anti-corruption work. Without whistleblowers, you don't get off the ground in investigating and prosecuting corrupt activities. They are the people who can deal with the corruption best, because they've seen it happen. In relation to whistleblower protection, I understand that there is some legislation in the pipeline in this Parliament, and it's my prayer that this Parliament will pass legislation that is effective and that does not only protect but also rewards whistleblowers.
Advocate, you've confirmed that the bill currently pending in Parliament, although tabled by Honorable Breitenbach, was researched and drafted in its entirety by your organization. Does your presence here today as an independent expert witness not create a conflict of interest, given that you are effectively making submissions in support of your own work?
The way that we look at it at accountability now is that what the court asked Parliament to do was to make the reasonable decision of a reasonable decision maker in the circumstances. It may be true that I'm the grandfather of the bills that I call the Breitenbach bills and Breitenbach calls the private members bills, but the truth of the matter is that what we need to do in South Africa is come up with reform that addresses the failure properly to implement the decision in Glenister 2 that was confirmed in Glenister 3. Now, there are various ways of doing that. If you are getting to the reasonable decision of a reasonable decision maker in the circumstances, there's nothing in that that requires a Chapter 9 institution. But there is a requirement that a reasonable decision be taken. And that comes from the Rail Commuters Action Group versus Metro Rail trading as Transnet. And that in that decision, at paragraph 88, a unanimous constitutional court explained how you get to the reasonable decision of a reasonable decision maker. And it's referred to in Glenister as a footnote.
But do you see the conflict of interest?
No, I don't see a conflict of interest at all because the reason why we put the drafts on the table in 2021 is that in 2020, the National Executive Committee of the ANC, its highest decision-making body between conferences, I think I have that right, but if I haven't, I'll get into trouble. And it produced and published a resolution in which it called upon Cabinet, National Cabinet, to urgently implement what I've suggested needs to be done. It wanted a new anti-corruption body then and there. And after a year had gone by and nothing had happened, I realized that we needed to do something about it. So I produced the drafts, and the drafts have been enhanced and worked on by Breitenbach, who was not a fan of the ideas that we have been punting since 2012.
The advocate, sorry. The question is not directed at the weight of the bill or the need of the bill. It's not directed at that. It's directed at most of your submissions earlier when you submitted to us. You were basically lobbying for the bill. And for someone that doesn't really know you, I was interested to know why you're pushing so hard for the bill. And then when Honorable Breitenbach came to her session, she then clarified, it's not even hers, it's yours.
Yes, I don't see it as a conflict of interest, which is the question you're asking me, because it's never been a secret that it's our bill. It's been given to the president, it's been given to Parliament, it's been given to the NPA back in 2021, and somebody picked up the ball and ran with it eventually, and now we have two bills pending in this Parliament due to the seed that was planted in 2021. We're now in 2026.
You see, when you are perceived as lobbying here rather than providing expert contribution to what our work is dealing with, that becomes problematic. And I want you to see that. And if you can't, that's also okay. But I'll draw your attention to another example. You had members of the committee call you out on statements you've made that is specifically directed at a particular party, and you had to withdraw on the record. It now makes you be perceived as not being independent. You see, and so that's what I'm drawing your attention to.
Is your complaint about independence, or is it about a conflict of interest?
I'm not complaining.
Well, your question.
Yeah, my question is about conflict of interest. The bill that you have been lobbying for earlier, very expressly so, right, is actually stated on the record as yours. So even though you named it, or it is named the Breitenbach bill, but as you sitting there, you know it's yours. And for that reason, you kept on lobbying for it. No, and it comes across as that. So I'm saying your posture should be different to say that to ensure the integrity of this committee for future sessions, any witness in your position, I believe, should come forward and say, instead of saying I'm an independent expert, say I'm a project partner. And we'll know when you talk about it, we understand why you are emphatic. Then we will also understand why your views are, why you would say what you said about the president, because of your link. So we are clear about it, you see? And that's what I mean by conflict of interest.
Yes. Well, I don't feel conflicted. And I have to tell you that in the very first submission that we made on behalf of Accountability Now to this committee, we referred to the book Under the Swinging Arch, in which the history of the entire saga from the dissolution of the Scorpions to 2022 or 2023 is all set out there. It's not as though I'm coming here flying a false flag, and I really don't feel conflicted about speaking to Parliament about what I believe the correct reform initiative should be. Whether you accept that is another thing altogether.
No, I want you to say that I accept that. I accept the fact that we should have legislation, etc., like that. We should also have expert contributions from yourself. We should. But it shouldn't become a strategy that as we talk on issues like this, that you use that as an opportunity to lobby and then make statements that makes you to be perceived as not being independent. That's what I'm getting at.
Yeah, well, I feel perfectly independent, thank you.
Almost done. Mr. Tate, you don't have so many questions, don't worry. Your submission recommends that all ministerial instructions to the SEPs be recorded in writing and entered into a formal register. As a matter of practical governance, how would this register distinguish between a legitimate policy directive and an operational instruction that might improperly interfere with a live investigation? Please.
Thank you. So I think it should be read in conjunction with a more clear codification of what is appropriate instruction and what isn't appropriate instruction in the SAPS legislation. So we would have a list that would say, this is in the purview of the minister, and this is within the purview of, or not within the purview of the minister. The register would then record any instruction made by the minister to the National Commissioner. And it would be then subject to the scrutiny of Parliament if it was felt that anything was outside of the mandate of the minister or not. So simply every instruction would then be recorded, and it would be up for review by Parliament. You would have a record of that, and if there was anything that you wished as committee and Parliament to interrogate further, then you would be able to do so through the parliamentary processes.
Okay. You noted that the allegations made by Lieutenant General Mkhwanazi were previously submitted to the Portfolio Committee of Police without an immediate response, which you term a critical failure in parliamentary oversight. Beyond establishing more subcommittees, as you mentioned in your submission, what specific legislative teeth can we give Parliament to ensure that officials fighting corruption are protected, officials who are fighting corruption are protected rather than allegedly ignored when reporting political interference?
They would, in addition to the in addition to the register that we propose, that there would be opportunity for direct resort to Parliament by, in this instance, the National Commissioner or an operational commander under him, if he felt or she felt that there was undue political interference in an operational decision. So the legislation would provide for that recourse to Parliament, that there would be this register of recording all instruction, and that there would be clarity in terms of what is within the purview of the minister and what isn't, and that there would be a re-emphasis that instructions that are not appropriate in terms of coming from the minister would not have to be obeyed by the police officials, and so protect their tenure and position.
You recommend statutory protections against arbitrary dismissal or redeployment to insulate operational command. To what extent does the current SEPS Act fail to protect whistleblowing officials from being sidelined or cleansed, as the General puts it, under the guise of administrative reassignment?
Sorry, I won't, I don't have that information kind of readily available to be able to respond to you on that one.
All right. See, Advocate Hoffman and Mr. Tate, thank you very much. In my view, we've heard from both of you two compelling, but I would think incomplete visions today. On the one hand, accountability now rightly inserts on or insists on a Chapter 9 Holy Grail, an institution outside executive control. On the other hand, EPCOF provides us with a roadmap for internal discipline and record keeping within the SEPS. However, I must point out a shared shortcoming, in my view, in these approaches. Both proposals treat the whistleblower as a secondary consideration to the institution. If we follow accountability now's path, we are looking at years of constitutional amendments, whilst the saboteurs mentioned continue to white-end our current units now, risking the organization being viewed as accountability later. If we follow EPCOF's path, we are taking a whistleblower, we are asking a whistleblower to trust a register held by the very department they are exposing. Where I do agree with you both is that we have a legislative failure that has created a no man's land for officials like Babita and Mpofu-Walsh and others. Our current laws, specifically the Protected Disclosures Act, are designed for labor disputes and not for state capture. They offer a weak shield made of paper against a deadly bullet made of lead. I'm calling on this committee to bridge the gap between these two submissions. We cannot wait for a Chapter 9 body to be built before we protect whistleblowers currently in the trenches. We need immediate intervention. We need accountability now. We must stop debating the architecture of the building while the residents inside the building are being killed for trying to keep the house clean from corruption. If we as Parliament continues to fail in our duty to legislate specific high-level protections for those exposing executive interference, then we are not an oversight body. Then we are an accomplice to legislative silence. Advocate Hoffman and Mr. Tate, thank you very much for your time. Thank you, Chair.
Thank you so much. I'm looking at the way you use your time, honorable members. And if you use your time the way you use it, the problem is not the chairperson, the problem is yourselves. And when you become a problem, I allow you to run the whole day without a break or to run until the time you want to run. Do you still have the strength and energy to run forward? Can I call the next speaker? Let's take a let's take a break, honorable members. Now we'll come back, and this is how you decided to use your time. So you must wait until we come back from break. When we come back from break, we are going to take Honorable Mwango and Honorable Matthys, and then allow the advocates to interact. And then we will thereafter release Advocate Hoffman and Mr. Tate. We're not releasing you now. You must come back. It's now 3:15. All of you must be back here at 3:30.
You might not know, Chair. Maybe
No, you have eaten yourself. Those who have not had a break, may you please leave the chambers now and come back at 3:30. I will remain here listening to what Honorable Skhosana is saying.
Yeah, I'm saying Advocate Hoffman must come back because Batoi never came back. Thank you.
Mngango, it's now your time. Honorable Mngango, it is now your time. If Honorable Mngango is not having questions to ask, we are going to call Honorable Mathis. If Honorable Mngango does not have questions to ask, we are going to call Honorable Mathis. Honorable Mngango, your time has started. If Honorable Mngango does not have questions to ask, we are going to call Honorable Mathis.
Well, thank you, Honorable Chairperson. I'm sorry for not responding promptly to your calling. We were still busy out there. In lunch, obviously, I don't have a lot of questions because I joined the process at the tail end of it. However, I do want to express my appreciation to Advocate Hoffman and the team for actually making their submission. And also the recommendations which seem to actually have been well thought out, and surely they will enrich the final outcome of this process. However, I do want to get some clarity on the issue of your proposal for the establishment of a Chapter 9 institution to be called Anti-Corruption Commission. I'm doing so actually ledging on your statement, which you actually made, that Chapter 9 institutions actually have become, grounds for corruption. So I just want to understand how you will actually, how are you proposing to ensure that this one as well does not actually become another terrain for corrupt activities?
Thank you, Honourable Member. Chair, may I answer? The situation in relation to the new Chapter 9 institution, which is called the Anti-Corruption Commission in the draft bills presently pending before Parliament, is that the process that will be embarked upon in order to effect appointments in that new body will be tailor-made to ensure that the right people get the job. And you do that with integrity testing, you do it with lie detector tests, you do it with background checks and audits to make sure that everybody who is in the new organization is a straight shooter, not a corrupt individual who's coming there to white ant it. This isn't my own idea. It is based upon the judgment in Glenister 3, a minority judgment of Justice Cameron, who went into the appointment procedures. So the short answer to the question is follow Cameron J's judgment in Glenister 3, and you'll get to where you want to be with a squeaky clean new Chapter 9 institution.
Well, thank you. I'm actually, concerned because my concern actually arises from the fact that even currently we do have structures that are actually that were created to deal with precisely the issue of corruption. Your Hawks, your NPA, IDEC, IP, SIU, you name them. But they don't seem to be actually making the desired impact in terms of fighting corruption. What would you ascribe their failure to?
Well, the SIU is not really part of the criminal justice administration in any way, shape, or form. It's a specialist entity that acts to recover state or state-owned enterprise assets that have been the subject of maladministration, malfeasance, or corruption. So if money is taken out of the system that belongs to the state or the state-owned enterprises, the job of the SIU, Special Investigating Unit, is to recover that money. And they do it in the civil court of the special tribunal, and they've done a lot better than the rest of the bodies to which you refer in your question, mainly because they are housed within the presidency. They get paid salaries at a different scale to those that are paid to prosecutors and to investigators in the Hawks. And the SIU leadership has been able to cherry pick and select people who are in the criminal justice administration and are transferred out of the criminal justice administration to be employed in the SIU. As I see it, because the SIU is such a well-functioning body and compared to the others, it may well be wise and economical to base the rump of the new Chapter 9 institution on the assets, the buildings, and the staff of the SIU, which has offices around the country and which has people who are familiar with the territory from the point of view of raking back loot, rather than from the point of view of locking up corrupt operators. And you would then be able, by recruiting in the National Prosecuting Authority staff and in the police, and of course in the private sector and elsewhere as well, you'd be able to recruit enough staff to properly populate the new Chapter 9 institution, which could then get on with the business of confronting of dealing with corruption efficiently, which is what the court requires in its judgment.
General Mkhwanazi, advocate, actually make a very fundamental allegation that corruption actually is cutting across virtually on all criminal justice, system, quoting, that judges, magistrates, police, whoever is involved in the criminal justice system. And in your observation and also your recommendations, you are actually proposing a phased approach to dealing with this situation. Most of your recommendations actually are looking at medium to long-term solutions. But my concern is that corruption is endemic now. It has to be stopped. Something has to be done now. And I'm worried, I wonder what would you actually propose as something that needs to be done now to actually do something to dent corruption activities now.
I must give you the science on this because it's actually very interesting. In any given large population, 10% of the people are always corrupt, no matter how well the system functions. 10% of the people are like you and me, they're never corrupt. And the other 80%, in other words, the vast majority of that population, can go either way, depending on the circumstances. And the one circumstance that has a greater effect on the incidence of corruption than any other is the deterrent effect of efficient prosecution of the corrupt. So I would suggest that in South Africa, we can solve the short-term problem by capacitating the Criminal Justice Administration to have some successful anti-corruption prosecutions and sound a warning to those who are toying with corruption, because the effect of corruption with impunity is that more and more people become attracted to it because they see other people in their office or wherever getting away with it. The impunity it's not the corruption that's the problem, it's the corruption with impunity that is the problem. And if you address the impunity by cracking down on corrupt activities, you will find that they become less popular because people are not getting away with it anymore. But that's plaster on the current problem. The true solution is to have a long-term anti-corruption commission, a body outside executive control that is able to do what the court requires in relation to effectively dealing with corruption.
Well, thanks, Advocate. You are actually, in your recommendations, you're actually focusing more on what the government and parliament could do to intervene, and very little, if any, on the bigger South African society. What would you propose would be the role of the bigger South African society in actually fighting this scourge, rather than actually leaving it out, leaving it into the hands of the government and parliament only? Because if you look at these corrupt activities, they are actually located in a fringe of people within our society. The bigger South African society is actually not corrupt. They are poor. People who are actually indulging in these corrupt activities are people who actually should not be doing that because they're well off in any case. But now, what would be the role of the civil society in actually dealing and fighting, contributing in actually fighting this crime?
Thank you, Honourable Member. The role of civil society is certainly a big one, but it cannot be an active role until such time as those in positions of authority, by which I mean Parliament and the Executive, are in a position to create the climate in which the impunity of the corrupt is addressed. People will call out the corrupt when they feel there'll be consequences, but they won't if they feel that the corrupt are protected by those in positions of power and authority. That's the inwardness of deterrence. There must be consequences for corrupt action if you are going to make any inroads on its occurrence.
My last question actually has to do with your proposal on merit-driven appointment and promotions within the SAPS ranks. And I cannot agree with you more on that particular one, because we have had.
I think you're mixing up my.
Oh, that's
No,
sorry.
no,
That's I'm sorry to actually take away your point. I honestly agree with you on that one. We've had an opportunity to interact with some of the generals here, and some of them, you could see that they can't even say "ha" to a duck, and but they are actually responsible for critical interventions in our crime situation. So I was wondering how you could actually advise on this particular point. What is it that needs to actually be done to actually ensure that indeed appointments and promotions are actually based on merit and nothing else, no political interference and nothing else but merit.
I'll just make a very brief point, Honourable Member, and that's to say in the 2025 SAPS Amendment Bill, there is a provision proposed for a Police Advisory Council, which is a body that would be comprised of experts from outside and inside the police that will be mandated to be able to develop standards, criteria around recruitment, criteria around promotion. And I think that that is a very important starting point to identify exactly what it is you're looking for in terms of promotion. And then there are other facilities that I think have been the subject of ongoing discussion within the Portfolio Committee on Police. Two-track career pathing for detectives and police officers, looking at the way in which promotions are provided for, that it's not a, here are the list of possible promotions and you can apply for something anywhere in order to move up the ranks, but that there's far more discernment in terms of what would be, who would be eligible for application for any of those promotions. Thank you, sir.
Thank you, Honourable Chairperson.
Thank you so much. The last will be Honourable Matthys.
Thank you, Chair, and thank you, Accountability Now, for your presentation. Apologize that I missed some of it. So my questions, I did go through it, though, the written submission, but the questions are mainly around what I've heard through the engagement with honourable members. So you mentioned that there are many. Let's talk about investors, right? You said that South Africa is not attracting investors because of the corruption, and investors tend to not want to invest because they're not going to get value for their money. What research has been done in that regard? So is there anything that you have, that there's research that has been done on investors that have invested in South Africa, in the state that it's in now, and have not gotten return on their investment?
Yes, there is a great deal of writing about this in the financial press. And I think the investors are not all the same. Some investors are more risk averse than others. So cautious investors like to invest in small returns that are safe, whereas brave investors like to invest where the return may be greater or may result in a loss. It's almost like human nature. It's a question of you are now looking at where you are going to place some money if you're an investment house, wherever in the world, anywhere from China to Canada. And what you do is you assess the position of the country that you are wanting to invest in from a risk point of view. So if the country is very low on the Transparency Now, what is it? Transparency International list of countries, you regard it as a high risk. If it's high, it's a low risk. And you have regard to the conditions on the ground in the country. What is its legal system doing to address questions of corruption?
Okay.
And there's stuff on our website about it if you want to.
Oh, no, I just thought that you would explain it to South Africans on any specific research. So I mean, we understand risk analysis that are done, but I think there could be argued quite soundly that there's no one that has ever invested in South Africa that has lost out on investments well, I wouldn't say never, but South Africa is ripe for investments. The people that are struggling in this country are people on the ground. Investors get off scot-free. But I do understand, and we do understand and appreciate the risk analysis that is involved in there. But we are, yeah. Let's talk about the Chapter 9 institution, or you were saying that we need a corruption body or anti-corruption body. Yeah, how do you envision this working that is outside of whose control? Because we have we have a democracy in this country. We have the South Africans who vote for who must control the country or who must control government. So when you say it must be outside of the control, who are you proposing it must be outside of whose control?
I'm not proposing that. What I'm doing is I'm relying on a judgment of our highest court, which says in so many words, our law demands a body outside executive control to deal effectively with corruption. That's a binding decision of the highest court in the land. It's not a take it or leave it.
So you've answered the question outside of executive control. That was what my question. So who appoints the body?
It will be appointed via the parliament of the country on the basis of selection criteria that will be written into the legislation that relates to its formation.
So ultimately, what's being proposed is that it is controlled. It's going to be controlled by Parliament, right? Because Parliament is about numbers, right? So whoever that body is going to be appointed, it's going to be controlled by numbers.
Well,
but you're saying that it must be outside of executive control in the way that it's not appointed by the president of the country and it's done by Parliament.
And it will have a situation in which it has to, it's not unaccountable. It has to account to Parliament for its activities in the same way as all the other Chapter 9 institutions account to Parliament for their activities.
And the same ones that have been pretty much ineffective, because if you look at it, we've got, even if we change legislation, and part of my questions is also getting back to the recommendations of bills that are before the House. Our problem is not legislation, I would argue that, because if even just the current legislation, even if it's just implemented at like 40%, we wouldn't be sitting here and you wouldn't even have an NGO to run.
That would be so nice.
But so I'm talking about the whole issue that comes down to legislation, changing the legislation, Parliament being a body. We've got Chapter 9 institutions, they also come here and they answer to Parliament. We've got the Public Protector, there's the Human Rights Commission, which we know how that goes. There's the Commission for Gender Equality. There's all these bodies that dealing with corruption in various forms throughout our state or government departments. So we can have another one that is going to be answerable to Parliament. Why would that one be any different to how any of these other NGOs? Because Parliament is about numbers. You just lobby. So how is this? How do you envision this one being different to any of these other entities?
The parliamentary committee to which the Anti-Corruption Commission will report will obviously be the Justice Portfolio Committee, a multi-party body, which most, if not all of the bigger parties represented in Parliament are represented. And that reporting line is a far better way to keep the institution honest than a reporting line to a single minister in the Department of Justice. That In other words, there are checks and balances within the committee system of Parliament, which is not something that is available to either the NPA or the Hawks at this stage. The Hawks are under the thumb of the minister, and the NPA as part, well, the Hawks are, the prosecution service is under the final control of the Minister of Justice. That's the difficulty that we've got, because the NPA is neither part of the executive nor part of the administration. It's a sort of neither fish nor fowl, the way that they have structured it in the Constitution. And that being so, the need to get the executive out of the loop in relation to corruption was perceived by the court as being the way out of the woods when it comes to ongoing corruption with impunity. They looked at the evidence that was placed before them. This is now after the Scorpions were closed down, and they said, look, we've got to take this function, which at that stage was investigate in the police and prosecute in the National Prosecuting Authority. And they said, no, we want another body to deal with corruption across the board, everything. So it's a one-stop shop, which we haven't ever had in South Africa. And there can't be any buck passing if you're in a one-stop shop. So that is the that is the binding decision of our highest court. It's not a take it or leave it. It's what needs to be done. And but yeah, the sooner it's done, the better, as far as I'm concerned.
So the question was more, so you've gone in again and explained how it's going to function or how it's envisioned. But currently we have entities that operate similarly to that, maybe not in the criminal justice system, but we do. Have you looked at the models that we currently have of the CGEs, of the ICASs, of the Human Rights Commission, that all the interviews are done here in Parliament, the appointments are done here in Parliament, and how they are operating, to be able to see where the gaps are and which ones are operating highly functionally, that we could be. So the issue is not that we should not have it, is it going to actually help fix the issue of corruption? Because the problem might be institutionalized right here in Parliament.
I think by creating an anti-corruption commission, you will bring a great deal of focus onto the downside of corruption. Corruption has the capacity to eviscerate a country. If you allow corruption with impunity, which is what is happening at the moment in South Africa.
But I don't think you're answering my question. I think we're going back and we're saying the same thing. I'm saying we're not disputing that at all, that we need that. I'm saying, has your organization done any research or done any analysis on how Parliament functions now in terms of the model that you've recommended with other entities, and have seen the gaps on how this anti-corruption commission is going to function?
Yes,
because we're just going to add another thing and spend more money, and we're going to end with the same results.
No, I'm impressed with the 7th Parliament. The other 6, not so much. And the 7th Parliament is the first Parliament that rejected a budget presented by the executive branch of government. And that, to me, was a salutary moment in the history of South Africa, because it showed that Parliament, instead of acting as the rubber stamp of the executive branch of government, actually applied its mind to the draft budget that was presented, or to the work that it needed to do. And it did its work properly, and we were given a budget that was the product of parliamentary intervention in the process that has hitherto, because of the numbers, as you say, it is a numbers game in the 6th and 5th and 4th and 3rd parliaments, just was a question of, well, the minister says so, we must do it. And that feature is a feature that will definitely come into play when an anti-corruption body is required to report to Parliament about what it's been doing. That is why I foresee a brighter future when Parliament is empowered to take charge of the anti-corruption machinery of state as the body to whom that anti-corruption machinery reports.
Okay, so in summary, we just need to have a parliament where we don't have a 2/3 majority.
That's not going to happen for some time, as far as I can see.
So we need to have the government of national unity vibes to be able to have better oversight. I'm taking from the input that you've just
No,
given.
I know you're
So,
joking with me, but the truth is, well, you may be joking with your colleague from the ANC, but the truth is that in my submission, all of the parties in Parliament ought to be supportive of an anti-corruption commission that reports to Parliament rather than to the executive.
Okay,
Because it puts Parliament
we are
in
not
a stronger
disputing
position.
that, and you keep coming back and you're making it sound like we are not in support of that. The issue here that I'm asking or that we are raising is that how effective is it going to be, because we have similar entities dealing with similar problems, not necessarily in the criminal justice system, and they are extremely ineffective. So, but we can move on from there. But I just want to make it clear that there's it should not happen. It is, are we going to waste our time? You answered the question that you have more faith in the 7th Parliament, maybe the 8th Parliament will be better when we'll have parties reduced to like 20% and that. I just want to talk about NGOs and civil society in general, because it's a hot subject now, especially with this Paul O'Sullivan running around the world with these NGOs and has infiltrated particularly our criminal justice system. Do you think the civil society is properly monitored here in South Africa? Firstly, answer the question on can civil societies, these NGOs, pose a national threat to our country?
I don't see that at the moment. I don't see a lot of foreign money coming in and messing things up or anything like that.
The question is that do NGOs, not just here in our country, but internationally, pose a threat to any country?
Yeah, well, certainly not to South Africa.
Why
I
do
haven't
you
looked at
think
the other
that?
countries, but South Africa is not threatened by NGOs. It's supported by NGOs.
Based on?
Based on what NGOs do. I've spent the whole day here today trying to persuade this committee.
What you do, but we don't know what you are doing behind the scenes. So is there any, and that's your NGO, there's a lot of NGOs that are
Yes, yeah.
registered here in the country. Okay, we'll move on from there. So having said that, since you're saying that South Africa has no threat because civil society in our country has not been weaponized for anything, and this is just based on you sitting here the whole day and presenting, and maybe the other NGOs as well. So in other words, there's no research, or you don't have any research to support that. Has there been any research on the impact of civil societies in South Africa? Do you know? Or any assessments or anything?
ISS might be able to help you.
And then my last and final question will be, are you apolitical? Is your organization apolitical?
Yes, I've never been a member of any political party at any time.
So how did the DA end up with your...
They can read and write, and they saw it and liked it.
And
they
then
didn't like it at first, I must say, but eventually they...
So you said what? The DA can read and write?
No, they can read and write. That's what I said.
Yeah.
What happened was this. In 2020...
I want you to say that again. The DA can read and write?
Yes, yeah. In other words, they looked at what we were proposing.
Did you approach any other parties?
No, I didn't approach the DA
Okay,
either.
I think we're done. Thank you.
Yeah.
Advocate RNC.
Thank you, Honorable Chair, honorable members. Perhaps, Mr. Tate, can I ask you first? Because I've got a few more questions for Mr. Hoffman, Advocate Hoffman. In terms of the separation of powers and parliamentary oversight, you indicate that the current rules of Parliament need to be strengthened. Alternatively, that it's not sufficiently what's the word I'm looking for? Not strong enough, but sufficient or not adequate in order to hold people to account. And the reason for this question relates to some of the work that we've had to do as evidence leaders and in our consultations with various witnesses. For example, General Mkhwanazi, who had been here to Parliament as recently as the 6th of March, which is just a few months before the 6th of July, when he appeared before the country and said, look, this is a last resort, this is a show of force, and seemed to say that something needs to be done about what's happening in our country, otherwise we're going to do something about it. Now, what is really concerning is that when one looks at reports presented to SCOPA, presented to, in the case of the police, the Portfolio Committee, where what General Mkhwanazi was telling the country on the 6th of July has been made evident for quite some time. Some of the reports that we come up with are dated 2014, 2015, 2017, and it's all there. And the problem seems to be that there's been no follow-up, no recalling of important senior management people to come and account to either SCOPA or the relevant committee. So that seems to be the problem. Is it a problem of the rules, or is it the issue of political will, or is it that some members of Parliament sitting on various committees are just not prepared to follow through for whatever reasons they may have? Sorry for the long-winded question/statement, but your comment would be welcomed.
Advocate Arendse, it's a very difficult question to answer. I think if there was a stronger system in place that would allow for an easier scrutiny of the instruction from the executive through to the operational head, in this instance of SAPS, and it allowed for that scrutiny almost as a routine in terms of the work of Parliament, it might alleviate some of the pressure for potentially discretionary political decision-making on whether to actually engage with it or not. There is always the risk of it's a political animal, of a political coloring to how and when and where you respond. But I think if this was routine and open and was simply provided, it would allow for a more administrative engagement with, is it appropriate, isn't appropriate, do we want to ask a question, don't we want to ask a question? And then I think the issue of recommendation and follow-up is it's critical to the power of Parliament. We get recommendations through committee, we get questions, we get written questions, oral questions, and we need to be able to keep a track of what, when, and how the the executive or the relevant minister has responded, or the operational head of the department has responded. And be able to then demonstrate that where there is an issue that Parliament thinks requires further scrutiny, there is a trail that has put it into process. And this would assist both in managing what are numerous recommendations and responses in any given year, but would also help insulate Parliament from accusations that it hasn't applied its mind, that things haven't gone forward, that they've been ignored. So it's in that context we think that those two environments could potentially be strengthened.
Is that the reason why you propose some kind of a register to keep track of these recommendations and whether they've been implemented and there's follow-up or follow-through? And also, I think you spoke about a subcommittee of a particular committee. Would this be a subcommittee of all the committees, or a subcommittee, say, for police? Would it be more of a monitoring committee to ensure that that there's follow through and what's colloquially called sort of consequence management?
Yes, sir. I think in the environment of the response, or the environment of instruction by the executive to the operational head, we've made a recommendation that these be in writing. And so the register is simply recording all of those in writing instructions and to be available for scrutiny by the committee. The subcommittee, or kind of consistent engagement, is to recognize that this is a politically contested area, that there are obviously huge political, as we've seen now, consequences to how and what and the response to that. And so that in terms of Parliament diligently exercising its function around the role of the executive vis-a-vis the role of the operational or departmental head, and assuring itself that these are maintained within the respective mandates, that this is a routine activity that is done by Parliament. I have no idea how many of these instructions would possibly be issued in a year, but that would inform how often a subcommittee of the committee could actually come together and review those. In terms of the recommendations, I think, and we argue that this can be located within the office of the Speaker, so that it carries that parliamentary weight in terms of recommendation, response, distribution of those responses, sanction if there is no response.
Now, I take it there's nothing in the rules of Parliament that precludes Parliament itself or any of its committees calling for a public hearing and asking for accountability by whichever department or ministry in relation to a matter of public interest.
No. To my knowledge, Parliament, that is part of the role of Parliament in terms of its oversight functions.
I asked that because I know perhaps one wouldn't agree politically, but one of the striking features of, say, the House of Commons or Congress, United States Congress, is that it seems to be the case that whenever there's a major issue of public interest, almost like, and I know it's not quite the case, but it's almost like the next day or the next week, there's, people responsible are called to account and they must appear before the committee. And there's quite a robust exchange and debate. There have been instances here, but not too many. I think now of, say, especially this time of the year, the road accidents involving the death of pupils, in transport. And I think most of us know mostly what the issues and the problems are. Just holding people to account.
Yeah. No, I would think that Parliament has been quite active in doing that. There's regular scrutiny, and certainly where the issues are of significant public interest, they have generated response to that. And I've been quite impressed by Parliament not ignoring those issues, but picking it up. I think those inquiries generate a wealth of information. As we've seen with this conversation, how many suggestions, how many recommendations, issues have been raised by everyone contributing to the discussion. It's how do you keep track of that? How do you put that back onto the agenda of the department, and how do you get them to respond to it timeously? And this is where I think those systems can certainly be strengthened within the parliamentary system, whether it by technology, whether it by additional resources, whether there's a specific facility that can help build up that capacity.
Thank you. Thank you. Advocate Hoffman. Okay, can I just try and summarize your submission? You might be surprised that I'm trying to summarize this in one paragraph or sentence. But what your submission comes down to is that we need to fight the big scourge in our society is corruption. We need to set up an independent anti-corruption body with investigative and prosecutorial powers along the lines that Judge Cameron in his minority judgment had stipulated in the Glenister. That's in the first place. Secondly, that corruption should not be the business of IPID. They should focus on sort of non-corruption issues involving SAP's misconduct. And that thirdly, the directorate, or rather IDAC, there's then no need for IDAC to continue in its current form. Is that in summary? And then this related to this, is it your opinion, or are you saying that Parliament is in contempt of a constitutional court judgment, a binding constitutional court judgment?
To be in contempt, you need a degree of intention, and I don't think that can be laid at the door of the 7th Parliament when it was a couple of parliaments ago that the judgment was under consideration. The judgment that was under consideration by this Parliament was the majority judgment in Glenister 2. The Cameron judgment to which you referred in your summary was a minority judgment in Glenister 3 that dealt with appointment mechanisms. It's not, I'm not here to bang the drum for the Constitutional Court in anything other than its decision in Glenister 2, which was confirmed in the first 2 paragraphs of Glenister 3. That is a decision that our law demands an anti-corruption body, a body outside executive control, not independent necessarily, but outside executive control, to deal with, which is a very wide verb, corruption in South Africa. And what I'm saying is that the law requires Parliament to get on with the business of creating that body, because that is what the law, that is how the law has been spelt out and changed in Glenister too. The whole idea of a multidisciplinary, multi-agency approach to corruption is gone. You've got to do it through one body, which is why I submit that IPID should not have a corruption function at all. That is what it's about. IDAC is a stopgap measure in the words of the Deputy Minister, and it was there to fill up the hole between the old way of doing things and what hopefully will occur when the bills propelled as private members' bills by the Honourable Breitenbach get debated and accepted by the necessary 2/3 majority in this Parliament quite soon.
And so how would this independent anti-corruption body differ from the role the Scorpions played? Because you must correct me if I'm wrong, Scorpions too was still headed by a National Director of Public Prosecutions appointed by the President. What were the features manifested by the Scorpions which were different to what we have today? So was it because there was a different culture at the time? Is it just that it was run differently by people who were committed to root out corruption? How was it different to what we have today?
Yes, I think that it is so that the Scorpions had an esprit de corps, a sense of mission. They called themselves the people's advocates, and they got on with the job in a muscular way, and they weren't frightened to go after the big fish in the pond in which they were fishing. The IDAC, on the other hand, although it is structurally the same as the Scorpions were, it's a unit within the National Prosecuting Authority that is tasked with investigating and prosecuting corruption. They really were quite tiny and not empowered to deal with the levels of corruption with impunity that we are experiencing in South Africa at the moment. What I'm asking for in this committee is that it respects and implements the decision in Glenister 2 that a body outside of executive control be created in order to implement the finding in paragraph 200 of that judgment.
So it's not a matter of bring back the Scorpions?
No, the Scorpions were easily closed down because they were a creature of an ordinary statute, which was the NPA Amendment Act, and they could be closed down by a simple majority in Parliament, and that's in fact what happened to them. When they were given their death sentence at Polokwane, it followed that they were
the corruption that we experience in our country and that's manifest and that's costing us trillions. It takes many forms. And I mean, we've seen during the course of these hearings, they manifest especially in system of procurement. People are placed on bid, you know how it works, bid evaluation committees, goes to bid adjudication committees. Then the head of department signs at the end and purports to say, you know, it's not me. This came through to me and I simply signed it. I work on the basis that they'll, in the meantime, it started right at the beginning. Now, this anti-corruption body, what I'm trying to get to is that it's going to have a massive, massive task. If you look at that kind of corruption that takes place across the public service, and especially in our parastatals, where there's huge amounts of money.
Yes, that's why
And
I'm suggesting that the
what I want
SIU
to
should
ask
be
about-
folded into it, yeah.
Yes, it might be a starting point for the SIU to, and for those who employed there to sort of step into the breach and form part of this body. But I think you know that the SIU's job, its function, its work is very different. I think the privilege of having done quite a few SIU matters and still on brief in some of them. And they bring you lots and lots of files with all the work that they've done very efficiently, very professionally. And you go to the special tribunal, you freeze the assets, and eventually the respondent parties will try and review the work of the SIU, and the special tribunal makes a ruling. And then a lot of money is recouped for the state. But it's not like a criminal conviction. And that's, of course, the big difference.
Well, it is a big difference because in the special tribunal, as you know, the standard of proof is on a balance of probabilities. Whereas if you are seeking to secure a conviction for corruption, you have to be able to prove your case beyond a reasonable doubt. But if you regularly, successfully freeze, seize, and forfeit assets through the special tribunal procedures, then it is a major disincentive to those who are involved in corruption because there's nothing in it for them. They are, the reason why they corrupt is because they want to get rich quick. The get rich quick doesn't look so good when the SIU knocks on your door, takes away the fancy motor cars and seizes your immovable property with a view to enforcing a judgment against you in due course. And it's a judgment on a balance of probabilities, not a conviction in a criminal
But
court.
we've also had the asset forfeiture unit doing the same.
They do the same thing and
but also housed in the NPA.
Yeah.
Now, I just want to ask, Ben, is it really a fair or valid comparison to compare what the SIU has done compared to the criticisms of the NPA not putting enough people in orange overalls behind bars who are corrupt?
You know, it's an unfair comparison because the SIU is working to a standard of proof that is far lower than the standard of proof required, and as it should be, to put people into orange overalls. You have to prove it beyond a reasonable doubt. You have to be sure that you've got the right accused in the dock in a criminal trial. So I have no difficulty with those. What concerns me is that there is a tendency to sort of look away from what the court required in Glenister 2, which is this body outside, a single body outside executive control that is there to deal with all aspects of corruption, A to Z. Having a whole lot of corruption bodies is just an opportunity. This multidisciplinary or multi-agency approach that we suffer from at the moment is just a way of diverting the efforts into different directions and of giving the corrupt an opportunity to find ways around the proper implementation of anti-corruption law.
So this anti-corruption body, it doesn't or wouldn't replace the NPA. NPA would still be dealing with, as it were,
all other crime.
All other, not involving corruption.
I must add on this, while it is so that the envisaged body is called the Anti-Corruption Commission, it is not only designed to deal with corruption, but also with organized crime, which means big crime. And that addition to the draft, to the bills, is there because organized crime usually involves corruption anyway, and targeting organized crime as well as corruption is what the new body will do.
And what happens with your hawks? The DPCI?
The DPCI has got quite a wide...
Dealing with priority crimes and
all
clearly...
sorts of priority, things like wildlife management, illicit diamond buying, all sorts of stuff that's got really nothing to do with corruption per se. And they're actually quite good at doing their work when it's not involving corruption, especially corruption in which well-placed, politically connected people are involved. So I would see the Hawks continuing with a more limited mandate. Their corruption mandate must be taken away from them. It in effect has been taken away from them already because IDAC is doing the anti-corruption work, which the Hawks initially were designated to do.
You haven't commented, but I assume that you would also be in agreement that we do need to look at the appointment procedures.
In the new body, yes.
Yes.
Yes, that's that Cameron judgment in Glenister 3. That's the...
But also more generally, like, for example, you know, the appointment of the National Commissioner by the President, then the National Commissioner appoints his divisional commissioners.
I think a lot of revision could
then
well help there.
Then the Minister appoints the head of the Hawks.
Yeah.
So you have those kinds of what appear to be anomalies and gives rise to a recipe for conflict.
Yes, that's why Robert McBride fell out with Lt Gen Mkhwanazi.
And I think it's either Mr. Tate or in one of the other submissions, there's reference to the establishment of an independent national police board.
I haven't seen that now. I don't think it was in his. Certainly, he didn't say anything about it today.
Thank you, thank you, Honourable Chair, Honourable members. Thank you.
Thank you so much, Advocate Rahman and Mr. Tate. We have come to the end of our interactions, and we want to thank you so much for the substantive recommendations that you are making, which will serve as a form of intervention to the difficulties that we are going through in our criminal justice system. And I believe that you have heard or carefully listened to some of the questions that honorable members have posed here. And some of them you might not have responded to them adequately. What you can do, you can go back and revise your submission. And if you, for instance, you want to give a practical exposition of how some of the recommendations can be implemented.
Yes, certainly, Chair. We can do that. Thank you.
When we will be discussing the recommendations, you may not be there in that meeting to speak for yourself. And if you can please help us where you think you need to add more flesh, you are allowed. You can gladly do so and resubmit.
When does the term of the...
we are not giving you a chance to make a submission. You have made a submission before the 31st of October last year. So
Yeah. My
yeah.
question is, for how long is this committee lasting? By when should I add to
We are
what I've said?
planning to end hearings by the 6th of February.
Oh, my goodness.
Yeah,
That
so-
might be difficult, okay.
Yeah. So in case there is anything that you may want to bring to our attention, which can enrich our insights, you are at liberty to do so. Yeah.
Thank you, Chair. It's been an honor and a privilege to be here today. And I must ask to be excused because my ridgebacks have not had any exercise and they cooped up at home all day.
Yeah. Yeah. Honorable Skosana.
Watching you.
Thank you, Chair. I just wanted, before he leaves, the issue of tender premier, I wanted a clarity on that because in my view, when you say a tender premier, because law firms, engineers.
Honorable member, we are not going to allow.
No, Chair, listen to me first.
No.
Because he says tender premier in his presentation here. I don't understand unless you know it better than how
That's
I know it.
exactly what I'm saying, that
Yes.
look, you have been given a chance.
No, it's a clarity. Yeah, but it's a clarity.
No, Honorable Skosana. Today, you have taken more time than any other. You have taken the whole hour. Yes. And we have given you sufficient time to ask clarity-seeking questions and make comments. Yeah, so thank you so much for understanding the order. Gentlemen, you are released.
Thank you, Chair. Thank you for your patience. And I was coming here this morning expecting to be out within an hour. And it is now almost 5 hours later.
Yeah. No, thank you so much. Mr. David Bruce. Good afternoon.
Good afternoon, Chairperson. Should I just go ahead? Would you like me to?
And welcome.
Thank you very much.
You are not a witness here. You are our guest. And the procedure that we normally go through of having to administer oath, we will not follow it because there are not going to be any allegations you are going to make in this proceedings. You will be presenting your own observations on the criminal justice system in the country and maybe experiences that you may want to share with us and recommendations. I'm looking at the time now. It's about 20 minutes to 5. You are not going to have 1 hour with us. You are going to have more than an hour. So if you can give us an executive summary of the presentation and the rest of the issues which may need to be clarified, you will clarify them during the interface with the members. Is that correct?
Yes, that's perfectly fine.
Yeah, I think you.
So if I speak for about 20 or 25 minutes, is that more than you want from me, or?
That's okay. But
I'm not going to drag it out.
You may be here for the next 4 to 5 hours.
Right, okay.
Yeah, that's why I say during your presentation, be mindful that most of the things will be clarified when members interact with you. Is that understood?
That's understood. Thank you.
Advocate Mkhize, can we confirm that the guest before us is Mr. David Bruce?
You may state your full names.
Okay, well, in fact, my full name is Robert David Bruce, and I'm known as David Bruce.
Yes, Chair.
And the civil society organization that he represents, is it the ISS?
That's right, I'm here on behalf of the Institute for Security Studies.
Thank you so much.
Thank you, Chair.
You can switch that other microphone off next to your Kawaza. Okay, Mr. Bruce, good luck in your presentation.
Thank you very much. Okay, thank you, Honourable Chair, and my greetings to the honourable members of the Ad Hoc Committee and to all others who are present here. My name is David Bruce. I'm representing the Institute for Security Studies. I've been working as a consultant with the Institute for Security Studies for a few years. And I've been working as a researcher mainly focused on questions about policing in South Africa for, I'm not sure if it's a good or a bad thing, but for about 30 years. So in the submission which the ISS has made to the Ad Hoc Committee, we've focused exclusively on one of the issues which is a critical issue facing which the Ad Hoc Committee is engaged with, and which is also, of course, an issue facing the Madlanga Commission. And as I think everyone here knows, it's a question which starts with the fact that our Minister of Police, Senzo Mkhunu, issued an instruction on the 31st of December 2024, in which he ordered that the political killings task team be shut down. So just what I just want to clarify then is just that while we acknowledge that there are other issues before the committee, and I want to refer specifically to the issue which Honourable Sauls raised of this crisis around the deadly danger faced by many whistleblowers. And I would particularly like to support and affirm the issue that you raised about the need to see that issue as an issue of profound urgency. But our submission, and all I'm going to be speaking to, is the issue of how to prevent inappropriate political interference. And it obviously raises questions about how we conceive of the question of inappropriate political interference. So in discussions about the instruction that Minister Mkhunu issued, there have been questions, for instance, was it, did this constitute inappropriate operational interference? Should there have been another process followed that involved consultation with for instance, the National Commissioner, questions about the motivation behind the instruction, and also then a related issue, but has been about questions about the political killings task team itself and about its effectiveness. Also, I think Sean Tate then has also emphasized that likely to be on Parliament's agenda in 2026 is the SAPS Act Amendment Bill. And so one of the questions that emerges is does this present an opportunity for Parliament to introduce legislative measures to try and do more to limit the potential for inappropriate political interference? So just to give it to you in a nutshell, what I'm going to be doing is proposing a way of looking at this issue of political interference, focusing on this question of the role of the minister and the relationship between the minister and the national commissioner, and the directions that are issued by the minister to the national commissioner. What I just want to also maybe just make clear at this point, and hope it will become clearer as my presentation progresses, is that what I've heard in the meeting that I've attended so far today, and in other discussions and conversations that I've heard about Minister Mkhwanazi's instruction, is there consistently what emerges is this idea that there's something called policy and there's something called operational issues, and that the minister's authority should be to issue policy and not operational issues, and not operational instructions. And basically, what I'm going to argue is that this is using this distinction, relying on that distinction, is inadequate for trying to regulate how the minister exercises his or her authority over the police. And so I'm going to be suggesting an approach to how the minister, how this can be addressed in legislation that has some correspondence with some of the recommendations that were made by Ad Hoc. So what I would then just like to refer to is, so what are the powers of the minister? And I think what I'm just going to refer to here is just the powers that are conferred on the minister in terms of legislation. In terms of the Constitution. So there are other powers that are conferred on the minister by legislation. But if one looks exclusively at the Constitution, then, and I'm going to rely on the way in which the Marikana Commission summarized these powers. So the Marikana Commission said that the minister's powers can be understood as having three components as articulated in the Constitution. The one is a political responsibility for policing. That's referred to in Section 2061. The one is that the minister must determine national policing policy, and that's provided for in Section 2061 and 2, and there's references to the role of the provinces in contributing to those provinces. But the third thing is that in Section 2072, Section 2072 says that the National Commission exercise control over and manage the police service in accordance with the national policing policy and the directions of the cabinet member responsible for policing. So this provision, Section 2072, at face value, it seems to be saying that the minister has the authority both to issue national policing policy and to issue directions. And by implication, directions are not synonymous with national policing policy. So then also what I just want to refer to then is just something that was an assertion made in the affidavit submitted to the Madlanga Commission by Major General Van Rooyen from the SAPS legal department. And she said that neither Chapter 11 of the Constitution, which is the chapter regulating the policing and the military and so on, neither Chapter 11 of the Constitution nor the SAPS Act provide any clear guidance on the ambit or scope of the police, of the policy or directives that the minister may issue. So what I also just want to, I'm trying to just pay attention to the chairperson's wish that I try and give a sort of high level, a kind of tighter version of my presentation. What I wanted to, I think maybe just highlight is that while the minister has had an authority to issue national policing policy. That's been embodied in the Constitution since 1996. This, in practice, this authority or responsibility is one that has largely been kind of dormant. So what we've had is a number of ministers of police since 1996, and what we could say is that if we were to compare them with each other, it's clear that they've had different styles of engagement, different levels of engagement with the police. So for instance, if we look at some of our ministers, some of them have been quite heavily occupied with mediating local level upheavals around crime and policing. And sometimes, as it happens in the process of engaging with communities, they often seem to make commitments which are a type of operational commitments on the part of the police. They quite often seem to make commitments that involve promising that greater police resources will be provided to that specific community. So, so what I would suggest then is that up to this point, we haven't really been able to develop a type of mechanism or machinery which is able to effectively assist the minister in addressing the critical questions facing our policing system. And so the one reservation that I have about the idea that one would like to confine the minister's role in relation to the police to that of making policy is that my impression would be that we don't really have an effective policy development capacity which supports the minister adequately in performing that kind of role. So what we do have now is, for the first time, what we have is a document that was signed by Minister Mkhwanazi on the 3rd of December, 2024, which is called the National Policing Policy 2025. So this is the first time that we've had a document which is called the National Policing Policy. A few things about this policy: the process of developing this document started in 2022, the draft was circulated in 2023, and as I've indicated, it was finally signed off by Minister Mkhwanazi in virtually at the end of 2024. So the process of developing this policy took close to 3 years. But I would also like to, and so also what was involved in this process was quite a high level of consultation with role players within the police, with other personnel within the criminal justice system, and then also with stake of the state and in society more broadly. So what we have then is what my observation about this type of process would be that that it is a helpful process in broadly understanding the perceptions of people about the policing system, but it doesn't necessarily lead to enable our policy-making machinery to kind of answer many of the critical questions that are facing our policing system. For instance, questions about the types of recruitment strategies that are being implemented and how to strengthen those recruitment systems and so on. So a further point that I just want to make now is just that moving the focus slightly is if we were to talk about political influence of over the police. So now I'm talking about, I'm not talking about inappropriate political interference. I'm talking about how politics operates in South African society and how that influences policing. And so what is clear is that, a lot of political influence that's and expressions of concern and political pressure on police, whether we're talking now about from the minister or from within parliament or from other sources within society, including the media, for instance, focus on questions to do with police priorities and the use of police resources. And so associated with this, there's a tendency to establish task teams or units to focus on specific aspects of the crime problem. So the one concern that one might have is that political influence of this kind neglects broader questions about the impact of such measures on other equally serious types of crime. But the basic point that is most relevant to this presentation is that this type of political influence, which, you know, as I've said, is often the focus of expressions of political concern regarding policing in South Africa, is simultaneously operational and of a policy nature, insofar as it focuses on questions about priorities. It could be seen as engaging with questions of policy. On the other hand, it is also very directly about how police resources are used and deployed. And so the point that I'm making is merely to illustrate that this idea of a clear distinction between policy and operations is not, doesn't necessarily, isn't necessarily easy to apply. And as I've suggested, on its own particularly, it's not adequate as a way of regulating the manner in which the minister exercises his or her authority over the police. So I just also then want to make a few points about inappropriate political influence. So the one point is, and this comes from studies of policing in African countries and also notably in Australia. The first point that comes up is that political leaders often appoint police leaders who are politically aligned with them. And so, and related to that, there's a tendency on the part of police leadership generally to comply with the directives that they receive from their political masters. So what's, for instance, been observed in Australia is that it's frequently only when there's been a change in political power and a new political party has come into office and a new minister is appointed, that these disputes between the minister and the chief of police emerge as a controversy in the public domain. The further point that just is also emerges from analyses that have been conducted of inappropriate political interference is that political interference is generally conducted, the communication through which ministers of police or other political officials engage with police leaders is often of a sort of informal nature, often of a verbal nature. That it's very rare that it's formalized in written form, particularly if it has some irregular elements to it. And so this takes us to the point, which is the proposals that we are making, which is about regulating political interference. And as I indicated, this overlaps in some ways with the point that Ad Hoc have made. So basically, there's four proposals, and there's and what I'm going to do just fairly quickly, I hope, is refer to a few examples from foreign jurisdictions where these types of provisions have been incorporated. So the first type of legal provision would be a requirement that prior to issuing a direction to the National Commissioner, the minister must consult with him or her. The second one would be that any directions are reduced to writing. The third one, which is overlaps with or resembles proposals made by APCOF, was that copies of all directions must subsequently be provided to Parliament or Committee of Parliament. And then the fourth one is that legislation should specify in some way a minimum set of issues that may not be addressed in ministerial directions. So the examples that I've got are firstly from Kenya. And so what you do have in the Kenyan Police Act is a requirement that directions from the minister be provided in writing. In the state of Victoria in Australia, so Victoria has a federal system and there's different legislative regimes governing the police in each of the different Australian states. In the state of Victoria, there is then this provision, it reads, the minister may, after consulting the chief commissioner, so there's firstly the requirement of consultation with the chief of police, give written directions, again, to the chief commissioner in relation to the policy and priorities to be pursued in the performance of the functions of the Victoria Police. And then the following section then lists a set of issues, which it says directions issued under the preceding section cannot address the following types of issues. And I can provide members of the committee with the list of issues that are listed in the Police Act in Victoria. There's a slightly different approach then that is taken in the state of Queensland in Australia, where rather than saying what directions by the minister may not address, the legislation then says they may only address the following types of issues. And so on this point of subsequently or ensuring the transparency of any directions that are issued to the National Commissioner, what we, again, there's examples both from Victoria in Australia and from Queensland, which illustrates slightly different approaches. So in the Police Act in Victoria then says that copy of all directions must be published in the Government Gazette and also published on the website of the Victoria Police. And then the Queensland Police Service Act, similar to the proposals made by APCOF, refers to the requirement of some kind of register and are actually quite complex in terms of different public bodies that this register must be submitted to, but they include the Legislative Assembly. Just one further variation on these types of approaches is in New Zealand, where, so as I've said, the Victoria Police Act says that outlines issues that may not be addressed by the minister in his or her directions to the chief of police. What the New Zealand Police Act says that if the commissioner receives directions dealing with the following types of issues, then the commissioner is not responsible for implementing them, and that the commissioner must act independently in relation to these issues. And these include any action, the investigation of specific people or action against specific groups of people, and also generally these lists of issues then include also things like decisions about, for instance, appointments or promotions of individual employees, and also disciplinary matters within the police. So just by way of conclusion then, some of the points we've, that our presentation speaks to is that policy making is embedded in the Constitution as a responsibility of the minister, that up to this point, a political system has not sustained a responsive capacity for policy development. That also we would caution against almost a heavy-handed approach to dealing with the issues, the issue of the risk of inappropriate political interference, insofar as one does not want to prevent the minister from exercising appropriate executive functions in relation to the police. And a further point, which has been, a key focus of this submission, is that many political interventions regarding police have operational impacts as they focus on setting priorities and ensuring that police resources are focused on specific crime problems. And so then what we suggest is that rather than limiting the minister to policy, emphasis should be on requiring consultation with the National Commissioner, written directions, ensuring transparency, and then also delineating a minimum core set of issues that should not, around which the minister has no authority over the police. And there's just one final word, which is because I've, in this presentation and in our submission, we focus on the relationship between the minister and the National Commissioner. But there's a further point, which is just that, and I think it has been, I'm not quite sure which honorable member of the committee made this point a bit earlier, but that in many ways, political influence of the police, including inappropriate influence, emanates from diverse sources. It might emanate from provincial legislatures. It might emanate from, for instance, local government, for instance, related to questions of public order, policing, and so on. And so, there is a question about, insofar as this committee does embrace the idea that, potentially amending the Police Act is one way of looking at addressing the issue of inappropriate interference. The point would be that the problem of inappropriate interference goes beyond, merely a question of the powers and authority of the minister. And so then what I just want to, and this is my final words, is just then flag the fact that there is a reported, it was submitted to government in 2018 by a body called the Panel of Experts, which was appointed on the recommendations of the Marikana Commission, was appointed by the then Minister of Police, Nathi Nhleko. As it happens, I was a member of that panel, but recommendation 13 in that panel's report then also speaks to this question about the broader issue of political influence of the police and make some suggestions regarding legislative provisions that might be helpful in, let's say, empowering police to resist inappropriate types of political influence. And that's the end of my presentation. So I hope that in some way it will be of help to the members of this committee. Thank you.
Thank you so much, Mr. Robert David Bruce from Institute for Security Studies. Honorable members, are you ready for rotation? I'm not allocating you the time that I have allocated you in the previous session, because I have noticed that my benevolence is being abused. Honorable James, you requested to leave. What time?
About 10 minutes, 10, 15 minutes, just waiting.
there anything you want to say before you leave?
No, I don't have any questions. Thank you, Chair.
In case you may want to go, you are released.
Thank you, Chair.
Who else wants to leave? Honorable Sangweni, what time do you want to leave?
At 1800 hours, Chair.
Is there anything you want to say before you want to leave?
Yes, please, Chairperson.
Honorable Topa,
Yeah, thank you, Chairperson. If I could leave by at latest 6:20, I would really appreciate it. And I just have one question.
you have one question. Honorable Diane Kolabanat.
Thank you, Chair. If I could also leave around 6, but I also have a question. Thank you.
How many questions?
Just one.
One. How many questions do you have, Honorable Sangweni?
A little more than one, Chair. Maybe
Can
4.
we take the members with single questions first? Starting with Honorable Topa.
Thank you, Chairperson. Thank you for your benevolence. Thank you very much for the presentation. I just have that one question. You made the point that ministers sometimes make promises to the communities and which are more operational, promises of money to certain communities and so forth. In your opinion, is this grandstanding, political interference, electioneering? Is it a mixture of all of it? Or is it actually just a genuine desire of the minister for strategic direction, but that strategic direction is then getting lost? I just want to understand your point that you made there. Thank you, sir.
Right, thank you. So I think the one point that I'm making is just, in practice, what type of role have our ministers of police been playing? So my one observation, I mean, as I said, I've been working in this field for 30 years, and I might be seen as someone who's been observing ministers of police for 30 years. And so the one observation would be that some ministers of police are more engaged in the role than others. And I would refer to specific ministers of police who appear to have been very actively engaged in the role. Which I see as being in their favor. But then the style of engagement was through mediating in conflicts. And so my observation would be that they are effectively involving themselves in a type of firefighting. So, one could have an argument then about that whether that should be their role or not. But it's just, in some ways, where I'm going to is pointing out here that this is one of the situations where one has had ministers who are playing a role which has involves making operational commitments on the part of the police. Whether, to what degree it involves consultation with, for instance, the National Commissioner or police leadership is never entirely clear. But, so what it, on the one hand, illustrates is that ministers aren't really carrying this role of doing policing policy, but also that, it illustrates this point. You see, I'm not sure, when people have raised this question as to whether this is something that a minister should or shouldn't do, it's not clear to me that it's something that they shouldn't be doing. But all I'm saying is that, it illustrates a point where they are effectively becoming engaged in an operational side of policing. And so what then I'm arguing is that, well, that's not necessarily problematic insofar as long as there's a transparency and this can be subjected to some kind of, and at least it's not necessarily problematic. And then insofar as we have transparency around what the the minister is doing, then we can interrogate that and assess whether it is inappropriate or not. But, in relation to the specific minister that I'm referring to, and I think it has been one minister more than many of the others who played this kind of role, I'm not aware that questions were ever raised in Parliament about him having been played a role that was inappropriate. Did I clarify that for you?
Honorable Diane Collar-Barnett.
Thank you very much, Chair. Mr. Bruce, hello to you. I'm very interested in your point 16 on page 7. Much of what launched this entire episode, the 2 investigations, etc., was based on whether or not the minister had the right legally to shut down the PKTT. That is one of the core elements, and that's from which came so much more. And that's possibly the entire rationale for what has come out. So you say here that the powers of the minister extend beyond the authority to issue national policing policy, but also has the authority referred to in section 207(2) to issue direction. And you say there's a reasonable interpretation of that section, that directions are distinct from policy. So it's quite different. And many people have said he only has the right to influence policy and not direction. So I see a quote here from Major General von Rooyen, who in her written submission said that neither Chapter 11 of the Constitution nor the SAPS Act provide any clear guidance on the ambit or scope of the policy or directives that the minister may issue. So what is your feeling on whether or not he had the right to close the PKTT, and perhaps comment on the method that he used to do so?
Okay, thank you for the question. I think the one question is then about the motivation of the minister in closing the PKTT. And there's, it would be fair to say that there are serious suspicions about what his motives were. And the minister has, Minister Mkhwanazi has defended his decision on the basis of, well, I'm not going to try and explain it in any depth, but on the basis of reconstituting supposedly decisions that had been taken about reconstituting the detective capacity of the SAPS, and it's the manner in which its specialized functions were structured. So, you see, I think that, the point that I'm making is that the directive that he did issue then, which was to close down a unit, to me, it's of the same, I think the word is sui generis, of the same family, of the same, as many political directives which are issued for specialized units of one kind or another to be established. So if we look at the establishment of the PKTT, that was, that was something that took place under political direction. And so, to me, establishing task teams and closing them down is something that, is equivalent. And so insofar as ministers seem to be authorized, or the executive seems to be authorized to play a role in the establishment of task teams, it seems also to me then that similarly it is within its powers to play a role in the dissolution of task teams. That does not mean that underhand motives may not play a role in such decisions. So the further point then, you see that I think that some of the answers to this question is not that the minister violated any formal provision that I'm aware of. There might be protocols of government that, for instance, you see, I mean, people have raised questions about the interministerial committee. And, so there's a question about, were there protocols relating to interministerial committees that were still binding on the minister? I can't answer that question for you, but it's not clear to me that there were. And so, I would say that, my question is that there is not, a clear breach. My understanding is that the minister did not clearly breach any provision that I know about. And so, but I would, then look to measures such as of the kind that are suggested by ourselves in Ad Hoc as a way of, so for instance, it seems fair to say that even if there wasn't a violation of any existing provision, that the process that he followed was lacking in some kind of way. And so, introducing the requirement that any instructions of this kind, directions of this kind, should be preceded by consultation with the National Commissioner would seem to be a reasonable measure to try and limit the risk of what might have been a poorly considered instruction. Thank you.
Honorable Sango. At any time you may want to be recused, honorable members. My benevolence allows you to do so.
Thank you very much, Chairperson. Good afternoon, Mr. Bruce. I never thought I would ever agree with the Institute for Security Studies. But let me say, today I feel like Honorable James, I feel vindicated. Not because, and I want to put this on record, not because it's in defense of Minister Mkhwanazi or anything of that nature. I hold no brief to defend anybody, including Minister Mkhwanazi. But I've always held a view that there is no way, and I mean, a lot of the time it's been a lone view, including in my party, there's no way a political principal can be given authority over a department, exercise oversight, and then is not able to give a direction, and I think your arguments that speak to some of those matters, I agree with you insofar as we don't know the motive. I agree with you on issues of process, but most importantly, I agree with you on recommendations which say that we must be able to delineate what we regard as strategic, what we regard as operational, and people must not just throw those words around, and then they're not able to explain it. So thank you so much for that submission. I just have a few questions, and maybe let me just start with this one, which was just irritating me a little bit because I couldn't make sense of it also in the context of what we've been dealing with. You said at some point that political leaders, please, I'm paraphrasing, so you'll tell me if I'm wrong. Political leaders tend to appoint as police people who are politically aligned with them. Now, at face value, there's probably nothing wrong with that statement, but I'm keen to find out what you base it on. Whether you're talking generally or you are referring to the South African situation. Over the last couple of months when we've been, engaging with these generals, none of them, for example, as far as I know, are members of the African National Congress, which has been the governing party. They don't come from there. So what do you base that on? What is your thinking around that? And then let me give you a second question so that when I come back for my third and fourth, I don't come back again. You've argued that Section 2072 creates this dangerous gray area around ministerial directions. Now, having read that section, what consideration have you given to how it may be better phrased in order to deal with this ambiguity while seeking to maintain, I suppose, what the intent of the legislators would have been in that case? Thanks, Mr. Bruce.
Thank you. Right. So in relation to your first question, what I would say, so it's about the assertion that political leaders tend to appoint police leaders who are politically aligned with them. And I wonder if that is entirely correct, but let's say that tends to appoint police leaders who are likely to be willing to do their bidding. So they might not be, of one mind with them politically, but likely to not contest, political type directives which they receive. And, insofar as I have managed to read about the experience with policing in many African countries, I think that the experience is consistently that, police leadership is generally compliant with the executive. And so this, because I believe it was you who referred to the question about inappropriate influence being to some degree anecdotal. And I think that resonates, I think, with the point which I'm making, which emerged from something that I was reading about policing in Australia, which is that you have a pattern where a certain political party is in power, and then the police leaders are generally happy to follow the directions that they receive from the political leaders that they've been appointed by. It's when there's a change in power in those countries, there's a new political party governing that state, and there's now political kind of differences of some kind, not necessarily clear what they are, between the police leadership and the political party in power, that you then have these kind of disputes taking place, where the police leadership starts expressing dissatisfaction with some of the directions or instructions that they're receiving. So it's, the absence of, and if we look at this issue in South Africa, does the fact that, in fact, the man whose allegations have been given rise to the creation of this committee is, in my understanding, is that he is extremely exceptional as a police leader in South Africa, insofar as he is virtually the only one, if not the only one, who's been willing to resist political directives. And so it's as a result
Sorry,
of...
Mr. Bruce, I'm also speaking for my colleagues. Let's try and keep the
Okay,
show because we're running out of time. Thanks, sir. And the second one was on section 2072.
Right. Well, you see, I mean, your phrase that this is a dangerous gray area, you see, I'm not sure that it is a dangerous gray area. That wouldn't be my formulation. My formulation is purely that the Constitution does say these two things, and that up to this point, there hasn't really been engagement with what these provisions mean. So my understanding is that it's, it is, from my understanding of how democracy works and should work, it is not necessarily appropriate to confine the minister's authority to one of making policy. That's my impression, subject to someone persuading me otherwise. And so I think my understanding is that it is not necessarily a bad thing that the minister has the authority to issue policy and to issue directions. What it does do is create the potential for that authority to be used in an inappropriate manner. And so the approach that we're taking in our submission is to try and ensure that Parliament is able to scrutinize the manner in which the minister exercises power. And it might also be seen that the national commissioner would be given greater power to be empowered to resist inappropriate interference.
Okay. So, I mean, as I indicated that the recommendations that are made here, I believe, are pragmatic. I mean, you're saying directions to be given in writing, made publicly available, specify what matters must be addressed in directions, minimum core issues, require minister to consult the commissioner. Just two quick and last questions on the recommendations itself. Now, if we were to adopt this minimum core model, I think it was New Zealand that you mentioned. In your view, which are the policing functions that you think that constitutionally should be insulated, from this political interference, so to speak? What would those look like? So what would be the core minimum areas? And then finally, I don't have a problem with the notion of a minister consulting the national commissioner, but it doesn't mean that the minister cannot issue a directive after he has consulted. Maybe the phrasing would be after consulting the national commissioner. And similarly, I mean, we've got that example in the communication sector now with the minister and ICASA. Similarly, the commissioner can voice their disagreement with the direction. Minister acts, he issues the directive in writing, and a national commissioner, if they believe that an issue is ultra-virus, it's illegal, they can refuse to implement the instruction. And basically that's what you are recommending. Would that be a correct understanding?
So, for instance, I think that this New Zealand example where the legislative says that insofar as directions deal with the following, the national commissioner is not required to comply with them and must act independently. I think that's a good approach to it. On the question of what those issues should be, there are obvious ones. The obvious ones are specific investigations against specific people. And I think a lot of people would include the conduct of specific public order operations, things like that. There's ones that tend to come up, which are, for instance, decisions regarding individual employees of the police department, including matters of discipline. But, I would say that, so for instance, but in Victoria, they've got a list of about 7 or 8 of these things. So, I mean, I think, there would have to be judgment exercised about what to include and exclude from that kind of thing.
Thank you very much, Mr. Bruce. I don't have any further questions. Thank you, Chair.
Thank you so much, Honorable Nomvalo.
No, thank you very much, Chair. No, let me start by saying that we are vehemently opposed to the content of this presentation. We don't agree with it. There's no point that we agree with. So in its totality, doesn't make sense to us in its totality. One, it doesn't make sense in terms of the legal framework, but secondly, in terms of a problem that we're currently faced with here in this committee, because our firm view is that, one, the minister does not have powers in terms of the current constitution and in terms of the South African Police Service Act to enter into operational issues. And if he does so, he is violating the constitution. The South African Police Service Act operationalizes Section 207 of the Constitution, and it does not give powers, consciously so, to the minister to enter into operational affairs. Section 11 of the Policy Service Act gives powers to the National Commissioner. And I think the reason behind this is that in most instances, in fact, in all instances, people who are appointed as national commissioners are people who are career policemen, people who have experience in the police. They were constables, detectives, brigadiers, and so on and so forth. That is why they are given powers, because a police institution is not an institution that you can gamble with. It's a very critical institution in governance. And to have a person who's the national commissioner, you require skills and expertise. And the minister is a politician, and there's no requirement for you to be a minister of police. If I love Honorable Skhosana and I'm the president, and if I want him to protect me for my future shenanigans, I can simply appoint him because I know that he's my puppet. He will take all instructions that I'm giving to him. Whereas a commissioner is a well-qualified person in terms of experience, who understands better how to run an institution or a department called SAPS. So I think there is no issue here with the current legal framework. There's absolutely no issue. And if anything, the current legal framework was violated on the 30th of December 2024, when we were busy at home celebrating New Year. So to suggest that more powers must be given to the minister and the minister must be protected and so on and so forth is to want to exacerbate the situation. That is my comment. We don't agree with what you have said, and we think that your proposition can exacerbate the current quagmires that we are faced with. Number two, you have also spoken about a tendency to establish task teams. And my reading of your tone is that you seem to be against that. My understanding, my simple understanding, I've never been a police, but with the little experience that I have with regards to the running of the affairs in the police, is that a task team is appointed for a specific purpose and to address a particular problem. And that has worked because a unit is a unit that is established to deal with general issues of crime. And then when there is a specific problem which is rife, or when there is a specific scourge which is growing uninterrupted, and the police can't in their current form address that issue, there is a need to establish a task team. And practically, that has worked for the people of South Africa. It has worked in KZN. Before I'm speaking now as a citizen of KZN. Before 2018, there was no task team in KZN, and people were dying like flies. And evidence is tendered here that there was a collaboration of criminals and people who are in the police. Because what criminals do, they identify role players in the current setup of the police and want to capture them and use them for their criminal activities. And when there is a task team, it's not easy to do that because various people are deployed in terms of their expertise and experience to deal with a particular problem. So, in terms of the practical records, task teams have worked for the people of South Africa. That is why today there's peace in KZN. People are not dying. We're going to elections this year. If you know KZN very well, by now many people would have died if that task team was not established. So to suggest that a task team or to label it as a tendency to establish a task team, I think, is a bit inconsistent and undesirable. It's peculiar. We don't agree with that because a permanent unit continues to focus in its competency, whereas a task team is established for a specific purpose. And when they have completely arrested that problem, then they get established. Now, another point that I wanted to raise is that I don't think there is a problem with the minister giving a direction, but there are requirements that must be met with that. One, a directive can only be given in terms of what is legally permissible. Two, a directive can be given through a comprehensive consultation with relevant people who have powers to make a determination in that directive. You can't, because you have powers, it's not an open-ended right or prerogative or discretion that you have as a minister. Because one day, if I have an open-ended right, I would wake up and say, Shongwe, you can pee here. And then I claim that I have a responsibility or a right rather, a constitutional right to give a directive. Now, a directive can be implemented in terms of the legislation, and the legislation gives powers to the minister, to the national commissioner, not to the minister. So the minister doesn't have powers to intervene on operational issues. There is nowhere, there is no law that gives a minister powers currently. Maybe they are yet to be made, but currently in the legislation and in the constitution only says, section 207, subsection 2 says, the commissioner has a responsibility to control and manage services in the police service in consultation or in accordance with the directives of the minister. But it doesn't end there. It goes also to the act which gives, and the act gives only the national commissioner powers, section 11, only the national commissioner powers to deal with operational issues. And the act drills it down because it explains specifically and it specifies roles of the national commissioner to say he can do A, B, C, D, and 3. So there is a difference between issuing a directive and actioning something. A directive, in my understanding, if I can give a practical example, can be given in this way. If I have a right to issue a directive and Skosana has a right to manage this house, I can give a directive to Skosana to say, by 6 o'clock, I think, or firstly, I would consult with Skosana because he knows the house better than I. because he manages it on a daily basis, and ask him if it is appropriate for him to change that door. And if he says, as a person who has experience and as a person who manages this house, I think it is appropriate to change that door. And then I can say, you can, having made all such considerations, you can change the door. And not come with a date to Skosana. That is dictatorship from a general perspective. It's dictatorship and it's ultra virus. I can't come to Skosana and say, Skosana, tomorrow at 10 o'clock, who manages this house? At 10 o'clock, that door must have been changed. What kind of a directive is that? That's dictatorship. I can't give that instruction to a person who has statutory responsibilities which have been explained thorough in a legislation, and just give an instruction to say do A, B, C, and D. Whereas I am not in charge of day-to-day responsibilities of doing what he does. So I don't have any question on your presentation. I'm crushing it from point one to the last point. We don't agree with it. It doesn't make sense to us. It appears to be more defensive than anything. It appears as a mouthpiece of Senzo Mkhunu. That is, it has been presented to paint a particular picture or to establish a particular defense. So there's no question. I was just engaging. Thank you very much. It's a comment.
Okay, thank you very much for the comment and taken note of the points that you've made. I think just my responsibility would be just to obviously reply to the last, was it a dig or a jibe or what? I'm not quite sure what you would call it, but that the submission was made in some ways in a way which was intended to favor one person or another person. And, you know, I can state very clearly and without any hesitation that, you know, that's just entirely not true. And the work forms part of work which is intended to support Parliament and support the government of South Africa in building an effective and sustainable democratic system. And that, yeah, and that is the spirit and the motivation behind it. But thank you.
I'm not sure whether I should be a chair myself now. I think I'll chair this meeting because the chair has just left. He left.
The chair just spoke to you and indicated you must continue. Please, hands off the chair.
Thank you. Good afternoon, Mr. Bruce. Good afternoon.
Good afternoon.
One, this security studies, this Institute of Security Studies is the one which was being led by then George Fivers, am I right? Or it's another one? The security study, or is it Jack Siller? I think it says.
Established by Yaki Saliers.
Okay. Who's funding it?
Your mic, please.
Your mic, please.
You're asking me, because I would refer you to the website of the, I mean, I work with a specific program of the ISS.
So you don't know who's funding it?
No, I do know him by name. As it happened, there was just an announcement that was issued by the ISS, I think yesterday or today, regarding the resignation of the current director. So the director's post is currently in
No,
trial.
I'm aware of that, Mr. Bruce. My question again, it's who's funding the Institute for
running it?
Security Studies?
Okay, well, can I refer you to a specific section of the website which deals with the governance system of the Institute for Security Studies, because I would have to consult that if I was to be able to provide you with a comprehensive answer to your question.
Oh, well, I'm not answered, but I thought that you are here, you know exactly who are the funders of this Institute
No,
for
I
Security
work with
Studies.
the ISS as a research on policing, and my work is very much focused on.
So if it's funded by drug dealers, you'll never know. You'll just say you are working there.
No, but I have confidence that it's not funded by.
No, you don't know.
Illicit sources of money.
No, you don't know.
No, I do
You
know.
don't know. Let's leave it like that.
I do know.
I'll check the website.
No,
you
no,
don't know.
I do know that.
Then
it is-
give me the answer if you know.
Okay, so I'm going to refer you to the website.
You see now, as I was saying, I'll look later on the website because you don't know for now.
Okay, no, but I have read the provisions of the website. I just can't.
Okay, no, let's leave it, Mr. Bruce, because of time. Major, you spoke about Major General Mkhwanazi van Rooyen, who heads the legal department at SAPS. Am I right? And you didn't say all what he said in the last when he appeared at Madlanga Commission. In your submission, there's nothing about that. But let me help you. I'm going to make a comment. I'm not going to ask because for me, really, I'm not sure why a coincidence.
We quoted Magda van Rooyen in our submission.
Yes, well, what did he say at the Madlanga Commission? Because what I'm saying here is not what I had and what I have. Maybe I didn't hear you well. Can you paraphrase it for me? Mike, please say.
The quote is that neither Chapter 11 of the Constitution nor the SAPS Act provide any clear guidance on the ambit or scope of the policy or directives that the minister may issue. So Major General van Rooyen was referring to particularly to Section 207(2) of the Constitution, as far as I understand, but also to 206(1) and 2, which authorize the minister to, on the one hand, issue national policing policy, and on the other hand, issue directives to the police. And her observation was that there's broadly a lack of clarity as to what the scope of these powers is.
Let me just contextualize it for you and with my comment now. Major General Petronel Mkhwanazi van Rooyen, SAPS head of legal service, testified that the police minister Senzo Mkhunu acted outside the authority and the legal mandate by ordering the political killing of a task team to be disbanded. She was very clear on that. I'm not sure how did you miss that in your submission. She argued it was an operational matter, not a political decision, and that the action severely hindered the investigation, suppressed cases, and ignored proper legal process. Do you remember that? Key points from her testimony at the Madlanga Commission of Inquiry. Overreaching of power. Van Rooyen stated clearly that the minister lacked the authority to disband the specialized unit, which are operational functions. Now, she testified that the rapid disbanding of the case at base PKTT had a negative consequences for the police work. And I think my colleague, Honorable Nomvalo, was arguing on that to say, he has nothing to ask, because as far as Umkhonto Wesizwe we are concerned, what is submitted here was a tick box exercise, in our view. And I'm saying this to you, Mr. Bruce. Someone who reads this will say that we are defending something here, because hence I'm saying to you, in your submission, what I've read to you, you haven't said anything about that. And Makhna, the legal head, was very, very clear on that. I'm not going to quote sections you've been, the section 2077. I serve in the police portfolio committee, by the way. The section which you being emphasizing on here might be misleading, and I'm saying this to you with due respect. Makhna said it all. We don't have to revisit that. By the way, he's the head of legal service in that department, and highly qualified for that matter. He's a PhD holder. And hence I read about the issue of New Zealand, you know, Queensland, what they do, in Kenya, what they do. You know, our history in this country, as you know, if you've been here for a very long time, because some of Europeans arrived not earlier, you know, some are born here, some they've got dual citizenship, some, you know, but our historical background, it's of such a nature that it's not easy to forget what happened in the past. Hence, my colleague gave you an example of KwaZulu-Natal, that the PKTT work wonders. If it was not the PKTT, hence we are saying it was really premature to have disbanded that PKTT. And others, which are, some of them are not disbanded. In particular, we're worried about this PKTT. Hence, we are sitting here today at the Ad Hoc Committee. This could have been prevented, you know, if there was no interference at all. We will find ourselves in here. So you know, we've got dynamics as compared to these other countries. Other countries, they might not have what we have here. There's a lot of issues in this country which we need to be attended to. And we think that in terms of the constitution which earlier when Advocate Rahman was here, the Roman Dutch law, as far as we are concerned as well, we still have to, as lawmakers, you know, you need a majority to amend this constitution. We are not happy. There's a lot of gaps which have to be closed in this so-called the best constitution, which is misleading, by the way, you know, but that's politically, that's not for you. But indeed, there's a lot to be done. But in terms of what I was saying to you, that I'm making a comment, I think you left what I've said deliberately about what Makhna said about the issue of interference, you know, and the issue of the PKTT. I thank you, Chair.
Thank you so much, Mr. Bruce.
Thank you.
Any comment?
Yeah, well, just a couple of points. One thing is that obviously you and Honorable Nomvalo have raised a question about the utility of task teams. You know, I don't agree with you that it's clear or straightforward that they have played a particularly useful role. I think that we're living in a country that has got a murder rate of something like 25,000 people a year, has enormously high levels of violent crime. KwaZulu-Natal itself also has very high levels of violent crime. The PKTT itself has, you know, have looked at discussions of the effectiveness of the PKTT. And, I think that's a complex question. I think that it's never straightforward to evaluate investigative units.
Now, are you saying
Sorry, can I
Mahda is wrong? Because I don't want to waste some people's time.
Okay.
Are you saying Mahda is wrong?
And yeah, I would also just say that I wasn't sure, I wasn't clear. I was, I had read the report that you were, I think the same one that you were reading from.
Yes.
And had been through parts of her testimony, but I didn't see any clear reference to an explicit provision that had been violated by the minister. And as I indicated in my response to Honorable Kola Barnard, what's never been controversial is where there has been political influence that has led to the establishment of task teams or units of one kind or another. So to me, it's not entirely clear, or not at all clear, let's put it that way. What is the difference if there's political influence, political directive calling for a unit to be shut down? In what way is that more or less operational than directions or directives for unit or task teams to be established? So to me, I remain unconvinced. I don't know what the evidence is that there was any clear provision that that the minister violated. There might be protocols, informal or formal protocols that I'm not aware of that have been violated. But as I said, I'm not aware of them. But as far as I can know of, purely looking at the Constitution and the SAPS Act, there isn't a clear violation that I'm aware of on the part of the minister. Whether his actions were well considered, whether he was exercising good political or judgment, whether he was exercising his authority in a responsible way is another question. But I'm not aware that he clearly violated or was in breach of his powers.
Through you, Chair, I think Mr. Bruce came with a mandate. I'm going to put it clear to you. He's not convinced about anything. We are talking about something in KwaZulu-Natal, where our honorable member comes from. He says the killings have subsided because of the PKTT. PKTT. You said no, you are not convinced. I'm saying to you, Mahda, the head of legal department, she said that in the Madlanga Commission, that the minister was wrong to disband that. We are saying there's nothing wrong with that. In fact, we are the first person who ever said that here. I'm even shocked.
I don't think you're accurately representing what I've said. What I've said is that he wasn't in clear breach of any legal provision.
I'm saying, irrespective whether clear or not clear, Nomvalo made it very clear in terms of the Police Act. I don't want to go there. But we said, in total, what you presented to us here, you are trying to convince us to say nothing, there's nothing wrong with what happened, the disbandment of the PKTT. And that the PKTT has worked wonders. We are not convinced of anything.
That's not what I said.
What are you saying, really? Because the submission is here. What you submitted to us here, and we are still arguing to say, there's nothing wrong, there's nothing clear about it, and we are saying to you, there's a difference. The people of KwaZulu-Natal are better off today. And we are talking about the lives of our people there. People were being killed in that province. And we are saying it was wrong for the minister to disband the PKTT. You said, no, there's nothing wrong with that. And I'm saying to you, I'm putting it to you that...
But I didn't say that. So why are you saying that I've said that? Because I did not say there was nothing wrong with it. I said it was not in breach of a legal provision.
Yeah, so in other ways, if there's no breach, there's nothing wrong. Whether people are dying or not dying.
I said it might have been poorly considered or ill-judged decision?
No. No, we are playing with words here.
Okay,
I'm saying to you, Mr.
Can
Bruce.
With words.
Can
I'm
we
not playing with
proceed,
words. I'm responding
Honorable
to
Member,
your assertions.
Mr. Bruce, the time of Mr. Skosana had expired, so
Yeah, thank you.
he was asking you questions on borrowed time from the chair. Can we afford Honorable Cameron?
Chair, I actually don't have many questions rather than a comment on the submission process. We're not here to oppose people that come and submit something. We listen to their opinion. We invited them. They are our guests. If we don't like what they say, that's fair enough. We can debate that later on when it comes to the report. Mr. Bruce is not a witness. He is an absolute expert in his field. If anyone did their own research, they would know that. And I think it would be fair to say that we need to give him a fair chance to speak. And once that is done, the committee can deliberate further whether we agree or not. Thank you, Chair.
Honorable Matthews.
Thank you, Chair. Mr. Bruce, good afternoon. I don't have many questions. I just wanted.
Chair, my hand is up.
Honorable Matthews.
Okay.
Yeah, but Chair, are you going to recognize me?
Can I continue, Chair?
Yes, continue, Honorable Matthews.
Okay, so Mr. Bruce, you said you've been in the field research or following police generally for 30 years. You're making submissions to us regarding interference, political interference in the policing establishment opposed to operations. You have followed all the ministers of police since, I think you said 1996. So stuff might be getting lost in translation here. So I would like you to give us some practical examples of any of the ministers who you think or who you would categorize rather as overstepped. There was political interference, the name of the minister and something that they did that supports what are you talking about in terms of political interference or whether it was political directives. So I think that will help us get clarity on your submissions, because I think now stuff is getting lost in translation. Okay, besides the matter that has us here. So that one we can park because it's been debated over and over. So let's start off, like maybe you can just give us an example of 5 different ministers in your experience that.
Well, you see, the answer to that is that this kind of controversy around the manner in which the minister exercises his or her power has not been a frequent occurrence in South Africa. And insofar as ministers have not frequently faced allegations that they've been exercising their powers in an irregular manner. Okay. And so the one very obvious example is when Lt Gen Mkhwanazi was the acting national commissioner, and what emerged there. And so it illustrates this point that would appear to me, it kind of appears to illustrate the point that police leaders generally comply with political authority and generally, are reluctant to resist their political bosses. But in the case of General Mkhwanazi, then there was a lieutenant general by the name of Richard Mdluli, who, cumulatively was on the one hand facing very serious charges, including charges of murder, and also in relation to other issues of corruption. And the police had taken action to suspend Lieutenant General Mkhwanazi and subject him to a disciplinary process. And what Lieutenant General Mkhwanazi said was that he had been placed under pressure, and he gave evidence about this before this committee, as far as I understand, where Minister Mthethwa, the late Minister Mthethwa, then wished him to withdraw the disciplinary charges against Richard Mkhwanazi. So that's the one example. The one very interesting example. So then,
Okay, so let's go back. So I want you to be able to distinguish. So the issue of the interference with the acting national commissioner, and I think it was with the minister, Nathi Mthethwa, the late Nathi Mthethwa.
yeah,
And you're saying Lieutenant General. So that is an example of political interference that was resisted, or that you considering that political directives. That's what we're trying to, I want to understand. I'm just trying to understand, what are you submitting? What is acceptable and what is not? In terms of what are you saying is good for the country?
well, you see, I mean, you know, that's a very clear example where there was someone who, what we know in the public domain is that for specific reasons, Lieutenant General Mkhwanazi, who was, had been appointed through an irregular process politically appointed as the head of the Crime Intelligence Division. Okay. And he enjoyed political favor as far as is understood, because he was seen as someone who supported the political interests that were in power at that time. And so then pressure was brought upon Lieutenant General Mkhwanazi to withdraw these charges against him. So it illustrates a case of political influence being used to protect a specific person who, by all accounts, should have been subjected to disciplinary procedure, should have been dismissed from the police. And effectively, as a result of this political pressure, this man remained on the payroll of the SAPS for another 6 years after. So, I mean, you know, there's clear examples. There is the question about the political killing.
So what are the other clearer examples? So we've
Well,
got
well,
that
you-
one.
you-
Let's
you
talk.
see,
So
so-
you're saying
so-
the issue with Lieutenant General Mkhwanazi does not fall into the same category in terms of interference and directives from a minister as the issue with the political killings task team. That's what I'm trying to.
yeah,
Why?
that-
What
it's not
makes
clear
it
to me
different?
that they
Because
want to-
it's a directive.
Sorry,
Why? What makes it different?
whether it's a legitimate interest or not.
So who decides that it's a legitimate interest or not?
Well, that can be a difficult question. But I mean, in the case of relating to Lieutenant General Mkhwanazi, it seems fairly straightforward that the police should have taken disciplinary action against him and dismissed him from the SAPS.
Okay. And then the political killings task team?
Well, you see, the one observation that I've made is this point that insofar as there is political engagement, the basic point, one of my most basic points is this point that insofar as there is political engagement with the police, it very frequently focuses on questions to do with what are priorities, what are not priorities. It focuses on questions of priority. And so if one looks at the economic infrastructure task teams, if one looks at the political killings task team, if one looks at other types of task teams that have been established,
Mr. Bruce, I
they
think
are
we're
often
getting
established
off.
under political influence. So to me, it's not clear what is the difference between a directive for a task team to be shut down and another political directive. To me, they seem to be equivalent. And so if the one is acceptable, then it seems to me that, you know, by implication, the other type of directive is, you know, is also, it's not self-evidently something that the minister shouldn't be doing.
So you don't think the directive in the first place to establish it was a problem either?
it isn't seen as a problem, and I'm not saying that it is a problem.
No, but you making presentations here, so we're asking you on how you would characterize it. And you can justify it.
No, you see,
That's what
I
we
have a reservation about this because you see, for instance, there's 27,000, there's 25,000 murders in the country. Political Killings Task Team is concerned with, you know, I don't know. I mean, the total caseload over about 6 years was something like 612 cases. I'm not quite sure how many of those were murders, but that's one small fraction of the overall problem of violent crime. So,
Okay,
you know,
but
there's
we're
a
going
question
off,
about.
yeah, my question, Mr. Bruce, was perhaps the initial instruction to establish it, because it was given by the president to deal, the president of the ANC was the president of the country at that time, because the ANC members and some other political parties were killing each other. Was that probably the problem?
You see, I mean,
Because it's given an operational
in
issue.
2013, I wrote an article motivating for task teams or dedicated units to be established to address political.
But I'm not talking about, we're not talking about the why, right? We are talking about the instruction, right? Not the why, etc. The actual instruction for the president to say, tell them, go and establish, and then the minister to say, the instruction to the acting minister that they must make those corruption charges of the Lieutenant General Mkhwanazi to go. I'm talking about the instruction. Is it political interference or not? Forget the part of you know, the backstory of it. We're talking about the instruction. When is it a directive, or and directive that is interfering with operations? Because that's what you need to tell us here.
Well,
because you are arguing the point on the substance, on whether the
point is
political killings
it is
task team.
operational in nature. It is operational.
So we can even argue that the initial instruction to establish it was political interference.
That's, you see, well, it was political influence, certainly.
Oh, that's different. Okay.
It's not, I wouldn't say it was inappropriate interference. But, and as a result of that, it isn't clear to me that by its nature, the instruction to close down the task team was irregular. But I think the critical question is in some ways what the motives were. And I don't think it was a good, you know, I don't think it was a well-considered instruction, partly because, for instance, the task team had an existing caseload, and closing down the
so your
task team
submission
seems to have been, at the very least, poorly considered. As a
so your submission here, if I need to sum it up, the directive of political influence, right, is based on what the motive is. In summary, that's what you're saying. Then if the motive is considered acceptable for whoever, according to, let's say you for an example, then it's not considered political interference.
Well, you see, I mean, I think it's also then clear that it would be appropriate. There's elements of this issue that are much clearer. So, for instance, for directives to be given regarding the investigation or prosecution, the investigation of a specific individual, or how the police should deal with a specific case, anything like that.
It's about
that would be
merits.
clearly irregular. Okay, and would clearly be, you know, would clearly cross the line. But if we're just talking, sorry, I thought this was on silent. It is, I don't know what's going on. I've got a phone that just isn't. I'm gonna throw it at the wall or something. Sorry.
Okay. I think we understand the submission that we should look at what the motive is on the directives. And then just my last question, Well, maybe you're not going to be able to answer it as you were not sure about, or you weren't able to tell us about your funders and whether there's been any investigation into the people who actually funded the organization. But as far as you know, does the ISS get lobbied by political parties to present particular positions? Or are they aligned with a particular political party?
No, as far as my understanding is that the ISS has a kind of open approach where it would offer advice to any political party. But it wouldn't, you know, then, yeah, insofar lobbied by, no, I don't think that the ISS does
So
that.
you're immune to being lobbied by a political party for a particular position?
Well, I mean, my understanding is that what the ISS tries to do is be open to role players in the policing field in South Africa, for one thing, and that those would include political parties. So the ISS is certainly open to engaging with all political parties.
How many political parties, to your knowledge, has the ICC engaged with? ISS. It is, yeah? ISS. Do you know?
I can't answer that.
So maybe if you can speak to those who would know, and we can get a submission on political parties that you'll have engaged on, or engaged in, or engaged with, rather, just so that would be able to.
Yeah, in my experience, it's primarily been the governing party and the official opposition. But, you know, and, yeah.
I'm done. Thank you, Chair. Thank you, Mr. Bruce.
Thank you. Honorable Nomvalo.
Yeah, no, thanks, Chair. I almost forgot what I wanted to say, but I have not forgotten. Chair, we must not live with a wrong impression and a wrong information here. Our understanding is that when presentations have been made before us as members of this committee, we are duty bound to engage them. We've not come here to peruse or listen and go home. We've come here to listen to presentations and engage. And engagement does not necessarily mean you must always agree. Where we disagree, and hear the views of the people who have been making presentations. So there is nothing peculiar with disagreeing, because people who are making presentations must be confident in what they have presented. If our disagreements are wrong, then they must prove us wrong. So we're not here to come and receive information. We have not at least drove from our provinces to come and do that here. We've driven from our provinces to come and listen and engage Tara. And engaging Tara means we can disagree when there's a need to do so. So that's our understanding. I've been tempted to raise this by what Honorable Cameron has said. It's completely wrong. Thank you.
Honorable Mnwango.
Thank you, Honorable Chairperson. I have no question. Thank you.
Thank you, Honorable Sauls.
Thank you, Chairperson. Mr. Bruce, good afternoon. Your submission cites a large gray area between policy and operations. Is it your expert finding that the current SEPS Act is too vague to prevent political interference?
Thanks for the question. I would say it's not a question of vagueness. I would say it simply doesn't address the issue. So you know, in my experience, what seems to me to be a positive source of reference for engaging with this issue is this experience, you know, which happens in so far as I've, you know, read about the issue. It's been something that's come up it's for one reason or another in these states of Australia and has been addressed by legislation in, these states in Australia and New Zealand, and it seems to me to be, a kind of sensible kind of approach that's taken in many of these jurisdictions.
So I'm still just being mild when I say vague. You are saying it totally doesn't address.
That's right. Yes.
All right. In your expert opinion, the SEPS Act in its current form, are you saying that it is a problem because it doesn't address or protect clearly against political interference? You're saying the act is the problem. It doesn't matter which minister is there. The act is the problem. So that no matter who comes, no matter who occupies the office, as we sit here now, if the act is in its current form, the current minister that's there, if he does the same thing, then the act has not adequately addressed it, and so also anybody else that comes. Is that your submission?
Well, you see, I mean, again, it's this point that my impression is that police leaders are often disposed to comply with political authority. The willingness to resist political authority is often not there. And so whether it's irregular or not, their orientation is to see it as something that they must do. And I think one could say that this is illustrated in this case by the manner in which, for instance, the National Commissioner responded. That the National Commissioner seemed, if it wasn't for the press conference in July, this wouldn't be on our table. It isn't something that the National Commissioner himself would have gone public about necessarily. And so it's more like when there is the will on the part of a chief of police, National Commissioner, whoever might be, where the chief of police feels unhappy, doesn't want to comply, these types of provisions may empower them to do so. And they may also inform the manner in which ministers exercise their authority. So, but the nature of the minister, if I'm understanding your question, one obviously has some ministers who might be more disposed to exercising their authority in a irregular manner than others are.
Okay, now let me rephrase the question. In your research, does the lack of a clear definition for the term used in the Act, ministerial directions, create an environment where a minister can interfere in operation?
I would say yes, that's correct.
All right. You cite New Zealand and Kenya. How does the lack of a written record for ministerial directions impact the constitutional principles of accountability and transparency?
Yeah, well, I mean, I think the short answer to that is that it enables them to be entirely absent if they, if these types of directions are not recorded in some way. Mm-hmm. It makes it possible for the minister to completely deny that he or she has ever issued directions or instructions of this kind.
And to support that position, would I be correct in saying that the reason why we're sitting here now is because the directive was given in writing?
That's entirely correct. I completely agree with that. It was because it was in writing. If it hadn't been given in writing, it could have simply been denied, and there would be,
So your proposal is it should be a standard rule that all ministerial directives must be in writing.
yeah, that's right, that's right.
The Marikana Commission you mentioned recommended clarifying these powers over 10 years ago. In your expert opinion, has the failure to amend the SAPS Act since then been a failure of legislative oversight?
You know, I'm not keen to point fingers about people having failed. What I would say is that it clearly hasn't been taken seriously as an issue, as a political concern. This is, this is in many ways the first time in South Africa that I've seen concerns about the manner in which the authority of the minister is exercised being foregrounded as a type of political concern.
All right. Now, let's move away from the political emotionalism. Let's deal strictly with research, and let's deal with the law and the lack in our law, because that's where your focus really is on in terms of your research. So let's test that. Does your research show that the persistent drive to create specialized task teams, does your research show that it actually, in reality, weakens the overall ability of SAPS to solve murders?
Well, the one answer to that is merely to point out that the SAPS itself has repeatedly raised points of that kind, and I can refer you to at least one or two, I think maybe 3 presentations which have been given by the SAPS, where you can see there's this concern expressed about this tendency to establish task teams without consideration on the impact that it has on other units.
I would think that you are referring to what you mentioned in your submission to us, that your research showed that the detection rate for murder is exceptionally low. It's currently reported by SAPS at only 11%. Is that correct?
Yes, that's right. And so, sorry, there's a point that I wanted to make here that's just escaping. Yeah, but the point that I would make, you see, is that I see the creation of task teams as in many ways a stopgap measure, that what's needed is an overall approach to strengthening the detective function within the SAPS, and that's been absent. And so instead what we have is this thing of the available resources being directed in one way or another to deal with what is inevitably a very small aspect of the overall problem of serious crime in South Africa.
Maybe by using the 11%, it doesn't really express why you are so concerned. So tell me if I'm correct if I rephrase it in this way, that if we say that the detection rate of murder is 11%, in other words, what that statistic says, that is not your statistic, but the statistics by SAPS, what it actually says is that 89% of murders goes unsolved.
Yes, that's right, yes. And so it illustrates to me the point that we should have a much more well thought through approach to strengthening our investigative response to crime.
Yeah. Let's dig a little bit more deeper so that we look at what you're actually saying. In KZN, the KZN paradox, and when we deal with now the specialized task teams versus the reality, the claim is that the political killings task team, the PKTT and other specialized units are touted as the solution to KZN's violence. But the reality is that KZN remains a killing field, contributing 21.4% of all murders in South Africa. Let's localize it a bit. The hotspots, despite heavy task team presence, Inanda police station in KZN remains the #1 murder station in the country. But let's not run the risk of just focusing on KZN, because the problem here that we are addressing, or that you're talking about, that I see in your submission, is not really just focused on KZN. Let's come to the Western Cape. The reality is, just like KZN, the Western Cape has numerous specialized units, anti-gang units, and the other units. Yet, it maintains a staggering murder rate of 60 per every 100,000 people. But there's task teams. In the Western Cape, murder rate is not dropping. It's not about the PKTT. It's about the country. You have at the Cape Flats, on the Cape Flats, between 11 and 20 murders every week. It's a bloodbath. And then you have the Eastern Cape. The Eastern Cape, according to our official stats, the Eastern Cape has the highest murder rate in South Africa. 69 out of every 100,000 people. But there's no attention given there. Why not? If the issue is really dealing with murder. So what I hear you saying is that resources are captured for elite specialized task teams, leaving the average detective at a local station overwhelmed with work and underfunded. You are saying, correct me if I'm wrong, but why take so much money and we put it into specialized units of between 30 and 60 people, where every station in our country, the detectives are struggling, no money to solve the actual murder rates that is increasing within our country. That is really why you are saying there should be a refocus and invest our money on detective work overall in the country rather than on units. Am I correct?
I think what you're, there's part of me that largely agrees with what you're saying. On the other hand, I do think that there's a debate. It is, and not that we've got time to debate because we're talking about people's lives and so on, but nevertheless, it seems to me to be valid to, in certain circumstances, prioritize certain aspects of the crime problem. And, one of the arguments that I'm, for instance, sympathetic to is, for instance, specifically the killing of whistleblowers. But similarly, if we're trying to maintain a democratic political system and political office bearers, their lives are in jeopardy. Particularly, I think it has often happened that those who have been killed have been those who've stood up against corruption. So I think, there are often arguments that certain aspects of the problem of crime should be prioritized even relative to other forms of crime that by many accounts are just as serious. So, it's not that, I accept that there are different approaches to this problem that are both valid, and it is an issue of decision making. So, it's not that I necessarily condemn these decisions to establish these task teams, but I don't think that the consequences of, the impact on other units are ever really properly taken into account. And the second point that I would make is that they have effectively been used as a stopgap measure, that what we need is a much more comprehensive approach to how to strengthen, firstly, our detective service and the policing system more broadly.
Where I come from, El Dorado Park, born in Kliptown, raised in Klipspruit West, there's a saying that summarizes what you just said. Goedes moet balance. You are saying it's not either or.
Yeah.
It's both, but there must be a focus on balance. But the biggest priority should be, once the specialized unit or task team is created for a particular crime issue, once that issue is managed, controlled, stop, close, and ensure that there's not local police stations and detective work all over the country is not negatively impacted by this focus on the units. There must be balance and prioritize. For what's the use? You have strong task teams, but weak detectives, detective units at stations all across the country. And you have general murder rates increasing, but that specialized issue is decreasing, but the overall problem is just getting bigger and bigger. Goedes met balance. Is my understanding correct?
Yeah, that's a good way of putting it.
So, ISS and yourself as a researcher there, you have confirmed what the people already feel. Our security strategy appears to be a performance, not a strategic, clear and decisive action plan. We have task teams in KZN, in the Western Cape, yet both provinces remain hotspots of blood. Meanwhile, the Eastern Cape, which is the deadliest province in the Republic at 69 murders for every 100,000 people. In the Eastern Cape, being murdered is no longer a rare tragedy. It is a statistical probability. You're talking about a society where almost every single family is either mourning a victim or living in immediate fear of becoming one. It is the deadliest place to exist in the Republic according to statistics. Yet, it is left to rot because it doesn't offer the right optics for a task team launch. We are chasing 100% headlines while only solving 11% of the murders. This must end now. And I join you in that call. We must stop the political capture of police resources for specialized units and task teams and return to the constitutional mandate of a professional, independent, and effective detective service that protects every single South African, whether they live in a high-profile metro or a neglected rural village. I thank you, sir.
Thank you
for your time. Chairperson, thank you so much.
Mkhwanazi. Wait.
No, Chair, there was a mistake. When I was supposed to speak, Babus Khosana took over. And when you came back, you thought I'm not speaking, so I just didn't want to phazamisa izinto sekhuluma buskosana. Yes.
Okay, you can go ahead.
Now, I won't take long, it's just clarity of certain questions, Chair. Nginenhlanhla yabantu abathanda ukuphuza amanzi. Nale nsizwa iphuza amanzi nayo, Chair. Evening, sir. Oh, it's afternoon actually. Sawubona. Ebusuku. How are you, sir? You can press there.
Thank you. How are you?
I'm fine, I'm fine. I take it you don't speak Afrikaans.
I don't have good Afrikaans. I read a bit.
Oh, I noticed when Honorable Souls was speaking Afrikaans to you, a surprise. Just clear me here on these questions. Firstly, if you were to advise the president, how soon would you advise him to fire Minister Mkhwanazi? It's a question.
Chair, may I be excused from answering this question if you don't mind? I don't think it's sort of really within my mandate here at this committee.
Are you really
If
sure?
You can proceed.
Okay. No, the reason I'm asking this is that, you see, Mr. Hofmeyer, when he left here, he said he's proud of the Seven administration, that we are the protectors of South Africa. So as you come here with your proposal, which we appreciate, and also thank you for your time that you put on your proposal, we must really scrutinize what you are telling us here. So I am starting there because I want to understand, if you were sitting with the president, how soon would you advise him to fire Minister Mkhwanazi, based on what you've seen and observed in the country? I take it that you wrote this proposal judging the country, the entirety of the SAPS and the minister. I take it you wrote this document because of that. So I'm asking, how soon would you advise the president to fire Minister Mkhwanazi? Unless you wouldn't. Is your interest for South Africans?
Sorry, I'm just, I'm not in a position of advising the president.
If you were?
And I'm not clear whether Minister Mkhwanazi is currently the minister or not. I'm just, it's a bit unclear to me as to exactly what the current position is.
What are the chances that your proposal is not fully researched? Because I noticed that most of your staff here speaks of international relationships. We should learn from other countries, Australia and all that. So are you well vested in South Africa?
So are you, I'm not quite sure where your questions are going to. Do you want to?
I'm just trying to establish.
I'm a researcher. I've worked here for 30 years.
Yes.
What do you mean by fully researched, if I can ask you that? Because, the level of information that's available out there is enormous. And I never engage with all of it.
Okay.
So try and, work in a responsible way and, do my best, but I'm not, I could never be claimed to be,
the best.
On top of everything that's been written or published about any particular topic.
Okay. The thing is, you said that the minister might have not breached. So I'm thinking you are well vested of the topic you are talking about, which is the minister. So you should know whether he's fired, he's suspended, or he's still acting, or whatever he's doing. I take it you should be knowledgeable on that note, on that subject.
Okay, that's okay. If you do take that's,
Now I'm
I
asking.
accept that.
Okay, do you know the current status of Minister Mkhwanazi regarding his employment?
You know, my understanding, when I've tried to clarify it, is that I've got various different answers. So not entirely clear what the current status is.
You're okay. Therefore, how did you come to think that he has not breached anything in terms of this PKTT disbanding?
Okay, he's not, there's no, the Constitution authorizes the minister to issue directives. As pointed out by Major General Van Rooyen, neither the Constitution itself nor legislation provide clarity as to what the ambit of that power is. So, you know, what I understand Major General Van Rooyen to be saying is that there isn't explicitly any provision which enables us to understand what the scope, you know, what is and what isn't a lawful directive by the minister. And I've, you know, as I've in my responses to other questions, I've also what I've also drawn attention to is this fact that consistently task teams have been established under political direction. So to me, it seems to me to be, you know, whether one's providing political direction for a task team to be established or for a task team to be shut down, that seems to me to be a similar type of thing. It's not clear to me that those are qualitatively different types of instructions. So therefore, you know, insofar as the one is generally regarded as acceptable, it seems to me that the other, it's not clear to me why the other is necessarily unacceptable, and so it's not clear to me that the minister is violating any provision. There's another, you know, there are other arguments about, for instance, the process that he followed, the motivation that he provided, etc. And I'm more sympathetic to those arguments, but insofar as anyone is trying to assert that there is any explicit provision that he violated, I haven't seen anyone actually say this is the provision that was violated, by including Major General Van Rooyen. I don't know of anywhere in her affidavit to the Madlanga Commission where she outlines which provisions were violated by him. And so, you know, so that's the basis for my understanding.
What would you blame this to? The Constitution as well? This clarity.
Well, you know, my understanding is it's something that can be addressed in legislation, that they, but you know, so I don't blame it, but you know, I mean, I think, you know, so for instance, the Marikana Commission in their report called for the, you know, this issue to be clarified. And so if there had been more attention, I think it would have had to come first of all, from a political level to the recommendations of the Marikana Commission. That was, you know, that's one, you know, situation in South Africa where the issue has been raised and where there's been a call for attention to be given to the need to clarify this point.
You know, somehow in this regard, I agree with you, somewhere, somehow, not entirely. But this is my view. I think this Roman Dutch law that we are using in South Africa is failing us. Hence, you saw a need to address this matter, but you didn't check where is the problem. I think the problem is our constitution is completely not a South African constitution. Hence, I have a problem with when you say we should be looking at Europe and what. I'm a South African, I love South Africa, unfortunately. But I think I agree, though you may not agree, while we agree, me and you, that the constitution is the problem. But let's leave that. This Roman Dutch law must be changed. Tell me, what's your take on the disbanding of the PKTT? Do you think It was correct.
Right. Well, see, I mean, the first thing I would have said that I would say is, if one was to close down the PKTT, one should have followed, the idea of closing it down effectively overnight by the end of the month seems to have been a poorly judged instruction. And so at the very least, any instruction on this matter should have, first engaged with questions about the current cases that were being dealt with by the PKTT. And, also with the question about what is the current level of political killings and whether there's a need for this type of team, a task team dedicated to political killings to be maintained for the purpose of addressing political killings. So, for instance, in the minister's instruction, it doesn't say anything about what is the current number of political killings in KwaZulu-Natal. On that level, I don't think it was a well-considered direction.
But do you think it was correct? It was a good decision? Are you for it?
No, but I just said I don't think it was well considered.
You don't think so? But
Yeah.
what's your take on the PKTT? Do you think what's your take on it?
On the PKTT,
Are we benefiting as a country?
from the PKTT.
Yes.
You see, I mean, I would say that's a complicated question, to which I don't have a simple answer. But I would refer back to the questions and the exchange that I had with Honourable Saul.
Yes.
Yeah, okay. And
Did you hear Honourable Saul when I was speaking about the money and the money spent on PKTT? I kind of disagree with him there. I think we should complain about the money of national dialogue because it bears no benefit for us. I should complain about that. I think you should complain about that as well, rather than complaining about the money for PKTT, which bears benefit to us, some of us who are coming from such townships and stuff like that. But let's pass there. Have you met with any political parties on the subject you have here on the table?
No, I haven't.
You haven't?
No,
Have you met with Minister Mkhwanazi?
no, I haven't.
I kind of found some similarities because I was kind of disturbed on your proposal. That's why I had to ask a lot of questions so that I really understand what you were saying. I feel like you have been lobbied. Instead of proposing, you more of went for protecting Minister Mkhwanazi and trying to prove that he is correct and right. That's why I lost the proposal. But since we have now had it, we've spoken, I now understand that what's your proposal. But tell me, what is South Africa going to benefit from your proposal?
Well, you see, I mean, I think what we would like to have is a policing system where the police are professionals and are able to exercise independent judgment about the policing issues that they're faced with. And so insofar as political influence prevents them from exercising independent judgment and responding to the crime situation which they're dealing with in the best possible way. I think measures to prevent political interference might empower them or support them to better be able to implement what one could call professional policing.
All right, no, thank you, sir. Thank you for coming. Chair, I would like to propose something, Chair, if you can. I think this time allocation in terms of today was beneficial to South Africans. So in the remainder of the witnesses that are about to come, I think if you can allow such interaction and more time, South Africans will benefit because we missed a lot of opportunities with the last witnesses where we asked 15 minutes and 10 minutes and we never got to get to the gist of the issues. So I'll propose to you and plead with you, Chair, that if possible, kindly allow this kind of system. It's proper. Thank you, Chair.
Yeah, only on condition that alternate members will not speak. Honorable Vessels.
No, thank you, Chair. No questions from me, and let me just also welcome the presentation and the submission, but no questions from me. Thank you.
Thank you. Kawazel. I'm going to have an online engagement now in case you finish before I come back. Honorable Mngango will preside and call the meeting off and announce that we are starting at 11 tomorrow.
Thank you, Chairperson. Thank you very much, Mr. Bruce. I have no further questions. Thank you.
Okay, so it means we have come to the end of the proceedings. Mr. Robert David Bruce, thank you so much. Thank you, honorable members. Let's start at 11 o'clock tomorrow. Andile, Bonani, and Pilot, Nicolette, can we make sure that tomorrow before we start, we provide comprehensive answers to the issues that members have raised this morning? Thank you so much. The proceedings have come to an end, unfortunately. Thank you so much, Mr. Sean Tate, for staying the course and for also pledging your solidarity to ISS. We want to thank you so much. Honorable members, you may stand up and leave the chambers.
Thank you, Chair.